Yes.
May I make
If
a
you want
submission,
or
Your Lordship?
20th, yes.
The Lordship's kind.
ಯಾಕೆ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ನಾಳೆ ತಗೋಬೇಕಾ? ಮತ್ತೆ ಕೊಡಿ ಎಲ್ಲ. Give all pending matters. No dates. Give all pending
May
matters.
I make a submission, Your Lordship?
They will come according to seniority. Interim order illa andre they will come on a particular date.
Sir, pending matter.
May I make a submission?
Please give all the memos, no mentioning.
Your Lordship, the
Compromise
matter
ಕೊಡಿ
is.
madam. ಯಾವತ್ತು ಬೇಕು? ಮಂಡೇ ಇಲ್ಲ 20. ಮಂಗಳವಾರ.
19 ಕೊಡಿ ಸ್ವಾಮಿ.
ಆಯ್ತು 19th.
ಸರ್ 20 ಕೊಡಿ. 61.
May I make a submission, Your Lord?
ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
Service to the respondent, my lord.
No problem, it will come ಕೊಡಿ. No problem, give it will come.
This
The
matter,
Lordship's kind leave.
fresh
No,
matter,
no,
Your
no.
Lordship.
No dates in pending matters, give it, yes.
Lordship, fresh matter
All the
which came
memos
to
it
be
will
filed
come.
on 30th July, Your Lord.
My lords, 10 FIRs are registered. 10 FIRs are registered. Not despite this court directing the police to extend police protection. Considering the judgment and decrees and orders, not my complaint is not entertained. And at the instance of third party, not 10 FIRs are registered and 3 days not they are threatening us, not.
2:30.
Your Lordship's
May I make a
kind leave.
submission,
One
Your
matter for 2:30. This is a matter of 138. 311 application. The matter is posted for judgment on
2:30.
2:30.
May I make a submission, Your Lordship?
Pending matters ಇಲ್ಲ ಕೊಡಿ.
Fresh matter, Your Lordship.
Withdrawal ತಗೊಳ್ಳಿ.
Serial number 51, withdrawal, my lord.
ಸರಿ ಕೊಡಿ ಜೋಗಾಗಿರಿ.
51. My lords. Withdrawal, my lords.
Withdrawal, give everything.
May I make a submission, Your Lordship?
On the spot inspection, I raised the unauthorized.
Tuesday sir, Tuesday.
My lord, 2:30.
No sir.
May I make a
Arrest
submission, Your
ಮಾಡ್ತಿದ್ದೀರಾ
Lordship?
sir?
Yes, my lord.
ಯಾಕೆ ಸರ್?
My
ಬೇಲ್
lord,
ತಗೊಂಡಿಲ್ವಾ?
file application is here for hearing for tomorrow.
ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
ನಾಳೆ hearing ಇದೆ. ಸ್ವಾಮಿ.
ಬೇಲ್ ತಗೊಳ್ಳಿ.
My lord,
Your Lordship, this fresh matter.
20th. 20th.
Your lord,
Matter.
Want it 20th or leave it? Yes.
your lordship, in trial court, the matter is listed for charge on Saturday, your lordship.
Move the other bench. Yes.
Your lordship, I have
Tuesday.
moved several
Move
memos.
the
my
other
lordship.
bench sir. Yes.
So for tomorrow, your lordship.
ಅಲ್ಲ ನಿಮ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ ನಾನ್ ತಗೊಳಕ್ಕಾಗಲ್ಲ. The other bench will not take the memos taken by this court. You move that court only. Okay. Yes.
This is on the Drugs and Cosmetics Act, my lord.
Ah,
And
so?
the company that has been selling a device as well.
It's all right. What is the problem now?
The problem is two departments, my lord. One department.
Fresh pending sir.
Fresh matter.
Tuesday ಕೊಡಿ.
My lords,
ಎಲ್ಲ
May I make a
why
submission,
are you
Your
waiting
Lordship?
for fresh matters? If you want it before Tuesday, mention it before the other bench or else please give it. Yes.
Fresh matter.
ಕೊಡಿ.
my lords,
fresh
No
matter,
sir.
2:30, my lord.
ಯಾಕೆ?
Fresh matter, Your Lordship.
ಆಯ್ತಾ 2:30 ತಗೊಳ್ಳಿ.
May I make a submission, Your Lordship?
My lords,
Fresh matter which is came to be filed on 30th July, Your Lord.
No problem. You want, when do you want it?
Tomorrow.
You move the other bench. Yes.
No, we'll take it on Tuesday.
Ah, yes.
lords,
Tuesday.
offense punishable under
2:30
section
ತೊಗೊಳ್ಳಿ.
7 of PC Act, my lords.
7 PC Act. ಈಗೇನು urgency ಏನು?
My lords, no interim order of stay has been granted.
ಯಾವ್ದಕ್ಕೂ
Pending
ಕೊಟ್ಟಿಲ್ಲ,
matter,
sir?
my lords.
Pending matter.
Pending matter.
ಯಾವತ್ತು?
Kindly take in a minute.
ನೋಡಿ ಮೇಡಮ್ ಅದು ಯಾವತ್ತು 7th ಯಾವತ್ತು ಹಾಕಿದೀವಿ?
13.
ಅವತ್ತೇ ಕೊಡಿ.
My lord, fresh matter for
ಅಲ್ಲಿವರೆಗೂ
2:30,
ಇಲ್ಲ.
my lord. Fresh matter for 2:30, my lord.
Sir.
POCSO and SCST Atrocities Act have been invoked against the husband by the wife, my lord.
All right.
That's for urgency, my lord.
No sir.
13.
Move the other bench. Yes.
My lord. It's Tuesday, my lord.
ಕೊಡಿ. Yes.
fresh matter, my
Tues-
lord.
Tuesday, my lord.
Third branch.
Give it, give it.
1 month, my
Fresh
lord.
matter.
Fresh matters ಎಲ್ಲ ಕೊಡಿ. FR number ಇದ್ರೆ before Tuesday comply them.
Fresh matter and fresh matter.
Withdrawals.
Fresh matter.
Pending matter, lord.
Pending, please give no dates.
Triple talaq matter, lord.
Maybe. Give it.
matter, my lord.
Yes, pending matters, please give.
Matter, one matter
It's sir.
2:30, for 2:30, my lord.
No 2:30. Pending matter.
20th.
ಇಲ್ಲ, fresh matter 2:30,
ಹಾ.
because the likely chance of framing the charges, my lord. it is-
ಇಲ್ಲಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್?
move ಮಾಡಿದ್ವಿ
Next
ಮೊನ್ನೆ.
week.
Next
2000 ಕೊಡಿ.
ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ.
ಇಲ್ಲ.
ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ.
ಇನ್ನೊಂದ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ. ಐ ಆಮ್ ನಾಟ್ ಸಿಟಿಂಗ್. ಇನ್ನೊಂದ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ.
Urgency ಇದೆ.
No, no, sir.
Personal matter ಅದಕ್ಕೆ.
Sir, personal matter.
Advocates family.
ಕೊಡಿ. 2:30 ತಗೊಳ್ಳಿ.
2:30.
Fresh matters on Tuesday.
ಸರ್ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ ಸರ್.
Please.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಗೆಲ್ಲ ಕೊಡಿ. ಯಾಕೆ ಡೋಂಟ್ ವೇಟ್ ಟು ಮೇಕ್ ಅ ಮೆನ್ಷನ್.
2023, but fresh matter.
ಏನು 2:30 ಬೇಕು ಅಂದ್ರೆ ಎಲ್ಲ ಥ್ರೆಟ್ ಆಫ್ ಅರೆಸ್ಟ್. ಟ್ಯೂಸ್ಡೇ ಮೂವ್ ಮಾಡಿ.
This is for admission.
Please give the memos. I will start. Yes, call the matters. Give it, sir. ಆಯ್ತು, being spoken to Wednesday ಹಾಕಿ ಮೇಡಮ್. Give it.
Issuance of passport.
Why are you here? What happened?
My lord, there are two cases pending before the magistrate.
Huh.
They are evading summons, but their advocate.
You are for the complainant.
No, my lord,
Then?
I am the accused.
Huh. Then what is the urgency now?
My lord, I am not able to take out notice on them. I may be permitted to take out on the council because.
ಅಲ್ಲ
he is-
ಅಷ್ಟಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ ಏನು ಟ್ಯೂಸ್ಡೇ ಬರ್ಲಿ
Okay.
ಕೊಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Tuesday.
ಪೆಂಡಿಂಗ್
Emergent notice was ordered.
then
to
it will come give it yes
My lord, issuance of passport is.
14% madam 14% Wednesday
My lord,
I was vacating for stay,
vacating stay which year
23.
23
my lord, issuance of.
vacating stay ಎಲ್ಲ ಒಂದಿನ ಹಾಕಿ ಮೇಡಮ್
Regard to unfreeze of the bank account, interim order has already been granted on 9th, but there is a.
I'll
correction,
vacate it give it yes
My lord, being
you
spoken to,
urgency ಏನ್ being spoken to by
but there is a correction in the interim order,
ತಗೊಳ್ಳಿ ಮೇಡಮ್
and along with the another matter is also getting filed. my lord.
ಅದೇನ್ being spoken to ಎರಡೂನು
That is the connected matter.
ಏನು ಬೈ ಒನ್ ಗೆಟ್ ಒನ್ ಫ್ರೀನಾ
Connected
yes.
matter.
Not fresh matter, my lord, so on 7th, senior council.
it will come yes
My lord,
But one fresh matter for end of the list for this reason,
seriously
not disproportionate asset.
ಅದ್ರಲ್ಲಿ ಏನು urgency
They are likely to place me under suspension, my lord, only on two grounds, my lord. The loan which is not taken into consideration and one property which does not
why suspension
suspension, my lord, in a case of disproportionate asset.
Give it. yes ತಗೊಳ್ಳಿ
May I request
My
for
lord,
230, my lord.
take it
My lords, I just moved a memo, my lords. The date is given on 30th, but my lords, the matter may be kindly taken up on 20th, my lords.
no sir
Section 7 of PC Act, my
No,
lords, there's
sir.
a grave urgency.
no sir
My lords,
lord,
the,
Panel ಯಾವ grave urgency yes
my lords, the matter it has been clubbed with,
No,
interim
sir.
order has been given in the other matters, my lords.
no problems yes
my lord, issuance of passport is pending because of this case, my lord.
Huh?
Issuance of passport is pending
thank
because
you
of.
next week
So admission-
Vacating stay 138, 19th.
vacating vacate sir and ತಗೊಳಕ್ ಸಾಧ್ಯ next Wednesday if you want give it otherwise it will be there yes. vacating still next Wednesday ಏನು fresh matter
Fresh
ಆಯ್ತು ಅಲ್ಲ
End of the list.
no Tuesday ಕೊಡಿ
Tuesday.
My lord.
FR ನಂಬರ್ ಇದ್ರೆ ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿ
My lord.
ಹಾ ನಂಬರೇ ಇಲ್ವಾ ವಾಪಸ್ ತಗೊಳ್ಳಿ ಮೆಮೊ ತಗೊಳ್ಳಿ
Two matters, my lord, one is fresh and one is not inside the 498, the petition by the husband.
give it husband you don't worry fresh matter ಕೊಡಿ ಯಾವ್ದು
Ground is, she herself has taken a money of 50 lakh.
ancillary ground ಇದ್ರು ಪರವಾಗಿಲ್ಲ husband let it come let the wife come yes notice issue ಆಗಿದೆ ತಾನೆ So ಏನ್ ಮಾಡಕ್ಕ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗ್ಲಿ ಎಸ್ ವಿಲ್ಸ್
One is fresh.
ಫ್ರೆಶ್ ಬರುತ್ತೆ
This is a fresh matter, my lord. None appearance it is.
Fresh
urgent 2 weeks.
matter
Yes, my lord. None appearance it urgent 2 weeks, my lord.
Huh.
Last week I moved, my lord. Lordship order to
Tuesday
Monday,
yes.
my lord.
ಮಂಡೇ ಬೇಕಾ
Alla, last week,
ನೀವು if you want other dates you move the other bench yes call the cases fast
Lord, my lord,
ಮತ್ತೇನು
ಇಲ್ಲ, Lord, section 7A, all other matters are listed on 13/9.
13th give it for 13th
13th.
Settlement for being
convenient
spoken,
date may be fixed.
move the other bench sir I am not sitting I told you
for settlement, my lord, for being
For
spoken, my
lordship,
lord.
any convenient
Last
date.
week, my lord, on Thursday, matter is disposed, my lord. In the final order, my lord, direction is given for 307 release, my lord.
ಜೈಲ್ ಅಥಾರಿಟೀಸ್
ಹೆಸರು ಬಂದಿಲ್ಲ ಅಷ್ಟೇ.
ಮೇಡಮ್ ಅದು ಜೈಲ್ ಚೇಂಬರ್ಲೆ ಕರೆಕ್ಟ್ ಮಾಡಿ ರಿಲೀಸ್
Please.
My lord, settlement matter, my lord. We are ready to report the settlement.
ಈಗ
No, my lord. Any date. that is-
20th
Yes.
Yes.
Lord, last week also I moved, my lord.
ಕೊಡಿ ಸರ್ ಪರವಾಗಿಲ್ಲ
Fresh matter.
ಮೇಡಮ್
Lakshmi Angar mention ಮಾಡಿದ್ರು, but the
ಆಯ್ತು.
matter has not been listed.
ಆಯ್ತು ಏನೀಗ
Even the memo, ನಾಳೆ list ಆಗಿದೆ.
you have to move the other bench I am not sitting tomorrow
Fresh matter, my lords. Civil case has been given a criminal touch, my lords.
give ಕೊಡಿ
Taken on Tuesday,
We'll
20th, my lords.
comply ಆಗಿದ್ರೆ yes next call the cases
Number one, this one.
split charge sheet
Split up.
Huh?
Split up, sir.
ಎಲ್ಲ ಒಂದೇನೆ split up or split yes list on 23rd in the fresh matters list Leonard HCGP is directed to accept notice for the respondent ಬೇರೆಯವ್ರದೆಲ್ಲ ಆಗಿದೆಯಾ you are A3
A3, madam.
yes sir yes Shivakumar sir
Number two.
TC of 2021 what is this question of stay now here and it's a 22 petition not seen the light of the day
Commenced. Trial has not commenced.
that may learned counsel by the petitioner is directed to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement list the matter on 23rd in the fresh matters list yes
Three.
next
You got a freezing of the account of.
order is 24/6/2021 ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದೀರಿ sir no problem Leonard HCGP is directed to accept notice for the respondent secure ನೀವಿಲ್ವಾ ಇದ್ರಲ್ಲಿ secure is
Please, my lord.
don't disturb him yes secure instructions and make his submissions list the matter on 23rd in the fresh matters list. Yes,
My lords, counsel for the petitioner, my lords. My lords, this is, case is pertaining to a 138 case, my lords. My lords, in this, the complainant and the accused have.
sir,
obtained
serve
a
on the
146
council, sir.
There's no
counsel
counsel for the accused, my lords. He filed a joint memo.
Joint memo, ಎಲ್ಲಿದೆ?
A compromise memo was filed.
Where is it?
My lords, it's at page number.
Huh.
18, my lords.
All right,
Based on that, and judgment came to be passed. My lords.
Page.
That's at page number 25, my lords. The operating portion of the order. For my lordship will find it at page number 24. Acting under section 255, subclause 2 of
Now,
CRPC.
what had to be paid?
My lord, 6 lakhs had to be paid, my lord.
You are the complainant?
I'm the complainant, my lords.
Yes.
Now, after that, the.
ಅಲ್ಲಿ
joint-
council ಇರ್ಲಿಲ್ವಾ?
My lords, there was some counsel who came.
Some
for
council ಅಂದ್ರೆ you have to serve that council.
And then unfortunately, my lords, now I made an application before the trial court asking them to pass in conviction order because the.
That we will do. We will not permit all these accused to enter into a settlement and escape.
Yes,
But
my
some service of notice should happen.
My lords, I'll carry
and
it on to
summons.
the respondent directly, my lords.
Yes. The petitioner is directed to serve the respondent by way of hand summons and place an acknowledgement before this court. List the matter on 22nd in the fresh matters list. Yes, next.
Five.
What is the stage? Crime is 2022,
My lord, in this
14922.
charge sheet is filed, my lord, NCC number
Yes, next.
Reporting may be received, my lord.
Yes, sir. Yes, next.
Six.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಇದ್ರಲ್ಲೂ?
Charge sheet ಆಗಿಲ್ಲ.
ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ.
ಆಗಿಲ್ವಾ?
ಆಗಿದೆ, that is what they have challenged, my lord, in this one.
Eh? No.
A1 step pending.
Crime is challenged, sir. ಎಲ್ಲಾಗಿದೆ CC?
Sorry, my
CC
lord.
ಆಗಿದೆ.
Serial-
CC
Yes, sir. ನಾನ್ ನೋಡಿದ್ದೀನಿ, ನೀವು ನೋಡಿ ಕರೆಕ್ಟ್ ಆಗಿ.
Okay, sir. Serial number 5.
In the meantime, last ಅಲ್ಲಿ ಒಂದು ರೈಡರ್ ಹಾಕಿ, only if the charge sheet is not filed as on today. Yes. Charge
Seven.
sheet, in the event charge sheet is filed, the interim order would cease to operate. Yes.
Connected matter 7719 stay there. Same.
Tag this petition along with zones.
What?
Yes. ಬರ್ಕೊಡಿ. ನಂಬರ್ ಬರ್ಕೊಡಿ. ಇನ್ನು ಬೇರೆ ಕೋಡ್ ಯಾವ್ದೋ ಕನೆಕ್ಟ್ ಆಗುತ್ತೆ.
Seven.
Yes, sir.
The discharge application of the petitioners were rejected by the magistrate.
Stage, yes. What application?
The discharge application.
Discharge application is rejected, that I'm aware. It's CC of 2022.
Yes.
Discharge application is rejected in the year 2022. We are in 24. Learned HCGP is directed to accept notice for the respondent secure instructions with regard to the stage of the proceedings as on today and make his submissions. List on 23rd.
Petitioners were
If-
not heard, my lords, in the revision petition.
That we'll see, sir. Yes, list on 23rd in the fresh matters list.
EVAC.
Huh?
EVAC proceedings.
Correct. ಎಷ್ಟಿದೆ arrears?
The years, my lord, 1.5.
1.5 crores, sir.
No, 1,50,000.
1,50,000. Deposit 75,000. Yes, that shall be, emergent notice to the respondent. There shall be an interim order of stay for, as prayed for, subject to the condition that the petitioner would deposit 50% of the amount in arrears as on today in the next 3 weeks before this court lists the matter on 29th in the fresh matters list. Yes, next. 29th, pada. Next
Appearing
week,
for
ಹಾಕಿ.
petitioner,
5th
my
in the
lord.
fresh matters list. 5th September.
Appearing for petitioner, my lord.
494.
Yes.
Other 498 and 494 will stay only insofar as other, who is the husband first?
Petitioner 1, my lord.
Who is accused number 4? Fast. You can't think here. Who is accused number 4?
My lord,
Puja, my lord, Shri is accused number 4. The petitioner number 4 is accused number 4, my lord.
ಅದೇ ಅಪ್ಪ ಯಾರದು ಅಂತ ರಿಲೇಶನ್ಶಿಪ್ ಓದಿಲ್ವಾ? Yes, list after 4 weeks.
my lord.
Ten.
Yes, next. Emergent notice to the respondent. Yes. ಓದ್ಕೊಂಡ್ bani, pass over ಮಾಡಿರ್ತೀನಿ. Read and come.
11.
Pass over ಮಾಡಿ.
Petition number. Lord 498A, Lord.
Lord, in this charge sheet is filed, my lord, NCC number 229 of
ಅದಕ್ಕೆ.
23.
Yes. ನಾನು ಅದನ್ನ ನೋಡು. Because 2020 ಚಾರ್ಜ್ ಶೀಟ್ ಇಲ್ಲದೆ ಇರಲ್ಲ. Yes, next.
12.
In the meantime, petitioner to serve set of, ಯಾರಿಲ್ವಾ? Still number 12. Shankar Nayak. Yes, next. List on 21st in the fresh matter. There's no representation by the petitioner. Next, 13. Husband, sir.
I am for the husband, my lord.
You are for the husband.
Yes,
Yes,
my
sir.
lord.
1 HCGP 2 emergent notice returnable by the 11th of September, list on 11th of September.
ಕೋರ್ಟಲ್ಲೂ ಕೂಡ ಸೆಟ್ಲ್ ಆಗೋಗಿದೆ ಸ್ವಾಮಿ MC ನಲ್ಲಿ.
ಎಲ್ಲಿದೆ?
Matter has been
ಕೊಡಿ,
in
page,
page
page.
number 27, my lord. Memorandum of settlement.
In the meantime, there shall be an interim order of stay of further proceedings where the petitioner in the light of the settlement arrived at between the parties. Application ilva? Stay application ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ ಅಲ್ಲ ವಾಷಿಂಗ್ ಗೆ ಅವರು ಒಪ್ಕೊಂಡಿದ್ರು.
ಆಮೇಲೆ ಒಟ್ಟಿಗೆ same earlier order. Yes, next.
Any short date may be fixed, my lord.
11th September. Yes.
Much.
Who is in possession?
Seven offense.
Who is in possession?
Petitioner, my lord.
How?
I have grandfather filed the OS suit, my lord, in
Page.
In
Suit
page
for what?
number 59, my lord.
Suit for what?
Declaration, my lord. Page number 59.
Why declaration?
I am the purchasing the
When did you purchase the property? 1, 2, in the meantime.
29/8/2009.
Yes, next.
16.
15, huh?
Government land. I have filed an application for
192A.
Lord, yes, ma'am.
Yes, sir. In the meantime, next.
16.
Great.
Early judgment.
Lord.
Lalita Shastri judgment.
I've produced my.
Where is it?
Filed a memo. I'll produce it. ma'am.
Huh?
I'll produce it. I missed it.
What, sir? ILR 2008 Karnataka, no, 2009 Karnataka 1416, yes. 1416 ಇರ್ಬೇಕು, check ಮಾಡಿ.
Lord,
Lalita Shastri was the state of Karnataka. Serial number?
16.
16. Nagendra T. Ah, yes, sir.
Lords, NOC Wakalat has been filed, my lords.
No problem, sir.
My lords, allegation is of
376, sir.
376 and 307, my lords. They were in relationship, my lords. She has moved with the petitioner all along.
Moved with the petitioner.
And she
Huh.
has roamed around, my lords. Now, because of
Roamed
some,
around? What?
some strained relationship between them,
Hmm,
an allegation is made of 376, my lords.
hmm.
My lords, the accused number 2 to 4 have been implicated.
Hmm.
No specific allegation.
No, no, no. 307, sir.
307 ಅವರೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಪರವಾಗಿಲ್ಲ, ಪೇಜ್ 74 ನೋಡಿ ಸರ್, ಯಾರ ಮೇಲೂ ಅಲಿಗೇಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ. ಎಲ್ಲರ ಮೇಲೂ ಇದೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ 317 ಮತ್ತೆ 307 ಮತ್ತೆ 376 ಅಲ್ಲಿ ಪೇರೆಂಟ್ಸ್ ಇನ್ ದ ರೋಲ್ ಬರಲ್ಲ.
376 I will stay in so far as parents are concerned, but not 307.
307 also, my lords.
No, no.
Parents were not at the spot, my lords.
It's all right. That we will see later. 376 definitely I will stay. Only in so far as parents are concerned.
Please.
1 HCGP, 2 emergent notice returnable by the 12th of September. List the matter on 12th of September. A perusal at the summary of the charge sheet would indicate that the accused number 1 and the complainant were in a relationship. And on the said relationship, certain facts have emerged which would become an offense under section 376 of the IPC. In the offense of 376 between the accused number 1 and the complainant, the parents are dragged into the web of the said allegation. Therefore, except accused number 1, all other, except accused number 1, there shall be an interim order of stay only of the offense under section 376 of the IPC. Accused 2, 3 and 4, except the said offense, accused number 2, 3, 4, further proceedings shall continue against the other accused for the other offenses. Yes, next. 1 HCG, ಆಯ್ತಲ್ಲ ಅದು? Yes.
17.
CC of 2016 306 offense ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
Lord, recently it has been committed to the sessions court, my lord.
ಹಾ.
Lord,
But produce the entire order
let's
sheet.
note, my lord, 8 persons were named, my lord, that they have omitted to come.
That we'll see. And this old matter we cannot. 1 HCGP, 2 emergent notice returnable by the 5th of September. List on 5th in the fresh matters list.
18.
8 ವರ್ಷ ಆದ್ಮೇಲೆ ಸ್ಟೇ ಅಲ್ಲ ಇಲ್ಲ.
My lord,
Recently had been committed, my lord.
ಪರವಾಗಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ. Yes.
2 to 7 have been left. my
What
lord.
stopped you, sir? We'll see. Yes. A1 and A8 ಮಾತ್ರ ಹಾಕಿರೋದು ಈಗ.
ಹೌದು ಸೌಮ್ಯ.
ನೋಡ.
ಮಿಕ್ಕಿದವರೆಲ್ಲ ಬಿಟ್ಟಿದ್ದಾರೆ
Fifth,
ಸೌಮ್ಯ.
sir.
Same allegations. my
List
lord.
on fifth, yes. Dismiss ಮಾಡಿಲ್ವಲ್ಲ? Yes, yes.
18.
Charge frame ಆಗಿದೆಯಾ?
Year before.
In the meantime, yes.
19.
Next.
Here for petitioner, the incident is on 2013, my lord.
All right, investment ಎಷ್ಟು ತಗೊಂಡ್ರಿ?
Investment, ನಾವ್ ಯಾವ್ದು ತಗೊಂಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಹಾ.
2,65,000, they are saying.
Hmm.
But the documents shows that accused number 4 signature only. But these petitioners have not involved or they have not established any cooperative
A
societies.
transaction between the petitioners accused number 4 with the complainant has resulted in the impugned proceedings. The transaction happens in the year 2013 for an investment that the complainant sought to invest on the say of accused number 4 or the petitioners. The crime comes to be registered 7 years thereafter. In that light, further proceedings shall remain stayed till the appearance of the complainant. List the matter on 4th September in the fresh matters list. 1 HCGP, 2 emergent notice, returnable was. And ಬರ್ದ್ಬಿಟ್ಟು ಆಮೇಲೆ list on 4th.
Till number 20. But this is a boundary dispute between parties.
Next.
21.
State, sir, next.
Please.
ಅದು
Apply.
fast ಇರ್ಬೇಕು.
Sorry.
Yes, sir. Next.
The petition.
Yes, sir, page 19. 354 is the offense.
There is a 2 complaints filed.
Maybe notice only for the present. 1 HCGP, 2 emergent notice returnable by the 11th of September. List on 11th in the fresh matters list. Next.
324 of I guess.
324 clearly met.
At least you notice.
Discharge ಆಗ್ತೀರಾ?
ಇಲ್ಲ.
1 HCGP, 2 emergent notice, no date. Pendency of this proceeding will not come in the way. Yes, next. ಅದು ಗೊತ್ತಾಗತ್ತಲ್ಲ? Will not come in the way ಗೊತ್ತಾಗತ್ತಲ್ಲ?
The petitioner, my lords.
ಹಾ.
It's a case of the.
379.
ಇದರಲ್ಲಿ
Main
page
time,
number
yes.
30, my lords.
Yes, sir. Next. Charge sheet file ಆಗಿದೆಯಾ?
No, my lord,
Suresh.
charge sheet is not filed.
In the meantime, only if charge sheet is not filed, first on the
My
ಹೇಳಿದ್ನ.
lord, incident number
Same.
24, my lord, sorry, charge sheet is filed, my lord.
That's what I asked.
60322.
It can't be pending this 2 years in the charge sheet ಆಗದೆ ಇರಲ್ಲ. Liberty challenge ಮಾಡಿ charge sheet. Yes. Next.
24. 25.
Rajesh, ನೋಡ್ಕೊಳ್ಳಿ correct ಆಗಿ.
Please, 24 charge sheet.
Learned HCGP is directed to accept notice for the respondent essential commodities.
Please,
Wait.
R2 also police sub-inspector.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ ನೋಡಿ. So and so. List the matter on 23rd in the fresh matters list. Learned HCGP is directed to go through the petition and make his submissions on the said date. ಅವತ್ ಕೊಡುವ. Yes, next. Yes. No representation, list after 2 weeks. Next.
27.
This case, I appear for the petitioner.
Heard the learned counsel appearing for the petitioner, a sale deed that is executed in the year 2015 is sought to be questioned in the year 2023, that too by setting the criminal law into motion without any speck of explanation for the delay. It transpires that the petitioner has instituted, a suit in OS 957 of 2022 as well. It is after that the impugned crime has sprung. Therefore, there shall be an interim order of stay, 1 HCGP to emergent notice.
28.
You wanted to say something else? Yes.
My lord, this matter 16/8/22 charges has been framed.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗುಂಟು. ಆ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗುಂಟಂತೆ, ನೀವು ಅದು ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ. 22ಕ್ಕೆ ಹಾಕ್ತೇನೆ. 22 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಎಸ್.
29.
2 and 3 we will stay.
Please,
Kashkan. Yes, next.
My lord, in this matter also charge sheet is filed, my lord.
Charge
NCC
sheet,
number-
challenge ಮಾಡ್ಬಿಡಿ ಮತ್ತೆ. Liberty, yes.
Please.
These are all matters to be stayed, immediately challenge ಮಾಡಿ. Yes.
30.
Lethal combination, sir. 306, 498A.
The 8/8/22, there is a 498 complaint was filed by the deceased. On 9th, the police have filed. In the 10th, husband has committed a suicide. And the mother-in-law also committed a suicide.
Mother-in-law also committed
Oh.
suicide. Husband and mother-in-law.
Oh.
Who is the accused now? Wife?
accused is the sister. That the next day, because the both of them have committed suicide, she felt, worried, and she also committed suicide. She died on 20th, Lord. The 20th, this complaint was filed, saying that ನನ್ನ ಮಗಳು ಸಾವಿಗೆ ಅವರೇ ಕಾರಣ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಅವ್ರ ಮಗಳು ಹೇಳಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. There's no death note, there is no statement before the
Yes.
doctor, nothing. ಅದು ಕನ್ಫರ್ಮ್ ಆಗಿರೋದು 11ನೇ ತಾರೀಕು. 20th ತೀರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. ತೀರ್ಕೊಂಡು ಹೋದ್ಮೇಲೆ ಅತ್ತೆ ಬಂದ್ಬಿಟ್ಟು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ.
Just go through it.
Please, my lord.
List on 22nd in the fresh matters list.
ಅದು ಚಾರ್ಜಸ್
ಯಾವಾಗಿದೆ?
28 ಇಟ್ಕೊಂಡಿದ್ದಾರೆ.
22nd is before 28th? Yes.
31.
Husband, no. 1, 2 and 3, Kashkan. Yes. A1 is the husband, is JK. Yes, next. Construction agreement in the meantime, yes. State, sir. Yes, next. You're not from this bar?
Appear really.
Huh?
I'm a junior.
All right. ಅದು ಬರ್ಕೊಂಬಿಡಿ. The entire offences spring in the case at hand pursuant to a construction agreement arrived at between the complainant and the accused. And criminal law is set into motion for breach of the said agreement. Therefore, there shall be an interim order of stay for the proceedings quay the petitioner. Your case, sir. Quay the petitioner till the next date of hearing. 1 HCGP 2 emergent notice. Yes, next.
For the petitioners, my lord. Petitioners is the.
A2 and A3, Kashkan, next.
But the petition.
Date, sir. 30, ನಿಮ್ದೇನಲ್ಲಿ 33 ಅಲ್ವಾ? 498 A2 and A3.
Hello. 2, 3, 4, 5.
At state, yes. Next, yes.
My lord. First petition is the younger brother of the second respondent. My lord, there are number of suits have been disposed of by the honorable trial court. My lord, the suits filed by the second respondent has
The
been.
petitioner heard the land counsel of the petitioner. The petitioner is before this court calling in question proceedings in CC so and so, registered for offences punishable under 447 and 427 of the IPC. The petitioners are in possession of the property is an admitted fact in the light of several orders passed in several suits instituted by the petitioner or the complainant. After all these comes the impugned crime. In a dispute that is purely civil in nature, criminal law is set into motion, which is clearly impermissible, albeit prima facie. Therefore, next.
35.
Special discuss. Lord, the complainant or but the correspondent is the agriculturist, my lord. There's a-
Page 45.
My lord.
Page 45, sir. Allegation ಇಲ್ಲ ಅಂತ ಹೇಳಿ stay ಮಾಡ್ತೀನಿ.
There is allegation, my lord. What am my lord? Agriculturist, my lord.
ಏನಾರ ಇರ್ಲಿ, that doesn't mean you have a license to assault, sir.
Put before the, my lord, the complainant
Put to- so-
adjacent land, my lord. The
So-
formation of the road, my lord,
So,
to the agriculturist.
ಆಯ್ತು, so.
My lord, my lord, the complaint is the intentional, my lord. They have not-
Maybe, sir.
Only the.
There is
intentions, my
no
lord.
reason to disbelieve the charge sheet so filed. Page 45 allegation ಇಲ್ಲ ಅಂತ ಹೇಳಿ ನಮಗೆ ತೊಂದರೆ.
My lord, the unnecessary, they have lot of the complaint, my lord. the-
ಅನ್ನೆಸರಿ ಇಲ್ಲ, ಕೈಗಳಿಂದ ಹಲ್ಲೆ ಮಾಡಿ ಒಳ ನೋವು ಉಂಟು ಮಾಡೋದೆಲ್ಲ ಇದೆ.
Kindly see, my lord, the womb certificate. my
That is
lord.
simple in nature. That also I have
Yes,
seen.
Lord.
That's all right.
This is, my
That
lord.
we'll see. 1 HCGP 2 emergent notice. Yes.
My lord, kindly see, kindly.
No, no.
36.
Wherever there is assault, I will not. Unless there is no assault and something has happened. Yes, next.
36.
ಅದು same.
37.
Petition is dismissed.
Dismissed for default, my lord.
ಅಲ್ಲ, default ಯಾವ ನೋಟಿಸ್ ಆಗಿರಲಿಲ್ಲ ಅವ್ರಿಗೆ?
ಇಲ್ಲ ಆಗಿಲ್ಲ.
Respond ಆಗೇ ಇಲ್ಲ.
ಹಾಗೆ ಇಲ್ಲ.
List on 21st in the fresh matters list. We'll dispose it. Next.
38.
Petitioner. The misappropriate of funds. There's one more case which is stayed, your lordship. It's before your, yeah. Number ಇದೆ.
Number ಕೊಡಿ.
313. It's already stayed and this is double jeopardy
Number
for the
ಕೊಡಿ, madam.
313 of 2023.
23.
Yes, your lordship.
Tag this petition along with 313 of 23. ಅದ್ರಲ್ಲಿ stay ಇದೆಯಾ?
ಅದ್ರಲ್ಲಿ stay ಇದೆ.
ಅದ್ರಲ್ಲಿ ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ.
ಇಲ್ಲ ಇದೆ.
Order ಕೊಡಿ. Yes. Lieutenant Counsel for the petitioner submits there's an interim order operating in petition so and so. Therefore, there shall be an interim order. So list both on 11th September in the fresh matters list. Yes, next.
Petitioner matter. In this, the crime number 203 was registered.
The criminal law is sought to be set into motion, of which the subject matter is a sale deed. The sale deed is said to have been executed in the year 2013 or 14? In the year 2014, and the complaint is registered in the year 2022. Setting the criminal law into motion of a remedy that the complainant has lost of registering a civil suit cannot be permitted, albeit prima facie. 1, 2 in the meantime. Next.
40,
Surface proceedings. In the meantime, next.
41,
505(2). ಯಾಕೆ ಹೇಳಕ್ ಹೋದ್ರಿ ಅದೆಲ್ಲ? ಯಾಕೆ ಬೇಕಾಗಿತ್ತು? ಎಲೆಕ್ಷನ್ ಆಗ್ಬೇಕು. Why did you need all this statement? ಸುಮ್ಮನೆ ಇರಕ್ಕಾಗದೆ.
Advise. WhatsApp status.
ಅದು ಗೊತ್ತು, ಅದಕ್ಕೆ ಯಾಕೆ ಬೇಕಾಗಿತ್ತು? 1 HCGP. ಕಂಪ್ಲೇಂಟ್ ಯಾರು?
That's private individual.
1 HCGP, 2 emergent notice. In the meantime, till the next date of hearing, list the matter on, returnable by 12th September.
Interim.
42, 13%
ಮತ್ತೆ ಸ್ಟೇಟ್ ಮಾಡಂಗಿಲ್ಲ.
For petitioner, my lords, I have filed wakalat.
14%.
And based of 14% committee, they have rejected. I filed application, wakalat.
ಹಾಕಿದ್ದೀರಾ?
Hakida.
ಆಯ್ತು. ರೆಡಿ ಇದ್ದೀರಾ?
Ready.
Who is landlord, who is tenant?
Landlord is the accused.
Landlord is the accused.
Yes, my lords.
Complainant is the tenant.
Complainant is tenant. Complainant.
420 is the offense.
323.
Assault.
What company is when then no land.
In the meantime, returnable by again September, madam. List on in the returnable by 11th. Next.
Interim.
Date, sir. Yes. Kashkan.
44,
What should the FIR was registered?
One, I will not. Husband, no stay. Yes, same.
Much
Kashkan.
obliged.
45,
And don't expect copies till next Monday. Yes.
For the petitioner.
Husband, sir.
No, my lord, 130.
Jumbo Bandari, sorry.
Jumbo Bandari.
Yes, order matra stay mad. Which is that order? There shall be emergent notice to the respondent. There shall be an interim order of stay of the order which directs, the order which makes 20% of payment to be the subject condition precedent for suspension of sentence till the next date of hearing. Please.
46,
In the light of the judgment of the apex court in the case of Jambu Bandari Swans, 2023, 10 SCC 4460, but not 4260. 40?
46,
498 mm.
Husband. List after 2 weeks, no representation for the husband.
47,
2, 3, 4, Kashkan, next.
For husband also.
No, sir.
Because he's in Canada after 2
May
years.
it be.
No, he
So-
wanted to come and settle it.
Ah.
Today, she has filed a maintenance petition. Today is for mediation. At
Then
least for some time, he will come and he will settle it.
let him come. You produce the air tickets that is going to come. I will direct him not to be arrested. Let him settle if he wants. Move ಮಾಡಿ. 2, 3, 4 I have stayed.
48,
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ, ಏನ್ ಪೆಟಿಷನ್ ಹಿಂಗ್ ಹಾಕಿದ್ರೆ ಹೆಂಗೆ?
ಅದ್ರಲ್ಲಿ ಏನು
ಏನ್ ಕೇಸಲ್ಲೂ ಏನೂ ಇಲ್ಲ, ಪೆಟಿಷನ್ಲು ಏನೂ ಇಲ್ಲ, ಕೇಸಲ್ಲೂ ಏನೂ ಇಲ್ಲ.
ಇಲ್ಲ. ಈಗ I am an advocate. Accused number 2 had approached me in that case in order to obtain bail. He had brought the wakalat of the present complainant. I had obtained anticipated.
ಫೋರ್ಜರಿ ಅಂತಿದೆ.
Forgery ಏನ್ ನನ್ನ ಕಡೆಯಿಂದ ಏನು ಇಲ್ಲ.
ಇಲ್ಲ, ಏನಾದ್ರು ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕಲ್ಲ.
ಅಲ್ಲಿ ಏನು ಇಲ್ಲ. ಅಲ್ಲಿ ಕೇಸ್
ವಕಾಲತ್ ಎಲ್ಲಿದೆ ಹಾಕಿದ್ದು?
that is not taken.
At least
I'll
important.
produce it. I'll
Show
produce it.
that something
produce
should
it.
be there.
I'll produce it.
21st,
Please.
list on 21st in the fresh matters list.
49,
Identical order have passed, sir.
Yes, ma'am.
Heard the learned senior counsel, Ramesh
68,
Shachala appears
53,
to
ma'am.
petition, tag this petition along with so and so same order. Next, sir. Yes.
49, sorry. 50,
PNDT. Yes.
Lord doctrine.
Medical termination of pregnancy. Why did you do, sir?
Lord doctrine of sameness.
Sameness. Why, sir?
Lord, similar order has been passed
Similar order. What similar orders?
in 6576.
ಕೊಡಿ ಅದು. ಸ್ಟೇ ಕೊಟ್ಟಿದೀವ?
Please, my lords.
ಅದಕ್ಕೆ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಸೇಮ್ನೆಸ್.
Oh, my lords, two
ಕ್ರೈಮ್
FIRs,
ಮಾತ್ರ ಸರ್, ಅದು ಇಂಟ್ರಿ ಮಾಡಲ್ಲ.
2 FIRs.
has been filed.
Lord, earlier, my lord, crime number 257 of 2023 was registered.
You
Subsequently,
tag
my
this petition along with the criminal petition, list them both on 21st in the fresh matters list. Yes, next. ಇಲ್ಲ ಇದೆ ಅಷ್ಟಕ್ಕೆ ಮೆಮೋ ಲೆವೆಲ್ ಬೇರೆ ಏನು ಆರ್ಡರ್ ಇಲ್ಲ ಅಷ್ಟೇ. Learned HCGP is directed to accept notice first. No representation, 2 weeks. Yes, next.
T2,
A2 and A3 Kashkan, next.
T4, to 53,
For the petition in this case, my lord. The second respondent filed a private complaint against the petitioner brought alleging offences, my lord, under section 405.
199 is also there. One government ಇದೆಯಾ?
ಹೌದು.
HCGP 2 emergent notice returnable by 11.
54,
ಕೊಡೋದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ. Yes,
Lord,
ಅವತ್ತು ಕೊಡು.
My lord, appearing for the petitioners in this case, my lord.
Which one, sir?
Serial number 54, my lord.
Where are you in the car?
Oh, no, my lord, I am not in town, my lord. I had to be out of station. It was supposed to be.
One husband, no stay, others, yes. Next.
My lord, husband, as against husband, my lord, one submission, my lord. There is no such provisions of section 323 or 324, my lord.
We'll see,
It is
sir.
just vague,
Sir, his husband, we will see, sir. Yes.
my lord,
Next.
as regards petition number.
Returnable by the 13th of September. Next.
T5,
2 to 4, my lord.
Yes, sir, others have granted stay.
Obliged.
Yes.
Lord, matter has been settled between the parties in terms of the compromise petition, I share B, my lords. Compromise, my lords.
ಇದ್ರಲ್ಲಿ compromise ಆಗಿದೆಯಾ?
Under the matrimonial cases.
Horrendous
They agreed to
allegation.
withdraw this petition.
Horrendous allegation.
I just make it. Since there was a dispute between the petitioner and the respondents, that they had agreed that not we withdraw the petition before the,
Let's see, get the wife.
I'll get that. That's what notice to be ordered. I'll just
Notice
secure
that.
presence.
Yes, otherwise this is horrendous.
That's a 498 petition, Lord, and filed by
No,
the,
we'll see, yes. One HCGP, 2 emergent notice returnable by the 11th of September. Yes. Eleventh of September. No representation, 2 weeks.
Not happy for the petitioner, my lord.
ಆದ್ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ರ, yes, sir.
My lord, the petitioner belongs to the Bovi caste, my lord, which has been declared as the scheduled caste.
That's all
Petitioner
right.
mother is also.
Only if charge sheet is not filed as on today, there shall be interim
No,
order of
charge
stay.
sheet has been filed. I produced the charge sheet, my lord.
charge sheet is filed.
ಹಾಕಿದ್ದೀರಾ?
Howದು? Charge sheet has been filed, my
My
lord.
lord, there is
Then
allegation,
just
my lord.
one ನಿಮಿಷ.
Tahsildar, after verification, my lord, they have ascertained
My lord,
that
the-
does not belong
Nah,
to.
I will narrate the facts.
Yes, yes.
But the petitioner belongs to Bovi caste. His mother, her mother also belongs to the scheduled caste. And her father also belongs to
In the
the
meantime,
Bovi
yes.
caste.
Yes, sir, yes, sir, stayed, next.
Ma-
1, 2.
my lord, so petitioner in this case, connected matter at page 109 and 111, my lord, there is stay in the matter.
Same, pages,
109 and
Amen.
111.
madam, tag. List, 11th. Next.
T8,
My lordship, petitioners are accused number 2 and 3, my lordship. My lordship, the allegation against the petitioner, my lordship, the entire complaint allegation against only accused number 1, my lordship. The photo na forgery ಮಾಡಿದ್ದಾರೆ in the MC proceedings.
2 and 3, yes, in the meantime, next.
T9,
Alleged offence is punishable under section 427 of IPC, my lords. My lords, a petitioner has initiated 138 proceedings as against the landlord, my lords. After lapse of 1 year, my lords, the respondent number 2 has filed the false complaint, my lords. Initially, NCR was.
Incident ಯಾವತ್ತಿಂದು, sir?
My lords,
When was the incident?
my lords, on 21/2021, my lords, lease deed was
ಎಲ್ಲ ಆಯ್ತು.
executed.
Incident ಯಾವತ್ತಿಂದು? 427 is mischief. So incident ಯಾವತ್ತು?
My lords, in the complaint, he states that while the petitioner was.
12/4/2023.
Please, my lords.
All right. Check number so and so. Emergent notice to the respondent, 1 HCGP, 2 emergent notice. Returnable by the 18th of September. In the meantime, 18th in the fresh matters list. Next.
Obliged.
A4 and A5.
So the
The
site is belongs to the petitioners, my lord.
The petitioners are A4 and A5 in the proceedings instituted by the complainant, finding no allegation that would touch upon the offense ingredients of the offenses under section
Lordship,
323 or 341 of the IPC. Que the petitioners accused 4 and 5, there shall be an interim order of stay of further proceedings.
Your lordship,
Sorry, only 4 and 5. 1, 2 and 3.
the property belongs to the petitioners, my lord, because of.
Only 4 and 5. The remainder of the accused, interim order, the remainder of the accused would be considered on the appearance of the complainant. List the matter on 10th September in the fresh matters list.
That's all.
Yes, next. 1 HCGP 2 emergent notice.
My lord,
Husbands,
husband is petitioner number 1,
correct.
2, 3 and 4 are parents and
Where are
brother
they? Next,
interim orders, my lord.
only against others.
Please, my lord,
Yes.
obliged.
62.
Take out notice, my lord.
You are 75 years. The victim is 41 years. What did you do? Pokso.
Victim is not 41 years. 9 years old.
Kamalu.
Mother is the complainant.
Mother is the complainant. Sorry, yes. You are 75, right?
70.
What is the age of the victim?
Victim is 9 years.
9 years.
Oh.
Yes. Anything else?
I'll take out notice, my lord. In the meanwhile, I will not insist for any interim order. my lord.
Dismiss
Because
ಮಾಡಬೇಕು ಅಂತ insist.
Just on merits, I be permitted to argue
No,
after appearance. my lord. Only thing is regarding the age, regarding the aspect of sexual assault, I want to argue that is
4 and 6.
after notice.
4 and 6.
Pardon,
No, you make out a case for notice. Otherwise,
my lord.
difficult case for notice even.
My submission, lordship, is one is there is no medical which is done. And the second is that he is already aged up at 75 years.
Like he is 75, that I understand.
Sexual assault, the intention won't be there at that age is my,
Oh,
in
is
the
that?
evening of his, he is suffering from all ailments, my lord, and evening of his,
Any ailment of the
life.
mind?
That is
Otherwise,
what
otherwise intentional always.
his children who are telling that he is also not mentally health, but
Difficult.
permitted to take out notice. I will take my chance, my lord.
ನೋಡ್ಕೊಂಬಂದು ಹೇಳಿ.
Full allegation ಇದೆ.
Allegation
Number,
serious ಆಗಿ.
17, my lord, page number.
And 9-year-old child. ಯಾಕೆ ಬೇರೆ ಏನೋ ಎನಿಮಿಟಿ ಇತ್ತ?
Pardon, my lord.
Enmity with the mother?
Nothing, my lord.
Then
They are
why-
apartment owner,
From-
apartment. They're staying in an apartment. And the only allegation is that the other apartment owners are, the association says that this person, he goes walking all over the apartment walkway
All right.
and he urinates everywhere. This is the complaint which was there. Suddenly the mother says complaint, they give a statement saying that yes,
ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಇದೆಯಾ ಇಲ್ಲೆಲ್ಲ?
Please, my lord.
ಇದೆ.
ಪೂರ್ತಿ ಇದೆಯಾ?
ಪೂರ್ತಿ ಹಾಕಿಲ್ಲ ಅವರು.
ಪೂರ್ತಿ get the charge sheet material, we'll see. List on 23rd in the fresh matter.
Please. Oblige.
Let's.
63. Waiting for petition and worship. Arguing counsel is out of
Station.
session next week, kindly worship.
Case also out of station, 2 weeks.
Worship,
Yes. List after 2 weeks, no date.
64.
Lords, petitioner is a.
How many sale deeds?
No sale deeds, my lord. There's a sale receipt, my lords.
Sale receipt.
Sale receipt, my lords.
Ah.
He enters into a sale receipt. Use 5 lakhs, my lords. He didn't turn up. 10/10/23 is the sale receipt, my lords.
ವಾಪಸ್ ಕೊಡಿ.
I'm ready, my lords. He has filed a suit for specific performance.
All
my
right,
lords.
give it. Suit also will come to an end.
Please, my lords. I'm
I will
ready to
issue
give it
notice.
back, my lords.
1 HCGP 2 emergent notice. Petitioner is also permitted to serve by way of hand summons. List on. We'll take it on 3rd September.
Please, my lords.
Yes.
5.
Raj Khan.
Lords, page 147, lords. Page 147. 2020, they settle in the police station.
All right. ಏನ್ ಬೇಕು?
So far as petitioner number 1 also, my lords.
ಆಮೇಲೆ, yes. Yes, 1 to returnable by 12th. We'll see on 12th, yes.
66.
Same, Raj Khan, A2 and A3. A2 and A3, sir. ಸ್ಟೇ ಕೊಟ್ಟಾಯ್ತು. ಎಸ್, ನೆಕ್ಸ್ಟ್. 67, no representation list after 2 weeks.
68,
Same order.
69,
The petitioners are the in-laws of the complainant.
Page 36.
36 ಇದು ನೋಡಿದ್ದೀನಿ.
Three
ಲಾಸ್ಟ್ ಟೈಮ್ ಕಂಡಿದ್ದು wound certificate ಕೊಟ್ಟಿದ್ದೀನಿ.
not 7.
wound certificate ಕೊಟ್ಟಿದ್ದೀನಿ. ಆಮೇಲೆ ಡಾಕ್ಟರ್ ಒಪಿನಿಯನ್ ಇದೆ.
Oh, no.
ಡಾಕ್ಟರ್ ಒಪಿನಿಯನ್ ಲಾಸ್ಟ್ ಟೈಮ್ kindly see.
Nothing doing. 498, 307. Against anybody, I will not interfere.
Page 25.
No,
ಡಾಕ್ಟರ್ ಒಪಿನಿಯನ್ ಇದೆ.
that's a matter of trial. This case, I will not interfere. Horrible allegation. Honest. ನೀವೇ ಹೇಳಿ ಕೊಡೋಂಥ ಕೇಸ್.
ಅಲ್ಲ 307ಗೆ ಅಲ್ಲಿ ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ ಅಂತ. ಡಾಕ್ಟರ್ ಒಪಿನಿಯನ್
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ. ಡಿಸ್ಚಾರ್ಜ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ಬನ್ನಿ ನೋಡೋಣ.
ವಿಚ್ ದಟ್ ಲಿಬರ್ಟಿ.
ಲಿಬರ್ಟಿ, ಎಸ್. ಅದರ್ವೈಸ್ ಇಲ್ಲಿ ಫೈಂಡಿಂಗ್ ಕೊಡಕ್ ನನಗೇನು ತೊಂದರೆ ಇಲ್ಲ, ಕೊಡ್ತೀನಿ.
ಬೇಡ.
ಎಸ್.
70,
CGP is directed to accept notice for the respondent, go through the papers and make a submission. List on 4th September in the fresh matters list. Next. Yes, sir. 71, anybody?
498.
No, this is even horrible. Well, everybody are frozen. Password.
72,
I represent petitioners. The dispute between the two family cousins,
Correct,
the case and counter cases, 504, 323, 354.
correct,
And petitioners 1 and 3 are the government officials,
correct.
and they were not in the spot, my lord.
No problem. That's a matter of trial.
Correct, my lord.
ನೀವು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೀರಲ್ಲ?
Now first now file ಮಾಡುದು.
ಪರವಾಗಿಲ್ಲ.
Second, this is the 4th case, my lord.
No problem.
So I request your lordship.
It's case and counter case.
Cases, this is the 4th case, my lord.
Maybe.
The
One
dispute regarding the,
One HCGP, 2 emergent notice.
please, is my request, my
No.
lord. Please.
ನೀವು ಹಾಕಿರೋ ಕ್ರೈಮ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅಂದ್ರೆ ಅವ್ರದ್ದು ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಅವ್ರು ಬಂದ್ಮೇಲೆ ನೋಡಿ.
And the dispute between the two family.
Maybe. Why have you registered the crime? ಯಾಕೆ ಹಾಕಿದ್ರಿ ಹೇಳಿ?
ಯಾಕೆ ಹಾಕಿದ್ರಿ ಅಂದ್ರೆ there is a dispute regarding the road.
ಡಿಸ್ಪ್ಯೂಟ್ ಆಯ್ತು. ನಿಮ್ಮ ಅಫೆನ್ಸ್ ಏನು?
Same offense.
ಅಷ್ಟೇ.
Same offense.
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್.
Please.
1, 2. ಹೇಳೋದಕ್ಕೆ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ HCGP 1, emergent notice 2.
53,
And for the petitioners in this matter, my lord.
ಶಾಸಕನ ಅಂದ್ರೆ ಗೊತ್ತಾಗುತ್ತಾ?
My lord, and for the petitioners in this matter.
A1 is the husband, no stay. A2 and A3, Kashkan.
My lordship, this is the second marriage for both of them. He has taken care of the
No
complainant's
problem, sir.
daughter.
Let the wife come, sir. Yes.
74,
ಹೇಳ ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಕೊಡ್ತೀನಿ. The accused number 1 is the husband, ನಿಮ್ದಲ್ಲ. Accused number 1 is the husband. A2 and A3 are the mother-in-law and father-in-law of the complainant. A perusal at the allegations would not indicate any of its ingredient found in the facts that are narrated either in the complaint or in the charge sheet, as the case is in the complaint. Therefore, finding no allegation, there shall be an interim order of stay of further investigation qua accused number 2 and 3, failing which it would run foul of the judgment of the apex court in the case of Kashkan Kaushar versus so and so, 2022 SSC online SC page 162. Yes, ashte. There shall be an interim order of stay only against accused number 2 and 3 and not the husband, accused number 1. 1 HCGP, 2 emergent notice.
74 for
74,
mother-in-law, my lord. A2 mother-in-law.
A2 is mother-in-law. So,
498 offense.
correct, sir.
320.
go to page 28, sir. Mother-in-law ಮೇಲೆ allegation ಇಲ್ಲ ಅಂತ ಸ್ಟೇ ಕೊಡ್ತೀನಿ ನಾನು.
But initial, first null and void petition ಹಾಕ್ತಾರೆ, ಅದಾದ್ಮೇಲಿಂದ ಅವರು
ಸುಮ್ಮನೆ mother-in-law ಅಂದ ತಕ್ಷಣ ಕೊಟ್ಬಿಡ್ತೀನಿ.
Mother-in-law.
Yes, sir. No. See page 28. ಇದೆಯಲ್ವ ಹೇಳಿ ನೀವೇ ಮತ್ತೆ.
Please.
Yes. one HCGP, two emergent notice. Pendency of this petition will not come in the way of either investigation. Charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ sir, try ಮಾಡಿ.
Pendency of this case will not come in the way of investigation.
Okay.
341, 74 ah? 1 minute. ಯಾವ್ದು ನೀವು appear ಆಗಿದೆ?
75.
Which is your matter, sir?
75.
70?
5 maybe. Yes.
Why did you say 74 then?
75 my lords.
Yes, sir. Serial number ಗೊತ್ತಿಲ್ಲ. Offense ಗೊತ್ತಾ ಏನು ಅಂತ?
ಹೌದು sir.
ಏನು?
506, 506, 504.
341, sir.
Yes, yes.
ಮತ್ತೆ? Yes.
504,
One HCGP, two emergent notice, finding no foundation.
Swami, idರಲ್ಲಿ permission sir. Swami, the respondent number 2 has continuously filed PCRs against the 5 wives sir, for some.
5?
My lords, he has 5
Can-
wives. Previously, he has married 5 of the.
5 wives
ladies.
ah?
Yes, yes.
Who is that man? ಒಂದು ನಿಮಿಷ ಕೊಡಿ.
Respondent number 2. I have some certified copies of the PCR filed by the respondent number 2.
You are what?
We are the wife and mother.
You are, both of you are wives.
No, 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 no.
Huh?
No, no, my lords, in other cases, in 2015, he has filed a PCR on one
Sir,
SG.
Petitioner number 1, accused number 1.
Yes.
She is the wife of the complainant?
Yes.
ಎಷ್ಟನೇ wife?
6th wife. sir.
6th wife?
Yes.
Petition number 2
She is mother-in-law
of,
the respondent
ಅಂದ್ರೆ
number 2.
mother,
Mother
first
of the
petition-
wife, this one, first petition.
first petitioner's mother.
Yes.
Against 5 wives, he has filed,
Yes, similar PCRs have been filed. I
ಕೊಡಿ
have
ಎಲ್ಲ.
I have a memo.
Give it. Case in the reverse ಇದು? Yes. ಇದ್ಯಾವುದು?
First case, he has filed GNWC case in a family court. And second.
Against what?
Against his one Yasmin Taj.
Which
She is first wife,
wife number?
wife number 1.
Baby number 1. Yes. Wife number 1. Next.
Next, he has filed one more PCR number 15423/15
Page.
against SG FIFA, page number 70. 75.
Page 17. PCR. ಅತ್ತಾಳಿ ನಿಮ್ ರೋಲ್ ಆಮೇಲೆ.
17.
First let us resolve whose wife is whose husband. Yes.
17, page number 17, my lords.
Page number?
17,
ಇದು wife number 2.
wife number 2. He has stated in the PCR, my lord, when he has married.
All right. Next.
And page number 36, document number 3.
36.
Yes, my lord. Reshma, I am.
This is wife number 3, na?
Yes, my lord. He has stated in the PCR the date of marriage also.
All right. ಆಮೇಲೆ ಎಲ್ಲರ ಮೇಲೆ similar offenses.
Yes, my lord.
Then next.
That document number 4, page number 56. We have got only the complaint to Commissioner of Police. That is Mrs. Salma.
1 minute. 50?
6, my lord.
This became a crime?
Uh,
Register ಮಾಡಿದ್ರ?
Illa, Swami, they have not registered, but he has, this lady Salma has filed a 498 FIR,
Against-
which was quashed earlier. He has come to this High Court and he has quashed the case. I'll produce the order copy of the same.
All right. Now this is 5 ಅದು?
Yes, sir.
You are the 6th now.
Yes, sir.
What is the offense, sir?
Whenever we are going to appear in the, our cases where we have filed this 498 everything.
You have filed
Maintenance
498.
case, Yes.
Huh.
He continuously comes with his mobile and he records, he abuses us, he instigates us. So all the FIRs which he has continuously in 2022, 23 and 24, he has subsequently has filed 3 FIR. On the same things that whenever we are going to the court, they are abusing, in the, all the offense.
Same offenses.
Place of offense is in the court only itself.
27, madam.
Huh?
Charge sheet ಆಗಿದೆ, 27 is the summary of the case.
ನೋಡಿದ್ದೀನಿ. 341 is the allegation ಇದರಲ್ಲಿ. Wife did not allow the husband to move around.
All the offenses, the place of offense is.
You should have
in all-
produced all this. Why have you not produced?
No, today morning they have given some parties, the petitioner have given it in.
ಬರ್ಕೊಳ್ಳಿ. The second respondent is the complainant. The accused number one petitioner is his wife, and the accused number two is the mother. The learned counsel for the petitioner submits that the accused number one is the sixth wife of the second respondent complainant. The modus operandi of the second respondent husband appears to be getting married, registering cases, getting married and indulging in certain torture to those wives. And whenever those wives would register complaint against the second respondent husband for offenses punishable under 498A or otherwise, goes on registering complaints against those wives for offenses of hurling abuses, assault, or restraint upon the movement of the complainant husband. The learned counsel for the petitioner has filed a memo appending several documents of crimes registered against the first 5 wives. A perusal at those documents would indicate that all the offenses alleged against every one of the wives that he has got married right from 2015 till date are identical. Therefore, I deem it appropriate to protect the sixth wife and her mother from further abuse of the process of the law by the second respondent husband till the next date of hearing. There shall be an interim order of stay of further proceedings in CC 32127 of 2022 till the next date of hearing. List the matter on 18th September in the fresh matters list.
Surplus.
76.
Lord, similar case he has filed in 2022, in which we have filed a petition in crime number, my lord.
Crime
That
number
it has
change.
been filed, yes.
Who is this Mohammed Ajmat?
He is the brother of the first petitioner, the wife.
ಇದು ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡಿ 7576
Family.
same order. ಇದರಲ್ಲಿ
No for withdrawal file.
petitioner is the brother of accused number one in the companion petition.
ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರೆ ಸ್ವಾಮಿ.
ಅದು all right, ನೋಡ. Yes. All further ಬೇಡ. All further proceedings ಬೇಡ. All further proceedings taken pursuant to the registration of the crime shall remain stayed. ಅದು ಹಾಕಿ ನೀವು ಆಮೇಲೆ ಮಾಡೋಣ.
77.
Much of.
Question.
ITP, sir.
Item 3, 4,
A3.
A3.
You are not the customer.
No.
1 HCGP, 2 emergent. Complainant yaru?
The complaint is one, my lord, it's Naveen, my lord.
ಅಲ್ಲ police ಅದನ್ನು? HCGP for both the respondents. Yes. No stay. They are not the customers, sir. Yes.
My lord, section 13, my lord, the entire investigation.
13 is not mandatory at all. And investigation conducted by police inspector is also not the ground.
Not special
Both-
officer.
Huh?
Not special officer, only
No
started
problem.
officer.
That has been held to be not mandatory. RAH Siguran judgment ನೋಡಿ. ಅವ್ರನ್ನೇ ಕೇಳಿ ಅವರೇ ಅಪಿಯರ್ ಆಗಿರ್ತಾರೆ.
Other it is not,
Yes,
lady
sir.
not, women is mandatory, my lord.
Woman is not mandatory, sir.
13,
Woman is not mandatory, sir.
class 1, my lord.
15 plus 1 is also not mandatory.
And
No,
some citation uploaded in.
no problem, sir. I have considered everything and held that is not applicable.
Cover by judgment, there is.
I have uncovered it, sir. No,
Darwad bench, my lord.
no, sir. Yes.
Advertisement.
We'll see. Yes.
Please.
Emergent notice.
Please.
1 HCG, 2, sorry, both respond. Yes.
78.
Heard the learned counsel appearing for the petitioner. The sale is 2006, ಅಲ್ಲ?
97 first sale. After that,
97 ಅಲ್ಲ second. ನೀವು picture ಬಂದಿದ್ದು ಹೇಳಿ sir.
2005.
The first sale that takes place in the year 1997 results in a subsequent sale in the year 2006. It is where the petitioner comes into the picture. About 18 years thereafter, 16 years thereafter, comes the impugned complaint by the complainant alleging certain certain facts that has become the ingredients of the offense under section 420 or 447, both of which are prima facie untenable as the petitioner pursuant to the sale deed is in possession, 447 cannot be laid against him. And since the sale deed is executed in the year 2006, there cannot be an offense of cheating in 2022. Therefore, there shall be an interim order of stay of further proceedings, square the petitioner till the next date of hearing.
Please.
Obra Ibra, square the petitioner till the next date of hearing. And date beda, ಆರಾಮಾಗಿರ್ಲಿ. Yes. Next time ಕ್ವಾಶ್ ಮಾಡೋಣ. Yes, ಬರ್ಲಿ ಅವರು.
Page is examination of CW 8, my lordship.
No, this 79 I wanted to fix. 79, 78 stay ಆಯ್ತು sir. Huh? ಬೇಡ. Yes.
Prohibition of charging of exorbitant interest. Non-cognizable.
No.
Your lordship, that's what
And
happened.
ಏನಿದೆ ಸ್ಟೇಜ್ ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ.
Evidence of
Evidence
CW
stage.
8, my lordship.
So non-cognizable offense, the FIR was registered on the.
No,
basis of-
non cognizable ಅಲ್ಲ.
How?
No, sir.
Well, he has taken permission from the court and thereafter filed his registered NCR first.
We'll see, yes.
Your lordship may kindly see the page,
3 and 4.
page 42.
But the matter is at the stage of trial, sir. Trial is on.
And basically, the lodging of FIR itself is
No,
bad in law.
I will not put the clock back. You will get acquitted, no problem.
ಇದೆಲ್ಲ acquit ಮಾಡ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ
ಅದು ಗೊತ್ತಿಲ್ಲ sir. We'll see. ಮಾಡದೇ ಇರೋದು ಬೇರೆ.
Your lordship,
You have an appeal remedy.
your lordship may kindly see the NCR is registered initially.
Sir, I will not put the clock back to several years and say FIR itself is wrong when trial is on.
I mean, taking cognizance itself is also wrong.
Oh, no. Sir. When was the cognizance taken, sir?
Your lordship may kindly see that is dated 31/2021.
ಅದು 4 ವರ್ಷ ಆಗಿದೆ. Nothing.
Even on merit also, the
Sir,
charge
it
sheet is not.
trial is on, you will get acquitted. If you don't get acquitted, you urge all these contentions before the concerned court. Not at the advanced stage of trial.
When the FIR itself is bad in law.
Sir, can I put the clock back? No, sir. I will not. You urge everything before the concerned court.
Permit me to urge these.
That I will do, anything, yes. The petitioner is before this court, calling in question proceedings in CC 293 of 2020, registered for offences punishable under so and so. The learned senior counsel, Sri Gopal Swamy, appearing for the petitioner, would submit that the very registration of the crime is erroneous and therefore this court should interfere. Much water has flown after the registration of the crime. According to the learned HCGP, who on verification of the records would submit that the trial is at an advanced stage. At this stage, interference in exercise of jurisdiction of this court under section 48 of the CRPC is not warranted. Therefore, the petitioner is at liberty to urge all the contentions before the concerned court, including the ones that are sought to be urged before this court in the subject petition. With this aforesaid liberty, the petition stands disposed. Next.
80?
Why did you call her fat?
There are two girls.
Fat people, if you call fat, definitely 509.
There are two girls.
Why, the girls have called the other girl fat. What, sir? Outraging the modesty of woman is the allegation. The petitioners are accused.
The accused number 3 is before you.
Accused.
3.
ಒಬ್ರೇನಾ ಇಲ್ಲಿ?
ಒಬ್ರೇ ಇದೆ.
But the petitioner is accused number 3. It transpires that accused number 1 and 2, while they were seated in chapter 1 bar and restaurant, in an inebriated state, appeared to have called the complainant a fat lady. Therefore, the offense under section 509 of the IPC has emerged. The petitioner is accused number 3. The two other are accused number 1 and 2 are women who have called the other women being fat. Prima facie, I find the crime so registered and investigation conducted by the police. Charge sheet hakbittidare and filing of a charge sheet which contains no ingredient of the offence under section 509 to be an abuse of the process of the law. Therefore, there shall be an interim order of stay of further proceedings quay the petitioner accused number 3 till the next date of everybody 1 and 2. Now they'll come. Yes.
Great.
Abuse of the process of the law. Therefore, there shall be an interim order of stay. Next.
The petitioner.
Yes, sir.
The offense under 323, 324, 504 and 506
Correct.
and 341.
Hmm.
It's the de facto complaint R2,
Hmm.
mother of petition number
Hmm.
3. Let's facts are on 9.
Hard facts are come to page 21 except A2 against everybody there are allegations.
Page number.
Yes, sir. 1 HCGP, 2 emergent notice returnable by 11th. Finding no allegation, no ingredient of offences so alleged only against accused number 2. There shall be an interim order of stay only against accused number
Look.
2.
Against accused number 2 also.
Hello, sorry. Also na, ಎಲ್ಲಿದೆ?
ಆರೋಪಿ ಎರಡು ಚಪ್ಪಲಿಂದ ಮೈಕೈಗೆ ಹೊಡೆದಿರುತ್ತಾರೆ ಮತ್ತೆ ಆರೋಪಿ
ಅಲ್ಲ,
ಮೂರು
except,
ಕೈಗಳಿಂದ
ಒಂದ್ ನಿಮಿಷ, ನಿಮಿಷ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ
Only 8, ಅಲ್ಲ, against others except accused number 2. Yes. so
Hello.
and so.
let's counter blast case ಅಷ್ಟೇ.
ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ ಮದರ್ ಗಿವಿಂಗ್ ಅ ಕಂಪ್ಲೇಂಟ್ ಆನ್ ದ ಸನ್
No problem.
and
I have not discussed this.
9-3 ನಾವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿ 354 ಅಲ್ಲಿ FIR ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ ಅಂಡ್ there is a stay of the coordinate bench
No
of the
problem,
honorable court. ಅಲ್ಲ ಅದ್ ಪ್ರಿನ್ಸಿಪಲ್ ಕಂಪ್ಲೇಂಟ್ ಸ್ಟೇ ಆಗಿದೆ ಸೊ ಪೇಜ್ 64
Then
63.
take advantage of it.
ಅಲ್ಲ ಸೊ ಈಗ ನನ್ನ
Let us
ಮೇಲೆ
say
ಚಾರ್ಜ್
again,
ಶೀಟ್ ಅಲ್ಲ
take advantage of it.
ನನ್ನ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸೊ
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ ಆಗಿರೋದ್ರಿಂದ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ
No problem, sir. List
There-
the matter on 4th September. Number ಕುಡಿಯೋದು.
ಹಾಕಿದ್ದೀನಿ ಸೊ ಪೇಜ್ ನಂಬರ್ 63 to
number.
65.
Page
63 to
tag
65.
this petition along with page 63. ಏನು ಬರಿಬೇಡಿ. The learned counsel for the petitioner submits there is an interim.
ಸರ್ ಅಡ್ವೊಕೇಟ್ ಮೂರ್ತಿ ಅವರು ಮಾತಾಡ್ತಾ ಇರೋದು. ಸರ್ ನಮಸ್ಕಾರ, ನಾನು ಅಡ್ವೊಕೇಟ್ ಚೇತನ್.
The learned counsel for the petitioner submits that there is an interim order operating where where the very complaint quay other accused has been stayed.
No, not that, my lord.
Then
The other case, the principal complaint, what I filed on 9-3,
It is
that has
stayed,
been
is it?
stayed, my lord.
the
The
issue.
subsequent is
issue
the counter
appears-
blast case. Now what is
The
under challenge?
issue
before
appears
my
to
lordship?
be a complaint registered by the petitioner and as a counter blast, the impugned complaint coming up. The learned counsel for the petitioner submits that in the complaint registered by him, this court has granted an interim order of stay. This being a complaint which is registered as a counter blast, therefore shall remain stayed till the next date of hearing. 1 and 2 HCGP tag the petition along with so and so. List them both on 13th September in the fresh matters list. We'll dismiss both.
Yes, my lord.
Yes, sir.
82. My lordship, this trial court, before trial court only, the case is disposed of, my lordship.
no.
Stating that accused has already paid the amount.
ಯಾವ್ದ್ರಲ್ಲಿ ಮೇಡಮ್?
82.
82, my lordship.
447, 324 paid the amount.
323, 504.
ಅದ್ರಲ್ಲಿ ಯಾವ paid the amount, madam?
Connected.
ಇಲ್ಲ sir. Here, my lord,
82 ಅಲ್ವಾ?
Please, my lordship.
ಚಾರ್ಜ್ ಇದ್ರೊಳಗೆ ಯಾವ್ದು
ಇದ್ರಲ್ಲಿ ಯಾವ್ದು ಬಿಟ್ಟು ಇಲ್ಲ ಮೇಡಮ್.
ಡಿಸೆಂಬರ್ಗೆ ಹಾಕಿದ್ದಾರೆ. ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ ಕೇಸ್ ವಾಸ್ ದೇರ್.
ಏನ್ ಹಾಕಿದ್ದಾರೆ ಡಿಸೆಂಬರ್ಗೆ?
Matter was posted to December.
Thank you for the information. Only notice.
No, one submission, my lord.
Hmm.
No, got.
Yes, sir.
My lord, petitioner files a partition suit. He is a retired ASI. In the year
Come to page 19.
Ha. My lord,
ದಿನಾಂಕ ಬೇಡ ಸರ್. A1 ಮತ್ತು A2
A1
ಜಮೀನಿಗೆ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ
ಪ್ರವೇಶ ಮಾಡಿ
ಕೈಗಳಿಂದ
ಹೊಡೆದು
ಹಾ.
ಬಾಯಿಗೆ ಬಂದಂತೆ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದು
ಆಯ್ತು.
ಕಾಮಗಾರಿ. My lord, my lord,
Hmm.
complaint is a hearsay complaint. This CW5 is alleged.
Complaint is hearsay.
Please, my lord.
I will grant an interim order after hear the other side.
Lord, I will.
You can say anything. that
I will demonstrate, my lord.
Yes.
Kiran Kumar.
Yeah, who is Kiran Kumar?
CW5.
Hmm.
He alleged
kindly take photo, my lord, page 59 for a moment.
ನಮಗೆ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ, ಫೋಟೋನು ಗೊತ್ತಿಲ್ಲ.
For-
ಕೈಂಡ್ಲಿ
for-
ಟೇಕ್ ಫೋಟೋ ಅಂದ್ರೆ
For a moment, page 59, my lord, 59 is the photograph, my lord. A1 was present, A1 was holding the machete, A2 was not at all present in the occurrence, my lord.
ದಟ್ಸ್ ವಿಲ್ ಸಿ. ಎಸ್.
My lord, another thing is, my lord, it is because we obtained a status quo, page 99.
ಎನಿವೆ ಮ್ಯಾಟರ್ ಇಸ್ ಇನ್ ಡಿಸೆಂಬರ್ ಅಲ್ವಾ ನೆಕ್ಸ್ಟ್?
ಅಲ್ಲ, ಅಲ್ಲ ಸ್ವಾಮಿ,
ಅಷ್ಟೊಳಗೆ ತೇಕೊಳ್ಳೋಣ.
ಇನ್ಸ್ಪೆಕ್ಟರ್, ರಿಟೈರ್ಡ್ ಇನ್ಸ್ಪೆಕ್ಟರ್, he is very well aware.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಇಸ್ ಡಿಸೆಂಬರ್ ಅಲ್ವಾ? ವೈ ವರಿ?
ಇದು ತುಂಬಾ ಏನಾಗಿದೆ,
ಅದೆಲ್ಲ
ರಿಟೈರ್ಡ್
information
ಸ್ಟೇಜ್
ಹೇಳ್ಬಾರ್ದು.
ಅಲ್ಲಿ he was not there. ಇಲ್ಲಿ ಏನ್
Okay.
ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಫೋಟೋಗ್ರಾಫ್ ಮಾಡಿದ್ದಾನೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಫೋಟೋಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
HCGP 2 emergent notice returnable by the 13th of September, list on 13th of September in the fresh matters list.
Sorry, till then,
December
ಅಲ್ಲ ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಇದೆ, ಅಲ್ಲ ಇದೇನಂದ್ರೆ ಒಂದೇ ಒಂದು ಓದ್ಬಿಟ್ಟು,
ಅವತ್ತು ಕೊಡು.
ಅಲ್ಲ ಒಂದೇ ಒಂದು ಓದ್ತೀನಿ ಸ್ವಾಮಿ. ಫೋಟೋ ತೆಗ್ದಿದ್ದಾನೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಫೋಟೋಸ್ ಇಲ್ಲ, ಫೋಟೋದಲ್ಲಿ ಬರೀ A1 ಮಾತ್ರ.
ಅವತ್ತು ಕೊಡುವ ಸರ್. ಎಸ್.
83.
In the meantime. Oh, ಗೊತ್ತಾಗತ್ತಾ? Okay, in the meantime. Yes.
54.
Matter is sub judice.
No, my lord, what happened?
499, 500, I know. What is challenged?
Earlier, my lord, in 2021, he filed the private complaint, my lord.
ಹಾ,
In that, the B report was filed, my lord.
ಅದನ್ನೇ ಕೇಳಿದ್. ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕದ್ಮೇಲೆ ಏನಾಗಿದೆ?
Then stay was granted by this court, my lord.
That is still pending.
Still pending.
Criminal petition.
In page number 88, my lord. Criminal petition number 445 of 2024.
Tag this petition along with criminal petition 445 of 2024. The subject matter of the said criminal petition is the police filing a B report in a complaint registered by the complainant and the complainant filing a protest petition and cognizance being taken by the magistrate on this after rejecting the B report. On those facts that form the contents of the aforesaid petition, the impugned proceedings for offence punishable under section 499 and 500 of the IPC have sprung. In the light of the matter pending adjudication, pending consideration at the hands of this court, there shall be an interim order of stay of further proceedings in CC 11076 of 2024 till the next date of hearing. Tag ಹೇಳಿದಿನಲ್ಲ. List them both on 19th September. Yes, sir.
85.
85, I appear for the petitioner, your lordship.
Madam, 307, your
Yes, Your
A7, but I would like to see the investigation papers.
Papers are there.
Your lordship, if I may be permitted to show the documents,
No,
there
no,
are civil
kodi,
disputes.
papers kodi. List on 21st in the fresh matters list.
Your lordship, for one moment, your lordship.
Learned
Civil
HCGP
disputes-
places on record the papers of investigation. The same is placed into the file.
Your
Yes,
lordship, I may be heard for 2 minutes. I'll just demonstrate. There are civil disputes pending between the de facto complainant A4 and
not a
A5.
license for 307, madam.
No, your lordship, he is no assailant. The complaint does not disclose that the petitioner was anywhere on the spot and the
We'll see,
premises were
on 21st, yes. Bail ತಗೊಂಡಿಲ್ವಾ?
bail ತಗೊಂಡಿದ್ದಾರೆ, your
ಮತ್ತೆ
lordship. But the
21st, yes.
alleged premises magistrate court complex, your lordship. None of the
List-
advocates
List
complained.
on 21st, madam, in the fresh
Much
matters list.
In this matter, my lord, I am appeal for petitioner.
Hmm.
So the second respondent filed a case
ಅದೆಲ್ಲ
against
sir,
498A.
So,
that
marriage date ಅದೆಲ್ಲ ಹೇಳೋದ್ ಬೇಕಾಗಿಲ್ಲ.
So that petitioners are parents of the husband of
Yeah,
second
parents.
respondent.
Learned, heard the land council appearing for the petitioner. The one HCGP 2 emergent notice, there shall be an interim order of stay where the petitioner still the appearance of the second respondent complainant. List on 12th in the fresh matters list. Yes, next.
87.
A2.
A2, my lords. It's a government servant, my lords. These are counterblast petitions are being filed by the complainant. There is no merit in the complaint. There's department and
That
inquiry.
we'll see.
My lords, yes, my lord. My lords, there's no merit in the complaint at all, my lords. Prima facie, there's no allegation against accused number 2. He was an in-charge managing director of the particular organization since there was no action taken based on the complaint. However, there are documents to show that there are action taken by this particular officer also, my lord.
We'll see, we'll see. Ambedkar Development Corporation.
Yes, my lord.
sir. One HCGP 2 emergent notice. Returnable by the 12th, list on 12th September.
Much more.
Yes.
Petitioners, my lord.
Case and counter case.
Please, my
Yes.
lord. The matter is also seized by this honorable court in RSA
Number,
matter.
number. ಅಲ್ಲ, RSA number ಗೊತ್ತು ಇದ್ರಲ್ಲಿದೆ.
Yeah.
But case and counter case.
Case and counter.
Correct. Notice. One HCGP, two emergent notice. Yes.
Here for the petitioner, my lord. This is the third complaint, my lord. Two complaints, same allegations, my lord.
Stay ಆಗಿದೆಯಾ?
Stay ಆಗಿದೆ ಎರಡರಲ್ಲಿ.
Number ಕೊಡಿ.
My lord, I have enclosed the copies also, my lord.
Tag
Annex-
this petition
annexed
along
HML.
with page 42 ಒಂದು.
42, my lord.
42 ಒಂದೇನಾ?
42 ಆಮೇಲೆ ಇನ್ನೊಂದಿದೆ.
Tag this petition along with page
42 and
42, petition
64
number
my
ಎಲ್ಲ
lord.
ಇದೆ. The learned counsel submits that the coordinate bench of this court in criminal petition 1314 of 2024 has passed the following order, page 43. The subject complaint is the third in line is the submission of the learned counsel appearing for the petitioner. Tag this petition along with so and so, there shall be an interim order of stay for the proceedings qua the petitioner, as is obtaining in the companion petition quoted supra. Next.
Much.
The report is accepted. Hello, 90 ಏನು?
90 the offense under section 471, 420.
Correct, sir. Page 72. Notice only.
One submission,
One HCGP, two emergent notice.
the
Yes, next.
one submission,
91 for the petitioner.
The report closed and accepted.
Please, my lord.
Ah.
Initially also, my lord, first time police filed.
You'll have to hear the other side. Yes.
I'm not sought for stay also.
You can't be stayed also.
Proceedings.
Heard the learned counsel Srimati Rakshita DJ appearing for the petitioner. One HCGP, two emergent notice.
2
Alla, sorry, two illala. 2
to around
one HCGP illala.
11, my lord.
One ನಿಮಿಷ. State ಇದೆಯಲ್ಲ, one HCGP, 2 to 11 emergent notice returnable by 11th of September. Yes.
92.
Preparing for petition, my lords. 143, 147. It's only a fact check video, my lords. There is no damage has been caused to the idol also. And here they,
This is an attempt to create disharmony.
no, my lords, because
No,
it is, there was two parties, my lords, engaged in this, my lords. So in case and counter case, my lords. So it's already one.
Maybe.
Because here in the Sottu Mahajar.
ಅವ್ರು ಹಾಕಿಲ್ವಾ ಕೇಸ್?
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ sir.
ಅದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಹೌದು.
Number ಕೊಡಿ.
Read petition number. I have produced, my lords.
Page.
Page number 54, my lords. Read petition number 10115 of 2024. Here also same allegation, my lords. 505 was 447 and 505 was
Tag this petition. Vivek. 54, page 54. Counsel for the petition submit. Same quote ಮಾಡ್ಬಿಡಿ interim order. Previous ಒಂದು ಹೇಳಿದ್ನ ಅದೇ ತರ quote ಮಾಡ್ಬಿಟ್ಟು in that light. Copies ಎಲ್ಲ next week. Urgency ಇದೆಯಾ?
Please.
Interim order copy.
Please.
Stayed.
Next.
ಏನ್ ಕೇಸ್ ಇಲ್ಲ.
Case under 138.
So what?
Yes, sir.
Heard the
Okay.
learned counsel appearing for the petitioner. The allegation, the allegation is for the offense punishable under section 138 of the Negotiable Instruments Act. It is settled principle of law that unless there is particular role attributed to the respective directors, a crime for offense punishable under section 138 of the Negotiable Instruments Act cannot spring. This is in the cannot spring. Permitting further proceedings qua these petitioners, one illa. One beda.
One is the company.
One company really.
One company.
Yes.
2, 3, 4.
Permitting further proceedings qua the accused 2, 3 and 4, petitioners 2, 3 and 4 would run foul of the judgment of the apex court in the case of Susila Padmavati so and so, 2024 SSC online SC page 311. Therefore, there shall be an interim order of stay only against accused number 2, 3 and 4. Yes.
Publish.
It's made clear. For the further proceedings, accused number 1 shall continue.
94.
Emergent notice, mail ಹೇಳಿದಿನ madam. Emergent notice to respond. Next. 94, no representation. This is after 2 weeks.
95.
You have stayed identical matters. ಇದ್ರಲ್ಲಿ ಮಾಡಿಲ್ವಾ?
138, my lord.
138 ಗೊತ್ತು, ಬೇರೆ ಐಡೆಂಟಿಕಲ್ ಕೇಸಸ್ ಮಾಡಿಲ್ವಷ್ಟೇ? ಕೆನ್ನಾ ಮೆಟಲ್ 94
Second
ಗೊತ್ತಾಗ್ಲಿಲ್ಲ
petition,
ಮೇಡಮ್.
not the signature of the check, my lordship.
94 ಹಾ ಕರೆಕ್ಟ್ 94 ಎಸ್. ಹಾ
The second petition is not the signature of the check, my lordship. It's not
It will
able-
see. Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to that effect in the next 2 days. List on 21st in the fresh matters. Next.
96.
The document.
ಅಲ್ಲ, ಸೂಟ್ ಹಾಕಿದಾರ?
ಹೌದು, ಸೂಟ್ ಇದೆ.
Number.
OS number 2925 of 2005.
The subject of the present crime is a sale deed that is said to have been executed between the parties. On the same cause of action, it transpires that a suit in OS
2925 of 2005.
2925 of so and so is pending consideration. Suit instituted by the complainant.
No, I have filed a suit.
Why?
Suit for declaration.
Suit so and so. After the registration of the suit by the petitioner, the impugned complaint springs on 17/7/2023. The issue being purely civil in nature is sought to be dressed with a color of crime, dressed DRESSED, dressed with a color of crime, albeit prima facie. Therefore, there shall be an interim order of stay of further proceedings, square the petitioner till the next date of hearing. 99, 96 ಅಲ್ಲ ಇದು?
96.
Yes, next. 7A,
Yes, my lord.
13th.
There is a different circumstances, my lord. I am not the government servant here, my lord.
So 12 ಬರ್ಬೇಕು ನಿಮ್ಮಲ್ಲಿ ಅಷ್ಟೇ.
My lord, I am the advocate clerk, my lord.
Advocate clerk.
Yes, please, my lord.
ನೀವು
Kindly see
ಮಾಡಿದ್ದೀರಾ?
that, my lord.
What is this? One ನಿಮಿಷ. Which advocates clerk, sir?
My lord. May I take
Which
my-
advocates clerk?
On Manjunath, it's an advocate, my lord, practicing. Yes, my lord. My lord, may kindly come to the page number 53, my lord. That is the draft Mahajar. May I have given my explanation, my lord.
ಹೊಸಕೋಟೆ ಮಂಜುನಾಥ್ ಅವರ ವಿರುದ್ಧ ದೂರು. ಏನ್ ನೀವು ದುಡ್ಡು ಕೊಡಕ್ ಹೋಗಿದ್ರಾ? ಇಲ್ಲಿ ತಗೊಳಕ್ ಹೋಗಿದ್ರಾ ಅವ್ರ ಪರವಾಗಿ?
No, my lord. No, my lord. ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಅದನ್ನ ನಾನು ಹೋದಾಗ ಅವ್ರು ನನ್ನ ಹತ್ರ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Only the amount was required from my side, my lord. I'm not the government servant. There is no FIR, there is no complaint against me, my lord. May I read that, my lord?
Then why are you before the court?
Because I'm the accuser in that case, my lord.
Are they accused?
Accused number 2, my lord.
Accused number 2 is it?
Yes, my lord.
One is Manjunath.
One is Manjunath. He's the head constable. He has demanded and the complaint is against him, my lord.
Advocate clerk head constable ಗೆ ಏನ್ ಸಂಬಂಧ? Why did you go there?
ಅಡ್ವೊಕೇಟ್ ಕೆಲಸ ಮೂನ್ ಸರ್ಟಿಫಿಕೇಟ್ ತಗೊಂಡ್ ಬರ್ಲಿಕ್ಕೆ ನಾನು ಸ್ಟೇಷನ್ ಹೋದಾಗ ನಾನು ಹೊರಗಡೆ ಬರ್ತಾ ಇರ್ಬೇಕಾದ್ರೆ ಅಮೌಂಟ್ ತಗೊಳ್ಳಿ ನನಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Change circumstance.
Yes,
Correct.
please, my lord.
The learned counsel B. Latif is directed to accept notice for the first respondent petitioner to serve set of papers upon the aforesaid counsel. Second respondent is the complainant. A complaint comes to be registered of demand of bribe. Que accused number 1, a head constable. The petitioner claims to be the clerk of an advocate who had been to the place to secure a wound certificate. At that point in time, noticing the local, noticing a trap being laid, amount is given to the hands of the accused number 2, the clerk of an advocate. It is therefore he is drawn into the web of crime. In that light, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. List on 13th.
Grateful.
Yes.
98. Withdrawn member.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಸರ್, ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ.
Liberty. Yes.
ಕೊಟ್ಟಿದ್ದು 7th ಕೊಟ್ಟಿದ್ದೀವಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದ್ರೆ ಲಿಬರ್ಟಿ ಕೂಡ ಫಾರ್ಮ್ಯಾಟ್. ಯಾವುದು ಮೇಡಮ್? In terms of the memo, yes. 98 in terms of the memo.
99.
171 in the meantime. Next. State, sir. 171E. Yes, sir. Next. 100 Jambu Bandari. What is judgment? 20% ತಾನೇ ಇದು?
20%.
ಮತ್ತೆ ಅದಕ್ಕೆ ಜಂಬು ಭಂಡಾರಿ ಅಂದ್ವಿ.
You will deposit the amount 30 days extension of time.
Got extension, yes. Learned counsel for the petitioner submits if 30 days time is granted, he would deposit the 20% amount as is ordered by the concerned court. Therefore, dispose ಮಾಡ್ಬೋದಾ?
Dispose ಮಾಡಿ.
Identical,
ಕೊಡಿ ಅದು, ನಂಬರ್ ಕೊಡಿ.
page number 47.
ಸೇಮ್ ಆರ್ಡ್ರಾ?
ಅದ್ರ 10 days ಅಂತ ಮಾಡಿದ್. ನಾವು ಕೇಳಿದ್ದೆ 10 days. So ಇದ 30 days ಕೇಳಿ, 1 month.
ಈಗ ಕೇಳೋದ್ರಲ್ಲಿ ಹುಷಾರಾಗ್ಬಿಟ್ಟಿದ್ದೀರಾ.
Last time.
Page
47.
ಇದು ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ. ಅದರಲ್ಲಿ 10 days ಟೈಮ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್ ಬದಲು 30 days ಟೈಮ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್.
NBW order ಮೇಲೆ it is stated.
ಇದೆ ಸೇಮ್ ವಿವೇಕೆ. ಇಲ್ಲಿ till the expiry of 10 days ಬದಲು 30 days from the receipt so and so warrant issued against shall stand suspended. ಆ ಥರ ಎಲ್ಲೆಲ್ಲಿ 10 ಕಾಣುತ್ತೆ ನಿಮಗೆ ಅದು 30 days ಮಾಡಿ. Disposed, yes.
101.
Charge sheet 506 ಹಾಕಿದೆ. The petitioner is before this court calling in question proceedings in CC 356 of 2024 registered for offence punishable under section 506 of the IPC. A crime had been registered. ಯಾವ್ದು 341 ಅಲ್ಲ?
ಹೌದು.
For offence punishable under section 447 and 506 of the IPC. The charge sheet comes down to offence punishable under section 506 without there being any ingredient that is necessary under section 503 of the IPC. Therefore, there shall be an interim order of stay till the disposal of the petition. 1 HCGP 2 emergent notice. Next.
102.
Petition. 354C, 5
Mobile ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ?
No, but that's if that is so, it's a.
You have destroyed the mobile.
1 moment.
201.
1 moment, kindly sir.
Yes, sir.
We filed a complaint as against the school saying that the encroachment is there. And the DC passed an order saying that my lord, it's a buffer, in the buffer zone, my lord, they put up a construction. That's why when the DC passed an order.
Drone ಯಾಕೆ ಸ್ಕೂಲ್ ಮೇಲೆ, ಅದು ಸ್ಕೂಲ್ ವಾಶ್ರೂಮ್ ಮೇಲೆ ಕಳಿಸಿದ್ರಿ?
That's it. They had up this story, my lord, because of
Story?
this, because of this reason. If that is so, my lord, the CCTV camera is there in that school. They are not at all recovered.
We'll get it. 1 HCGP 2 emergent notice. The learned HCGP is directed to secure the complete charge sheet material and place it before the court on the next date, 22nd, fresh matters.
Framing of charges, my lord.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ
It's we filed another, immediately after that, my lord.
ಡಿಸ್ಚಾರ್ಜ್ ಯಾವಾಗ ಆಗಿದ್ದ ಆರ್ಡರ್?
It's last month, my lord.
Last month, ಅಂದ್ರೆ ಇಲ್ಲ 22nd in the fresh matters list. Yes.
103.
Husband, no.
Husband ಇಲ್ಲ, only mother and sister.
ಅಷ್ಟೇನಾ? Yes. ಇದು ಇಬ್ಕಾಶ್ ಖಾನ್. Petitioners are A2 and A3. Mother and sister, mother-in-law and sister-in-law of the complainant, finding no allegations. ಅದು ಗೊತ್ತಲ್ಲ. Yes, next.
104.
For the petitioners, please, my lord.
Page 31 covered, is it?
Please, my lord, it is covered. It is covered by a lot decision also, but it was not, we had not got the copy, please.
All right, page 31. Yes, government ನೋಡಿದಿರಾ?
Yes, my lord.
Yes. 7980 KP Act. Andar, Bahar. Yes. Page 31, covered.
105.
ಗೊತ್ತಾದ ಹೆಂಗ್ ಮಾಡೋದು covered ಅಂದ್ರೆ? Both the learned counsel appearing to the petitioner would submit that the issue in the list stands answered by so and so. Yes. Any doubt, chamber? Yes, next.
It is allowed, please, ma'am.
Petitioner.
Driver or owner?
Drivers.
Emergent notice. 1 HCGP 2 emergent notice. No stay if it is driver. Yes, next.
Complaint itself is
No
disclosed 2 vehicles.
No
but
problem.
FIR and charge sheet against only
We'll
sole.
see. Dismiss ಮಾಡಿಲ್ಲಲ್ಲ. Next.
No license.
License ಇತ್ತಾ?
ಇಲ್ಲ.
License ಇತ್ತು, insurance ಇಲ್ಲ. Insurance.
ಮತ್ತೆ no stay at all. Yes, next.
106.
Petitioner, my lord.
NBW is issued against this accused on 4/6/24, my lord.
That's all right. Why have you not appeared, sir?
My lord, appeared, my lord. I filed discharge application also.
ಅದು ಗೊತ್ತು, discharge application is decided after 9 years of its filing.
Yes, my lord.
But why did you not appear before the court?
My lord, is continuously appeared, my lord, 18/5
No,
2020.
not a case for an interim order.
My lords, petition number 2 is a public servant, my lords. 127 protection is also available.
197, sir.
197, yes.
Yeah,
my lords.
127.
On 197. My lords, allegation against the both the petition is that, my lords.
Grama Sabha meeting,
Next, ಗೊತ್ತಾಯ್ತು. Next date ಏನ್ ಮೇಡಮ್? ಗೊತ್ತಾ?
1980 ಗಿದೆ.
1908.
Here, charges,
Appear and come.
charges ಗಿದೆ.
ಇರ್ಲಿ. Yes. Yes, sir.
Yes, continuously appeared, my lords. Yes, filed a discharge
Then
application.
why NBW?
No, my
When
lords,
did you file application for discharge?
LBW ಇಲ್ಲ ಸ್ವಾಮಿ. Kindly see.
Discharge application ಯಾವಾಗ ಹಾಕಿದ್ರಿ sir?
Applications filed a long back, my lords. In the
Long back ಅಂದ್ರೆ ಯಾವ long back? 1900?
No, my lords.
Year ಹೇಳಿ.
22, my lords.
ಹಾ, ಅಷ್ಟೇ.
My lords, there is no NBW, my lords. Kindly see page number 84.
4624.
Yes, check up. 1980 ga next.
1908, my lords. There is no NBW, my lord. Kindly see, my lord.
Not a case for interim order even otherwise. Yes. Will only issue notice.
My lords, petition number 2, my lords.
One, ಯಾಕೆ state party ಮಾಡಿಲ್ಲ?
Private complaint, my lords.
CC. One emergent notice returnable by the 4th of September.
Please, my lords.
Yes.
107.
Fake cash certificate.
Yes, my lordship.
Yes,
There
sir.
There is no document has been produced, my lordship.
What no document has been produced?
ನಾನು ಏನ್ as per the allegation, my lordship, fake
ಏನ್
document.
ಉಪಯೋಗ ತಗೊಂಡ್ರಿ fake cash certificate ಇಂದ?
ಬೋರ್ವೆಲ್ ನ ಕೊರ್ಸ್ಕೊಂಡು ಅಂತ ಅಲಿಗೇಷನ್ಸ್. ಅಂಬೇಡ್ಕರ್ ನಿಮ್ಮಿಂದ ಬೋರ್ವೆಲ್ ನ ಕೊರ್ಸ್ಕೊಂಡು ಅಂತ. But I already amount to pay ಮಾಡಿದ್ದು entire amount.
On fake cash certificate, why did you take it?
My lordship, I have not produced in the outlook. The witness has been stated, my lordship. Accused number 1 is created a document.
I submitted wrongly for the other previous case.
ಇದ್ರಲ್ಲಿ NBW
PW issue ಮಾಡಿದ್ರು.
ಅಪೇರ್ ಆಗಿ ಬನ್ನಿ.
ಅಲ್ಲ ಇನ್ನೂ ನಾವು ಅಪಿಯರ್ ಆಗಿದೆ.
ಆಗಿ.
ಆಲ್ರೆಡಿ ಕೋ ಅಕ್ಯೂಸ್ ಸ್ಟೇ ಆಗಿದೆ.
ಎಲ್ಲಿದೆ?
In the criminal petition number 13287 of 23.
13287
287 of 23. Produce ಮಾಡಿಲ್ಲ.
Where is the order?
Produce ಮಾಡಿಲ್ಲ.
Order ತಂದ್ಕೊಡಿ ಮಧ್ಯಾಹ್ನ. Yes, stay. Companion, Learned Counsel submits companion petition. There is already an interim order. ಅದು ಕಾಪಿ ತಂದ್ಕೊಟ್ಟ ಮೇಲೆ tag this petition along with source.
108.
Third offense is 420 of IPC.
Correct. ನೀವು ಸೇರ್ಬೇಕಾದ್ರೆ ಯಾಕೆ ಸುಳ್ಳು ಡೇಟ್ ಆಫ್ ಬರ್ತ್
I have not given any.
But not given.
Page.
Page is evidence, my lordship.
Huh?
124 ಗೆ suit summons issue ಆಗಿದೆ.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ?
ಏನಾಗಿದೆ?
3124 ಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ.
ಚಾರ್ಜ್ ಶೀಟ್.
ಚಾರ್ಜ್ ಶೀಟ್.
All right.
25 and 24 ಗೆ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡ್ತಾರೆ.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ ಅಪರ್ಚುನಿಟಿ
ನೀವು ಪರ್ಮಿಟ್ ಮಾಡಿರ್ತೀರಾ?
ಇಲ್ಲ. Kindly see.
HBC ಆಗೇ ಇಲ್ವಾ?
Kindly see.
HBC ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಅದನ್ನ
ಯಾಕೆ?
ಫರ್ ಚಾರ್ಜ್ ಅದನ್ನೇ ನಾನು ಇದು ಚಾರ್ಜ್ ಮಾಡ್ತೀನಿ. Page my lord 40. Kindly see page 40.
The petitioner secures employment as a Group D employee on an alleged wrong date of birth, which appears to have a difference of 4 years from the actual date of birth. Therefore, the crime comes to be registered on a complaint made by a co-employee in the year 2022. The learned HCGP on instructions would submit that the matter is at the stage of evidence, as summons is issued to CW 1 to 4 for appearance for the purpose of trial. The learned counsel for the petitioner, taking this court through the documents appended to the petition, would seek to demonstrate that the charge sheet was filed on 25/1/24 and the charges were framed on 25/4/24 without giving any opportunity, as there is no hearing before charge taken place. Only on the said submission, till the HCGP would verify and make submissions, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing. List on 10th September. ಅದು ಸುಳ್ಳಾಗಿದ್ರೆ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿ. ತೊಂದರೆ ಇಲ್ಲ ನೋಡ್ಲಿ. Yes, next.
109.
There is an interim order in the connected matter. My lord, I am accused
Could
of 4.
Connected matter ಎರಡು. Otherwise, all offences are found. How is it stayed?
SDA.
No problem, sir. We'll see, sir. Tag this petition along with criminal petition 6522 of 2024. List them both on 11th September. There shall be an interim order of stay in the light of the interim order subsisting in the companion petition. Next.
110.
In the meantime.
7.
Let's.
State, sir. Yes, sir.
111, I appear the petition, my lord.
111.
Yes, my lord.
Why are you on VC?
My lord,
Heard the learned counsel appearing for the petitioner. The petitioners institute suit in OS 318 of 2022, in which the concerned court grants temporary injunction against the complainant. Complainant. Immediately after the temporary injunction being granted, springs the impugned complaint for offense punishable under section 448 of the IPC. The complaint prima facie.
on submission, the complaint is, my lord, the suit is subsequent to the complaint.
All right, so and so. The issue being purely civil in nature is sought to be given a color of crime. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Then correction Martin. Yes.
112.
Accused number 3.
Loan granted on spurious gold. 112.
Please, my lord.
Your A3.
3, my lord.
Gold loan.
Please, my lord.
Correct.
Please.
ಮತ್ತೆ ನೀನು ಗೊತ್ತಿಲ್ದಂಗೆ ಹೇಳ್ತಾ. Allegation is spurious gold ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ.
Please, my lord.
Yes. The petitioner is alleged of pledging spurious gold and securing a loan. It is ununderstandable as to how the gold that was not spurious at the time of entry into the bank becomes spurious later. Therefore, there shall be an interim order of stay of further proceeding till the next date of hearing. Yes, next. KPID. Notice.
2020, he deposited the money according to.
We'll see.
Complaint is in the 2024, my lord.
Parvala. We'll hear the state. The learned HCGP is directed to accept notice for the respondent. Copy the madam. So and so. ಏನದು? Records ಇದೆಯಾ? ಕೊಟ್ಟಿರಿ. List on 22nd in the fresh matters list. Yes. ತಗೊಳ್ಳಿ ಫೈಲ್ ಹಾಕಿ. The learned counsel ಅದು ಬರ್ಕೊಂತೀರಿ ಮೇಡಮ್ ನೀವು? Yes, next.
114.
Charge frame ಆಗಿಲ್ವಾ?
ಇಲ್ಲ.
There shall be one HCGP 2 emergent notice. There shall be an interim order of stay only if charges are not framed as on today.
Please.
In the event charges are framed, the interim order would not operate.
Please.
Yes, next.
115.
Forest Act.
Well, in this case, my lord, accused number 3 as a
Sorry,
petitioner.
115. CC of 2018. What has happened?
My lord, and now the matter is posted for HPC.
Correct.
They stay in favor of accused number 1 and 2.
ಕೊಡಿ ನಂಬರ್ ಪೇಜ್ ಅದ್ಯಾಕೆ ಕನೆಕ್ಟ್ ಮಾಡಲ್ಲ?
ಇಲ್ಲ, actually, my lord, meanwhile,
ನಿಮ್ದಾ?
the interim order was, ಅಲ್ಲ, ನಮ್ದು.
ನಿಮ್ಮಿಂದ ಯಾರೋ ಇದ್ದಾರೆ ಅವ್ರದ ಅಂತ ಕೇಳಿ. ಕೊಡಿ.
Already I taken the printout from the system.
Tag this petition along with so and so. The learned counsel of the petitioner submits that there is an interim order operating quay so and so. Till the next date of operating so and so. Same. Quote the interim order, same interim. Next.
Great.
Please, my lord. Forest Act, my lord.
116.
Please, my lord. Forest Act, my lord.
Forest Act, will issue notice first.
My lord, this only comes if it's a forest, my lord. I have a judgment of the Honorable High Court itself saying it's squashed, my lord.
That let them.
I'll just point out, my lord. My lords, my kindly. see
ಇವತ್ತೇ stay
annexure-
ಕೊಡ್ಬೇಕು ಅಂತ
I'll annexure C, I'll just point out, my lord, because
Perfect.
there is an order where the range forest officer also made a party. And the
Alright.
orders and the order of the special district
Please.
calling my property.
List the matter on 21st in the fresh matters list.
My lord, the only issue is here, my lord. Vehicles are seized. These
ಈಗ
are all
ಹೇಳಿ
my laborers.
ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ?
These are my laborers.
ಹೇಳಿ ಬಂದಿದ್ದೀರಾ entry ಮಾಡಿ ತಗೊಂಡೇ ಬರ್ತೀನಿ.
ಅಲ್ಲ,
ಮತ್ತೆ
I'll just point out, my lord, because we already have benefit of an order.
vehicle is seized, is it?
Vehicle seized, everything seized. My lord.
When
These are my
were
laborers,
they
my lord.
seized? When were they seized?
As on the date of registration of affair itself. my lord.
Date, sir.
Date is on, my lord, 10th, 11/6/2024.
It's all right. ಒಂದು ವಾರ ಇನ್ನೂ ಇರಲಿ. List on, or I'll post it tomorrow before the other bench, you can try. ನಾಳೆ ಹಾಕ್ಲಾ?
My lord,
I'm not sitting tomorrow. We'll post it tomorrow if there is urgency.
Then, my lord, 21st itself, I'll take a chance.
List on 21st in the fresh matters.
Because it's not a forest, my lord, that's the
All
only
right.
issue.
Let the, yes.
Please.
117. Petitioner.
Identical orders we have granted in other cases. Number. Same. Now, ಕುಡಿಯೋದು. Madam tag. Next.
Please. 118.
Andar bahar.
79.
Seven-
Court by judgment. for
ಕೊಡಿ.
the-
Page number 148, my lord.
48 is coordinate bench.
ನಿಮ್ದಿದೆ
ಹೌದಾ?
lordship judgment, my lord.
48. Page 48 covered, both so and so. Disposed.
Then 19?
In the meantime, counter blast is in the meantime. Next,
120?
you're all siblings, all brothers,
No,
all the same partition. ಯಾರು ಹಾಕಿರೋದು ಮತ್ತೆ?
partition ಇವರೇ ಹಾಕಿದ್ದು.
ಯಾರು?
Petition
ಹಾ,
has filed a suit for partition.
correct.
Not on the basis of it is a joint family. There is a joint purchase by all the,
Joint purchase.
that is the allegation, contention in the suit.
The parties to the list are plaintiffs and defendants, or the other way in OS 1070 of 2023, which is pending adjudication before the concerned court. On the same set of facts springs the impugned complaint for it having been registered on 29/11/2023, ostensibly on after the registration of the suit between the parties. In that light, there shall be an interim order of stay of further proceedings in CC so and so till the next date of hearing. 1 HCGP 2 emergent notice. Next,
121?
87 Race Betting Act. Yes, sir. Permission ilva?
My lord, there is permission, but my lord, the permission is granted through permission letter. My lord,
Yenide letter? Where is the permission?
my lord, at page number, my lord, page number 62.
60?
62, my lord. Not the honorable magistrate grants permission, not captioned as permission letter. It's not in the order sheet. And
Not necessary. Hinge irbeku.
my lord, my lord, your lordship,
Any other grounds?
my lord, Karnataka Race Betting Act, my lord, there is no such act existence.
ಅದೇ ಯಾವ್ದು ಬ್ಯಾಕ್?
Check, my lord.
ಅದನ್ನ ಆಕ್ಟೇ
No
ನೋಡಿಲ್ಲ.
such act, my lord.
Karnataka Race Betting Act.
Race Betting Act.
Police themselves have evolved some act, is it? Race Betting Act.
I'll verify, my lord.
Even I verified. I could not find Race Betting Act.
FIR has registered.
ಅದಕ್ಕೆ
for-
ನಾನೇ ನಿಮಗೆ ಕೇಳೋಣ ಅಂತಿದ್ದೆ ಯಾವ್ದಿದೆ ಆಕ್ಟ್ ಅಂತ.
There is no such act in existence, my lord.
ನಿಮಗಾದ್ರೂ ಗೊತ್ತು? ಇಲ್ಲ. We will verify. Yes. List the matter on 3rd September in the fresh matters list. There shall be an interim order of stay of further proceedings, quay the petitioner till the next date of hearing.
Grateful.
After limitation,
Limitation.
what to- date of the search, fast, dates.
Date of the
Date of inspection, sir.
inspection is 15th February 2022.
ಆಮೇಲೆ
Uh,
registration.
Inspection was done in the year 15 February 2022. However, intimation of accident was given on 27/4/2021. After a lapse of 1 year and
23,
21.
date of 14, 2022 end date ಅದು.
2022 is the inspection date.
Date,
15th February 2022.
15/7/22, intimation,
15 February.
15/2/22.
Yes.
Intimation of accident.
Intimation of the accident 27/4/2021. Accident was intimated in the year 2000. Accident occurred on 26/4/2020.
What I'm asking, intimation is 14/7, crime is on 14/7/22?
26/4/2021 is the incident date, your lordship.
Yes.
Then subsequently, after 1 year, inspection was conducted, 15/2/2022.
All right.
Thereafter, show cause notice was issued on 8/4/2020.
ಅಷ್ಟೇ. The accident in the factory premises takes place on 24/1/2021. The inspection on the said accident takes place on 15/2/2022. And the crime is registered in the year 2024. At every step, there is gross delay and violation of the act. Beyond limitation, the complaint ought not to have been entertained by the concerned court. Therefore, there shall be an interim order of stay of further proceedings till the next date of hearing. Emergent notice to the respondents. Aste dates ಕೇಳಿ.
123?
No, similar matter is already stayed by the. your
ಕೊಡಿ ಯಾವ್ದು?
lordship. They
Tag
may
this
be
petition
connected.
along with
194/2022.
ಬರ್ಕೊಡಿ. Yes, tag this petition along with sounds. Next. 120. The petitioner is before this court calling in question proceedings arising pursuant to a private complaint registered. A perusal at the private complaint would not indicate its compliance with the judgment of the apex court, as there is no compliance of subsection 1 of section 154 or 154(3), nor there is an affidavit appended to the private complaint. Therefore, there is violation of the judgment of the apex court in the case of Babu Venkatesh versus State of Karnataka, 2022 SSC Online SC page 200. Therefore, there shall be an interim order of stay of further proceedings quay the petitioners till the next date of hearing. Yes.
Petitioner.
Husband,
What the husband, they accept all this, the family members, other
ಅಲ್ಲ,
than
ಈಗ ಹಸ್ಬೆಂಡ್ ಇಲ್ವಾ ಇಲ್ಲಿ?
husband, accused number 1.
ಅದೇ ಹೇಳಿದ್ದು ಮೇಡಮ್. ನೋ, accused number 1 is the husband. The remaining accused are all members of the family, against whom further proceedings, if permitted to continue, would run foul of the judgment of the apex court in so and so, as there are no ingredients that would touch upon the offences so alleged. Therefore, there shall be an interim order of stay quay all other members of the family except accused number 1, husband. Next.
25.
Petition.
They're all members of the same family.
Members of the same.
The complainant and the petitioners are siblings.
The complaint is a stranger, my lord.
ಒಂದು ನಿಮಿಷ, you are members of the family. ಎಲ್ಲ ಕೊಟ್ಟು
How members of the family?
ಯಾಕೆ stranger?
How is this third party, my lord, is not connected to
Sir,
this?
come to your cost title, sir.
ಹೌದು.
ಯಾರು ಹೇಳಿದ್ದು? ಯಾರು ಕಂಪ್ಲೇಂಟ್ ನೋಡಿ ಅಲ್ಲಿ?
No, different by.
ಸರ್, ಸನ್ ಆಫ್ ಸಂಜೀವ್ ಕೊಟ್ಟಾರಿ.
ಅಲ್ಲ,
ನೀವು ಫಸ್ಟ್ ಪೆಟಿಷನರ್ ಸನ್ ಆಫ್ ಸಂಜೀವ್ ಕೊಟ್ಟಾರಿ. ಸ್ಟ್ರೇಂಜರ್ ಅಂತ ಹೆಂಗಂದ್ರಿ? ಇದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು. ಯು ಕನ್ಸಿಡರಿಂಗ್ ಹಿಮ್ ಸ್ಟ್ರೇಂಜರ್, ಅದಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್. ಚೇತನ್ ಬಿ ಯಾವ್ದು ನೋಡಿ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡಲ್ಲ ಅದಕ್ಕೆ.
Defendant number, here in the case, my lord, suit was filed by
We
family.
will grant stay, but ನೀವು ರಿಲೇಶನ್ಶಿಪ್ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೇ ಕೊಡಲ್ಲ.
Please.
How did you call him a stranger? He is your brother. Brother ಹೌದು ಅಲ್ವ?
It is alleged that my lord.
Brother ಹೌದು ಅಲ್ವ? You are son of Sanjeev Kottari. Complainant is also son of Sanjeev Kottari, not brother.
Partition. Partition deed ಆಗಿದೆ.
Correct, sir.
Please.
Yes. The petitioners and the complainant are siblings. They are in dispute with regard to their partition in OS 417 of 2023. Despite the pendency of the proceedings before the concerned court instituted by the second respondent complainant, the criminal law is set into motion on the same cause of action. Therefore, there shall be an interim order of stay of further proceedings quay the petitioners till the next date of hearing.
Good.
Next,
126.
section 80,
Yes.
KP Act. ಕೊಡಿಯದು. So and so, madam, covered judgment. Yes, next.
Petitioner.
ಕಾವ್ಯ ತಗೊಳ್ಳಿ. ಕಾವ್ಯ ಕಾಶ್ಖಾನ್. 127.
Please.
A2 and A3. A1 no.
Against the husband, just one submission.
Ah.
Page 41 may be seen. All the allegations say that right after marriage in 2020, all the harassment has taken place, demand for dowry has taken place. But page 41, she herself in her MC petition, as well as a maintenance petition which I have appended, she says that I didn't get visa till 2021. So.
Barley, let husband come. Yes, let the wife come. A2 and A3, Kashkan. One, accused number 1, husband.
Good.
Yes, next.
128.
Please, my lord. So petitioner is the sole accused, please,
petitioners
my lord.
And the complainant are before the concerned court in commercial OS 501 of 2024, which forms the subject matter of the impugned complaint as well for offences under section 406 and 420 of the IPC. In the light of the parties before the concerned court in commercial OS, there shall be an interim order of stay of further proceedings quay the petitioners till the next.
Investigation, I have sought for investigation, please, my lord. FIR has been registered, please, my lord. Matter has been directed under 156(3) of CRPC, please, my lord. So though cause of action was arisen only in Bangalore, my lord, they have chosen Nelmangala. And none of the parties are staying and no such transaction has taken place within the.
ಕೇಳಿಲ್ವ ನೀವು?
ಕೇಳಿದ್ದೀನಿ, stay of investigation, because now the matter has been referred to.
ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ದೀಗ.
Please, my lord.
Yes.
Oblige, my lord.
ಅದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ / ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲದರಲ್ಲೂ ಬರುತ್ತೆ.
Please, please.
Yes, next.
Petitioner,
see, confession statement, let the,
my lordship, there is no documents, my lordship.
we'll see.
Except confection.
One, learned HCGP is directed to accept notice for the respondent. The primary submission of the petitioner is that the petitioner is arrayed into the web of crime on account of a confession statement made by the co-accused, i.e. accused number 1. Therefore, the learned HCGP is directed to go through the papers, make her submission on the next date, list on 21st in the fresh matters list. We'll see. Next.
130.
Petitioner is arraigned as accused number 3, my lord. Offenses 419, 420, 464.
Fake railway recruitment.
First year crime number 638 of 21 crime ಆಗುತ್ತೆ ಅದಾದ on the very same day 11:30 ಲಿ crime number
Parvala, we'll see.
crime number 9
Whoever has suffered has registered separate crimes, sir, we'll see, yes.
also till date they have not
Fake
filed,
railway
any
recruitment.
charge sheet.
Adu ನೋಡ್, this is recruitment scam.
ಮತ್ತೆ ನಮ್ಮೂರ್ ಕಡೆಯಿಂದಾನು
One
seize ಆಗಿದೆ.
HCGP, 2 emergent notice.
31.
Pendency of this petition will not come in the way of further investigation. Yes.
Please.
This already framed this case, but the summons also issued to the witnesses. My lord.
Correct, sir.
I sought for a direction to expedite the trial.
You are sensible. Page 29, all, everything is met. Caution ಕೇಳಿದ್ದೀರಾ?
Yes, my lord,
Will not grant.
but I am seeking a direction to expedite the trial. My lord.
2022 CC, sir. How can we force the court?
Already twice summons issued, but they are not turned up. Summons witnesses.
9
Therefore,
months?
I'm
9 months.
6 months. My lord.
Ah.
6 months. My lord, at least.
9 months, if not early arrest.
6
The
months. My lord.
petitioner, though, has called in question
6 months. My lord.
the proceedings in CC 22155 of 2022. The learned counsel would restrict his submission for a direction for a speedy disposal of the case before the concerned court.
Witnesses are well less. My lord.
No?
ಕಡಿಮೆ witnesses ಇದ್ದಾರೆ.
And
6
so and
months.
so, since the offences are the ones punishable under 323, 324 and 550, 354 of the IPC, the concerned court shall endeavor to conclude the proceedings within 6 months from the date of receipt of the copy of the order,
Applies.
ordered according. Yes, next.
132.
Lords, the petitioner number 1 and the complainant are both doctors, my lord. They have been in a live-in relationship together for 2 years almost, my lord. Petitioner number 2 and 3 are parents of the petitioner number 1, my lord. They reside.
Were you married earlier?
It was,
Were you married earlier before entering into a relationship with the complainant?
yes, my lord, it was also told to the complainant, and I have produced various even chats with regarding to that, which shows that she knew that the divorce petition was pending before the court.
Divorce had not been granted.
Yeah, not yet being granted, my lord.
Is it granted today?
No, no,
Still pending.
still pending, my lord. Since the date.
2 and 3 we will grant stay, not accused number 1.
My lord, I would like to make a
No.
submission. It seems she has expressed her interest to settle the matter. She is asking for
Stay order.
no, my lord.
ಮತ್ತೆ?
She has asked that if her loan dues are settled, she is ready to settle the matter.
What is that amount?
She has asked for some 10 lakhs, my lord. Even the petition number 1 is
All
thinking
right.
about it.
Issue
She-
notice.
At least a date, stay
Date I
may
will
be
give.
granted, my lord.
Date I will give.
My lord,
Husband, I will not
almost
stay.
2.5 years they were in a live-in relationship
Maybe.
together.
On a false premise.
My lord, you can peruse the complaint, my lord.
We'll see.
Section, I mean, page
2 and
30
3 I will stay, madam.
My lord, page 35 ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಎಲ್ಲಾ ಸಂಬಂಧಿಕರ ಜೊತೆ ಚರ್ಚಿಸಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ that it is abuse of process of law.
Why? Complaint ಕೊಡೋದು abusive process.
No, my lord.
But ನೀವು ಮಾಡಿರೋದು after marriage?
It was within her
That
knowledge.
we'll
my
see.
lord.
Let the wife,
It is-
let the lady come.
At least a date and day may given in September. She intends to settle the matter.
All right. No, not till. Husband, I will not grant.
Yes, ma'am. At the-
He will
at the
never
date
come
may be.
to settle the matter if stay is granted. The allegation in the case at hand is are the ones punishable under so and so. For a relationship between the accused number 1 and the complainant, complainant, the parents are dragged into the web of crime. Therefore, there shall be an interim order of stay, accused number 2 and 3 till the next date of hearing. 1 HCGP, 2 emergent notice, 12th September.
That's your grace.
Yes.
133.
269 and 270 FIR and 80 of KPMs. These petitioners are accused number 1 to 5. ಕೋವಿಡ್ ಟೈಮ್ ಅಲ್ಲಿ ಓಡಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ
ಪೇಜ್ 43 ಬನ್ನಿ. Yes.
But they are, so there is no material with regard to this.
That we'll see. One HCGP. Ibrigu HCGP, pendency of this, yes, will not come in the way of further proceedings. Yes, next.
134.
Petitioners, my lord. Offenses under section 498A.
The petitioners are accused. ಯಾವ accused ನೀವು?
A1 and A2, my lord.
Petitioners are accused 1 and 2.
Sorry, my lord.
Having been,
I'm not the.
ನಿಮ್ದಲ್ವಾ ಇದು?
Serial number 144, sorry.
140
144.
ಇದ್ಯಾವುದು?
134.
134 ಯಾರಿಲ್ವಾ? TK Rajgopal. No representation. List of 2 weeks.
135.
Of petitioner.
MMDR. List on 21st in the fresh matters list. A learned HCGP is directed to secure instructions, go through the papers and make submissions. Next.
136.
A2 and A3. Okay. Kashkan. Father-in-law and the mother-in-law. So on. Next.
137.
Lord, I prefer the petitioners, Lord. Lord, petitions are trustees of the, my lord, family trust. They have not removed from the trust against which, my lord, a suit is filed before the judicial court, Lord, page number 129.
Page 29.
129,
Page 29.
please. This is the charge sheet, my lord. I just read the,
ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ.
no, I'll not say so.
Wound certificate is simple in nature. That's a
I'll
different
just
thing. But
point
you
out-
say no allegations.
No, I did not mean that there's no allegations. Lord, after 1 year of the, my lord, the suit being pending, Lord, they approached the police. Lord, the very police issues NCR. They don't register. Lord, thereafter they approaches the jurisdiction court by filing private complaint. Lord, complaint is referred as
So
156.
police ಒಂದ್ಸರಿ NCR issue ಮಾಡಿದ್ರೆ
No, I don't say though. The very same officer,
Anything more
my lord, the very same police, my lord, they say that there's no crime. Thereafter, my lord, my lord, when the matter is referred to them, they file a charge sheet. Lord, kindly turn to, my lord, page number, the wound certificate, my lord.
that is simple, sir.
So, my lord, I would say that
307 ಗೆ not a big case, but other.
what I would respectfully submit that, Lord, once a civil suit is pending, calling in question the termination from them or the
That is not a
services.
license to assault.
No, they did not assault that. Kindly see the weapon used by them, Lord. Kindly see them. I would have not troubled my lords if not scared. Kindly turn to the Lord the wound certificate there.
ಏನ್ weapon?
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು unknown weapon ಅಂತಾರೆ. Kindly turn, Lord.
You use something that cannot be identified, sir, unknown.
No,
weapon.
kindly appreciate this fact. What I would respectfully submit that, Lord, since the matter being a civil nature, Lord, they have not filed a private complaint. The very police officer, Lord, after investigation.
ಮತ್ತೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. You
I
already.
just,
you have told
the
it
reason to
once.
mention that is that the offense under section 307 is not made out. That too, my lord, when the suit is pending for, Lord, a scheme suit is pending, as a counterblast, not Lord, the private complaint is filed. Lord, she being the sister of the complainant, brother, there's intrinsic dispute between them. That they, without Lord following due process, he has removed her from the service, the trust. Now, my lord, to see that, Lord, they would succumb to his demands and, my lord, walk away from the trust. Now, this private complaint is filed. It is, Lord, sheer abuse of process of law. I would, all that I would request that, Lord, she being a lady, a sister of the complainant, Lord, he cannot abuse the process of law by this, my lord, this, making this false complaint. Currently, my lord, I would, again, my lord, impress upon my lord to see the complaint.
Not impressed.
I just, one point, if to attract negligence in section 307, not a weapon to be used, and the injury should be to vital part that would cause, Lord, death.
307 case is bleak, that I can say.
So, my lord, this
But
is what
others-
I would just, my lord,
Not with regard to other offenses.
kindly, my lord, now, my lord, the.
Heard the learned counsel so and so. A perusal at the summary of the charge sheet as obtained in column number 17 would indicate no foundation laid for the offense punishable under section 307 of the IPC. A further perusal at the wound certificate would also indicate that the wounds inflicted are simple in nature, for which section 307, simple in nature. The material used, material object used for inflicting such wound is depicted to be quote unquote unknown. Therefore, there shall be an interim order of stay of the offense punishable under section 307 only. One HCGP, 2 emergent notice. Okay, ಆಮೇಲೆ ನೋಡೋಣ. Please, yes. Committal ಆಗಲ್ಲ. ಒಳ್ಳೆ.
Commit
Yes,
ಆಗಿದೆ.
next. ಆಗೋಗಿದ್ಯಾ?
ಆಗಿದೆ.
ಇರ್ಲಿ ತೊಂದ್ರೆ ಇಲ್ಲ.
Charges ಇದೆ.
Quash ಆದ್ರೆ ವಾಪಸ್ ಬನ್ನಿ. Yes.
Your Lordship, serial number 138.
A2 498A Kashkan. Next.
Manual stay, Your Lord. My lord, for the petitioner in this case, my lord. My lord, the petitioner is the plantation owner, my lord, wherein, my lord, the respondent number 2 is the uncle of the victim. My lord, it is the allegation made in the complaint, my lord. Your lordship may kindly come to
The
page.
petitioner is alleged of offense punishable under section 337 of the IPC. The second respondent's relative suffers an accident while he was lifting the
Bag,
coffee
sir.
bag. There cannot be negligence alleged against against the owner of the plantation for the employee unable to lift the bag on his employment. Therefore, there shall be an interim order of stay of so and so till the next date of hearing. Next.
Please, my lord.
Petitioner in this case. Offenses are under 419 and 420. my lord. Offenses are under 419.
What kind of fish?
Sorry, my lord.
ಇದೆ ಇರ್ತಾನೆ?
140, my lord. Serial number 140.
140. Defreezing.
Yes, my lord.
Huh.
My lord, if your lordship could see, there are 2 complaints. One is filed in
We'll
Bangalore.
see, let the instructions come. Learned HCGP is directed to secure instructions and make submissions with regard to the reason for freezement of the account of the petitioner by the next date of hearing, list on 21st in the fresh matters list.
Grateful.
Yes, next.
41.
ಬೇರೆ ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ ಯಾವತ್ತದು?
ಅದು ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಕೊಡಿ.
21. Not this, covered by your lordship judgment.
ಕವರ್ಡ್ ಅಲ್ಲ,
ಹೌದು.
ನಾನು ಕೇಳಿದ್ದು ಇನ್ನೊಂದು ಕೇಸ್ ಯಾವತ್ತು
ಅದು
ಯಾವ್ದು?
21 ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
23 ಮೇನ.
ಅದ್ರ ಜೊತೆಗೆ ತಗೊಳ್ಳುವ. 9B ತಾನೆ?
ಎಸ್
ಎಸ್.
9B ಮೇಲೆ ಇಟ್ ಕವರ್ಡ್ ಬೈ
ಆಯ್ತು ಸರಿ, ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. ಅದು ಮಧ್ಯಾಹ್ನ ರೀಚ್ ಆಗುತ್ತೆ.
ಆಯ್ತು.
42.
Poxo after marriage.
After marriage, okay. Now they are living together, my lord, they have a small
Charges are
kid.
framed, my lord.
That's all right, madam. There is a problem with ground reality. The parents have got them married.
17 years.
And,
Plus 17 years. It is, the contention is that personal law permits, that I will not agree. Poxo is Poxo for everybody.
Now the
But
problem is,
personal law permitting cannot override the general laws, sir, here.
my lord, the
Penal law
reality
cannot
is
be
that, my
overridden
lord,
like that.
they are living together,
That
not
will-
having a small kid.
ಅದನ್ನ
Now
consider
if
ಮಾಡಿ.
the trial is permitted to be continued, it would affect the child.
Him there. ಏನ್ ಸೆಟಲ್ ಮಾಡ್ಕೊಂತ ಇದ್ದಾರೆ?
Settle.
No, you should, there's a child, custody ಇದ್ದೀರಾ?
ಇಲ್ಲ, he is on bail.
Learned HCGP is directed to accept notice for the first respondent. Counsel so and so undertakes to enter appearance for the second respondent. List the matter on 23rd in the fresh matters list. Till such time, further proceedings before the concerned court shall remain stayed.
143.
Lordship, petition filed by the petitioner wives, accused number 2 arraigned as an accused number 2 for offense under section 324, 504 and 509 of IPC. So the facts alleged as per the.
Which is your complaint?
My complaint is 249 of 23, your lordship, that is at.
Which is the impugned complaint?
Impugned complaint is 250, your lordship.
ಅದರಲ್ಲಿ 354 ಎಲ್ಲ ಡ್ರಾಪ್ ಮಾಡಿದ್ರಾ?
354 ಎಲ್ಲ draw ಇದ್ ಮಾಡಿದ್ದಾರೆ. I have filed a protest petition also, your lordship, it's pending before consideration for the appropriate court.
One HCGP, 2 emergent notice in the meantime.
Your lordship, I'm for the interim order may be
Granted.
your lordship. because I'm for-
Granted, sir.
44.
Much obliged.
A2 and A3. ಏನೂ ಇಲ್ಲ. ಬನ್ನಿ ಸರ್.
Section 498A.
498 is
Petitioner are the parents of the accused number
correct,
one.
sir.
Please.
No problem. Come to page 16, sir. Sorry, 17, 16 and 17. Complaint.
Complaints.
ಎಲ್ಲ allegations A2 and A3 ಮೇಲೆ ಇರೋದು.
Lordship, it is a false complaint.
Ah,
lodged by the
ಅದು ಆಮೇಲೆ.
de facto complaint.
Oh, no. ಇನ್ನು ಮದರ್ ಇನ್ ಲಾ ಫಾದರ್ ಇನ್ ಲಾ ಅಂದ ತಕ್ಷಣ ಕೊಡಲ್ಲ. ಎಲ್ಲ allegations ಇದೆ.
There is no material on the. lordship.
We'll see the material. One HCGP, 2 emergent notice. The learned HCGP is directed to secure and place on record place on record
The one submission.
investigation papers for the
petition,
next date of hearing.
The petition number one is partially blind. In that regard, I produce the.
ನಮಗ್ ಗೊತ್ತಿಲ್ಲ,
medical-
ಬರ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಬರ್ಲಿ. ಬೇಲ್ ಗ್ರಾಂಟೆಡ್ ತಾನೆ?
Please.
ಪರವಾಗಿಲ್ಲ, ಇರಿ. ಎಸ್. ನೆಕ್ಸ್ಟ್
145.
ಪ್ಯೂರ್ ಕಾಶ್ ಖಾನ್, ನೋ ಅಲಿಗೇಷನ್ಸ್.
For the petitioners, my lord.
Hmm.
145.
Hmm.
Petition number 1, my lord, is a sister who's residing in
all
Bangalore. She's
right,
the practicing advocate. From the year
ಇವ್
2006.
ಆಲ್ ಸ್ಟೇ ಅಲೋ ಮಾಡ್ಬೇಕಾ ಈಗಲೇ?
ಇಲ್ಲ.
ಮತ್ತೆ ಸ್ಟೇ ಕೊಟ್ಟು ಆಯ್ತು ಮೇಡಮ್, ಪ್ಲೀಸ್. ನೆಕ್ಸ್ಟ್
46.
heard the learned counsel so and so. A release deed is executed by the complainant on 30th March 2011. And on the same set of facts, a regular first appeal, the dispute has reached this court in regular first appeal 1099 of 2023. 12 years thereafter, the complainant registers the impugned complaint on the score that the release deed executed by them, they were not aware of the release deed executed by them. Therefore, there shall be an interim order of stay of further proceedings square the petitioners till the next date of hearing. Anything else? Next.
Pleasure.
A3, A4, Kashkan. A234, next. Jagan, over, stayed, next.
48.
Madam, 147 and A23 and 4, Kashkan.
My lord, complainant has filed private complaint, my lord. Trial court rejected the application on the ground that he has not followed the Priyanka Srivastava complaint and affidavit not filed. I have filed, spread the documents.
ಹಾಕಿದ್ದೀರಾ?
In
ಅಲ್ಲೇ
spite of the
ಹಾಕ್ಲಿಲ್ಲ?
mark ಆಗಿದೆ, ಎವಿಡೆನ್ಸ್ ಓನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಇಲ್ಲಿ ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
ಅಲ್ಲ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಸಿಕ್ಕಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದೀನಿ.
ಇರ್ಲಿ, 20th in the fresh matters list. Yes.
49.
This case I pay for the petition.
140? ಲೀಲಾಧರ್ ಅವ್ರು ನಿಮ್ದಲ್ಲ.
Sorry.
Unless you're his colleague.
What happened?
Leeladhar sir, page 33, all offences met.
One thing.
One
What
thing,
something.
something.
What 53, you are also same, another counter complaint, this honorable court has been stayed in.
Yes.
58, 68, your
Page.
68, your CC number for 80/2024, this honorable.
Kavya, tagged, page 68. Quote the interim order.
Much.
Copy next week.
And call with both the cases ಅಂದ್ರೆ ಒಳ್ಳೆದು.
ಎಲ್ಲ ಮಾಡ್ತಾರೆ.
Nice.
Tag.
Much.
50.
Submission, previous matter 21 ಹಾಕಲಿ sir, 20 ಇಲ್ಲ.
20 ಆಯ್ತು. 20 in the fresh matter. 20 ಹೇಳಿದ್ ನಾನು.
21 ಗೆ.
21 ಬೇಕಾ? ಯಾಕೆ ನೀವು ಇರಲ್ವಾ? ನಿಮ್ ಕ್ಯಾಲೆಂಡರ್ ನೋಡಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. 21, I'll write, yes. Serial number?
Promised to 150 Marash.
150?
150 Marash. Promised to
The
marry Marash.
petitioner and the respondent complainant, accused number 1, sorry. The accused number 1 and the respondent complainant appear to have begun their relationship in the 8 years prior to the registration of the complaint. The talks of marriage also took place between the parties. It was the accused number 2 and 3, the petitioners also got involved in the talks of marriage. It did not fructify into marriage. Therefore, the offense under section 376 of the IPC and 417. In the teeth of the aforesaid facts, if further proceedings are permitted to continue, it would run foul of the judgment of the apex court in the case of Naeem Ahmad versus so and so, 2023 SEC online SC page 89. Therefore, there shall be an interim order of stay of further proceedings till the next date of hearing. 1 HCGP 2 emergent notice. Next.
Date may be fixed, Marash. My lordship, date may be fixed.
ಸಾಕು ಸ್ಟೇ ತಗೊಂಡ್ಮೇಲೆ ಡೇಟ್ ಬೇರೆ. Seriously? Good.
Date may be fixed.
List on 24th September. Working Saturday. Yes. Lokesh, Kashta, page 48, 49.
I'll only refer to email
August,
dated
August 24th. ಬೇಡ ಹಂಗಾರೆ.
page 83 minutes. In email as well. In fact, the day one, it was absolutely, she has admitted that there was no sexual harassment or mental harassment. Page 83 for a moment, my lord.
Come to page 49, second paragraph, unnumbered.
Shakshi number 1.
All offenses are there.
Lordship may kindly come to one. It's just a professional level.
Page.
Page 65, the email trials will start. This is prior to 3 months before registering of
All
FIR.
right.
I'll only take your lordships to page 67. From Deepa, the complainant first sends a mail to our posh head, Dr. Nupur, dear Nupur.
ಅಲ್ಲ ಪಾಶ್ ಕಮಿಟಿ ಮುಂದೆ ಏನಾಗಿದೆ?
Posh committee, she did not lodge any complaint before posh committee. She did not go even before.
That is
posh-
not a prerequisite for 354.
Absolutely, it's a prerequisite. madam.
It is not a prerequisite. I have myself held, ಮೊನ್ನೆ pronounce ಮಾಡಿದ್ದೀನಿ.
In the mean, for a moment, dear Nupur, only one email trial between the posh head. The complaint was not, the company deployed posh head to deal with her. Page 67 minutes. Initially, she will send a mail. Other matters to be discussed and was closed in December. For the volume scope of your gig is not applicable. Same was discussed with you. For point 2345, sexual harassment, torturing, no respect. We both have detailed one-to-one discussions in the first week of December 2023, and same was not found true. And it was observed that the hostile environment was created because of your non-performance and behavior. For this, she replies, she does not even dispute this fact.
The 1 HCGP 2 emergent notice. A perusal at the email trail which the learned counsel for the petitioner takes this court through would
Annexed
indicate that the allegation of sexual harassment has sprung from the termination of the complainant.
No, my lord, this was sprung from because work pressure, work pressure was created.
And work pressure of the complainant.
Later, she was transferred to Pune.
Learned counsel submits that the complainant has not complained before the posh committee with regard to any sexual harassment. Though that is not a prerequisite for registration of a crime under section 354A, till the appearance of the respondent complainant, there shall be an interim order of stay of further proceedings qua these petitioners. Emergent note 1 HCGP 2 emergent notice returnable by 11th September till 11th September. ನೀವು ಆ ಕೋರ್ಟ್ ಬಿಟ್ಟು ಈ ಕೋರ್ಟಿಗೆ ಬಂದಿದ್ದೀರಾ? Yes.
152.
My lord, for the petitioner.
Only atrocity we will stay. ಬೇರೆದಕ್ಕೆಲ್ಲ ಇಲ್ಲ. Yes. 1 HCGP 2 emergent notice. A perusal at the summary of the charge sheet as obtaining in Soren's column number 17 would indicate no speck of foundation being laid for offense punishable under section under the provisions of the Atrocities Act. Above all, it appears the dispute pending between the two is sought to be rendered with the color of atrocity. Therefore, there shall be an interim order of stay only insofar as the allegations pertaining to the Atrocities Act are concerned. 1 HCGP 2 emergent notice.
153.
Pass over ಏನಿಲ್ಲ ಅದ್ರಲ್ಲಿ. Page 26 ಅಲ್ಲಿ all offenses met. Senior ಬಂದ್ರು notice.
No, my lord. Kindly pass over, my lord.
Passed over by 1 week. List on 20th.
My lord.
The fresh matters list. Next.
150.
My lord, I will argue the matter. Yes. My lord, page number 20, my lord. My lord, my lord, so many litigation is pending against the petitioners and the respondent number 2. My lord, what happened is, my lord.
That does not mean that you have a license for all this.
No, my lord, even my lord, the specific court act is alleged against the first petitioner. My lord, all of the petitioner, my lord, there is no allegation in the charge sheet or the complaint. My lord, entire material in the
We'll
charge
take-
sheet, my lord,
we'll
is
take
silent
it on-
against the
we'll-
other petitioners.
List on 21st in the fresh matters list.
My
Next.
lord,
ಯಾಕೇನು ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
in the meantime.
ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
Bail bond.
ಹಾ. Next is
54.
Get
For the petitioner, my lord.
In the meantime, next.
Non-cognizable offense.
55.
The crime is registered on 15/7/2024. The learned HCGP is directed to secure the investigation papers and place it before the court on the next date of hearing, list on 21st in the fresh matters. Next.
156.
It is directed to place the record material.
Yes, BDA. Yeah. Yes, madam.
Records are there, my lord.
After filing charge sheet against A1 to 25, after taking custody of petitioner, no investigation is done, my lord.
Let us see. Kodiyat. List on 20th in the fresh matter. Where are the records?
Records.
So, ಅಷ್ಟೊಂದಿದೆಯಾ?
Filed against 1 to 25, not against supplementary charge sheet ಅಥವಾ ಏನು ಮಾಡಿಲ್ಲ.
No, no, let's see. Kodiyat. List on sounds. List on 21st in the fresh matters list. Yes, next.
157.
Till then, my lord, proceedings against.
ಅವತ್ ನೋಡುವ. ಯಾರಿದು? ಶ್ರೀಕಾಂತ್.
14%. R. Srikanth.
I'm not feeling well today. I pray for time.
Case is also ill, sir. It is also not feeling well.
Pray time.
Allegation, wife had filed, you had filed, what is this? Assets and liabilities. Wrong.
Wrong.
Why did you file?
No, I have not filed.
Then
Wrong.
who has filed?
Respondent wife has filed. And in the connected matter, there is a stay from the Honorable Apex Court. My lord.
Apex Court. Right. Learned counsel, but the petitioner in person submits that he is indisposed today. When do you want, sir?
For 2 weeks. My lord.
After 2 weeks. List the matter after 3 weeks. You get well completely. Next.
58.
Yes, something for the petitioner. This honorable court granted on
The
10/7/2020.
earlier order.
Is appear before this honorable court.
Shanti Bhushan.
I don't have a copy.
Yes, sir.
This came from Israel, my lord. He's
Huh?
come before this honorable court. As per the direction of this honorable court, he's appear before the trial court also.
Appeared, huh?
Appeared.
Where is the order sheet?
Order sheet, sir.
Wanted to come. Please come.
On 5/8/2024, he's appeared before the trial.
When did you come back from Israel?
On second, my lord. Second act of August 2020.
Please come back.
He has come back.
NBW is suspended for 4 weeks, my lord.
We will suspend it further, 498A.
Yes, my lordship. Mali's prosecution in this matter,
Ah.
the allegations in Ennur police station, she lodged a complaint in Vijayanagara police station.
ಅದು ನೋಡೋಣ ಆಮೇಲೆ.
Even in the meanwhile, there is a party one notice and all. In his absence, they file a FIR and file a charge sheet and all, my lord.
FIR ಗೆ ನಿಮ್ಗೆ ಕೇಳ್ಬಿಟ್ಟು ಫೈಲ್ ಮಾಡ್ಬೇಕಾ?
Alla, there is no allegation against.
That we'll see.
In that time, he is not in India, my lord.
The pursuant to the order passed by this court on 10/7/2024, the petitioner flies back from Israel and has attended the court proceedings. A perusal at the offenses, ingredients of the offenses alleged against the petitioner would clearly indicate his absence throughout the period of the allegations that are so laid. Therefore, till the appearance of the wife, there shall be an interim order of stay.
No, my lord. I am appearing.
ಇಲ್ಲೇ ಇದ್ದೀರಾ?
Yes, my lord.
ಹೇಳಿ sir.
I am for respond number 5, my lord. My lord, this is the second marriage to the petitioner, my lord. First marriage was ended with the allegation that, my lord, there is a disability of impotency, my lord. This fact was suppressed by the petitioner and the family member, my lord. Second marriage was arranged, my lord.
Where is that? Where is the finding of that kind?
It is a serious allegation,
There is
my lordship. There is no any proof of a document for impotence.
ಅದಕ್ಕೆ ಯಾವ ಪ್ರೂಫ್ ಸಿಗುತ್ತೆ?
Alla, we ready for the medical test also, my lord.
Wait, sir.
Simply they mentioned in the complaint and all.
Where is the annulment of marriage first?
Please, my lord.
Proceedings ಅಲ್ಲಿ.
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೇವೆ.
Is there a finding to that effect?
No, my lord.
ಮತ್ತೆ?
In the meanwhile, my lordship, the WhatsApp messages are there, my lord.
ಏನು?
ಅಂದ್ರೆ ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಮ್ಯಾರೇಜ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು ಬರೋದಿಲ್ಲ ಇಸ್ರೇಲ್ಗೆ, ಡ್ರಾಪ್ ಮಾಡಿ ಅಂತ. ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 43, my lord, annexure E. All WhatsApp messages are there. The serious allegation in the complaint, there is no importance and all in this matter.
ಫಸ್ಟ್ ಮ್ಯಾರೇಜ್ ಅಲ್ಲೂ ಡೈವರ್ಸ್ ಆಗಿದೆ ವೆರಿ ಸೇಮ್ ರೀಸನ್ ಇಂದ.
ಅಲ್ಲ ಅದನ್ನ
ಇಲ್ಲಿದೆ,
ಹೇಳೇ
ಕೇಳ್ತಾ
ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ
ಅದನ್ನೇ ನಾನು
ಅದನ್ನ ಹೇಳೇ ಮಾಡ್ಕೊಂಡಿದೀವಿ ನಾವು.
ಆರ್ಡರ್ ತೋರಿಸ್ಬಿಟ್ಟು ಮಾಡ್ಕೊಂಡ್ರಾ?
ಹೇಳಿದೀವಿ ಸ್ವಾಮಿ, ಹೌದು.
ಡೈವರ್ಸ್
ಡೈವರ್ಸ್ ಕಾಪಿ ತೋರಿಸಿ ಹೇಳಿದೀವಿ.
ಎಲ್ಲಿದೆ?
ಡೈವರ್ಸ್ ಕಾಪಿ ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್ ಹಾಕಿ ಅವರು
ಹೌದು
ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್.
ಹೌದು
ಹೌದು
first
ಮ್ಯೂಚುವಲ್
marriage.
ಕನ್ಸೆಂಟ್ ಆಗಿ ಹೇಳಿದೀವಿ ಅವ್ರಿಗೆ. Subsequently,
ಅದರದ್ದು ಡೈವರ್ಸ್, ವೇರ್ ಇಸ್ ದಿ ಪ್ಲೇಂಟ್? Who had filed for divorce?
Petitioner as well, petitioner and first wife, my lord.
Where are those documents?
I will produce it.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ಹಾಗಾದ್ರೆ ಏನು ಬೇಡ, ಅದು ಫಸ್ಟ್ ಮಾಡಿ. Has fled, come from Israel and has participated in the trial proceedings. Therefore, warrant of any kind hanging on the head of the petitioner shall remain stayed. The learned counsel appearing for the respondent complainant submits that the petitioner, the complainant wife is second in line to the first petitioner, to the accused number one. It has happened after the annulment of marriage with the first wife. The learned counsel submits the annulment of marriage has happened due to the impotency of the petition accused number one, which is seriously disputed by the learned counsel appearing for the petitioner. Therefore, the parties to the list to produce the proceedings that led to annulment of marriage from the plaint till the order by the next date of hearing. Yes. Next. Date 24th September.
129.
In this case, I appear for the petition.
Forest.
Yes,
My lord, a week's time may be given.
There will say, my lord, they're calling the people, my lord,
Calling people.
calling petitioner, my lord, for appearance of the notice.
Submit the report.
Right from all the documents says it's a revenue land, my lord.
ಅದೇ granted land ಅಂತ ಹೇಳ್ತಾರೆ.
It's a granted land.
PDCL.
Even my lord,
One minute, list, at the request of the learned HCGP, list the matter on 21st. No precipitative action shall be taken till the next date of hearing. Yes,
Okay.
next.
Great.
160.
My lord, 406 and 420, my lord. My lord, after 6 months of issuance of notice to the complainant for recovery of the amount, my lord, he filed a false complaint, my lord.
ಯಾವ್ದು ಮೇಡಮ್? 4th September. 4th September. ಯಾಕೆ ಕೇಳು, ಮೈಕಲ್ ಹೇಳಿಲ್ವಾ? Yes.
My lord, recovery notice I have issued in the month of 11th month of 2023, my lord, for recovery of the amounts due to me.
The issue in the list pertains to registration of a private complaint.
No, my lord, it's complaint to the police.
Complaint ಮಾಡಿದ್ದೆ, ನೀವು private complaint ಹಾಕಿರೋದು.
ಇಲ್ಲ,
ಮತ್ತೆ
ನಾವು
ಇದ್ಯಾವ್ದು?
mediation agreement, commercial suit we have.
Sir, one ನಿಮಿಷ, come here. Page, annexure B, page 14 ಯಾರ್ದು sir? Serial number ಏನು ವಿನೋದ್ ಕುಮಾರ್ ತಾನೆ?
Yes, my lord.
ಹಾ.
14, it's not private complaint. Complaint. to the
Private
police
ಅಲ್ಲ ಗೊತ್ತು, ಕಂಪ್ಲೇಂಟ್.
Complaint. to the-
ನೀವೇ ತಾನೆ ಕಂಪ್ಲೇಂಟ್?
ಇಲ್ಲ, ಅವರು complaint. I have lodged mediation proceedings in Cochin, my lord.
Page
My lord, 20,
20?
my lord, 23, my lord. 23 is the notice,
is
my.
Recovery of money.
Yes, my lord, recovery of.
That's what.
27 is the mediation
You
application.
are the employee,
No, my lord.
then
I
partner.
am the supplier of goods to the.
Granary Wholesale Private Limited.
I supplied and I sent the bill, my.
The petitioner, heard the Land Council so and so. The petitioner is said to be supplier of goods to one Granary Wholesale Private Limited. The dispute between the two is with regard to the non-payment of money despite the supply of goods. Therefore, the petitioner institutes a commercial OS in number,
My lord, it's mediation proceedings before.
which is in the pre-suit mediation stage. Immediately thereafter springs the impugned complaint alleging misappropriation against the petitioner. The crime appears to have been registered as a counterblast to the demand of money by the petitioner. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
My lord.
1, 2, ಅಷ್ಟೇ.
161.
ಭೀಮಯ್ಯನವರೇ, 12/4/22 ಆರ್ಡರ್ 2 ವರ್ಷ ಆಗಿದೆ.
Subsequently filed a revision petition before the sessions court, my lord.
Nothing.
It has been dismissed for
Nothing. ಇವತ್ತೇನು ಆರ್ಡರ್ ನೋಡೋದು? Yes.
my lord.
What has happened before the court now?
Is pending, my lord. And
Petitioner is
accused has not
directed to
been-
serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement list on 3rd September in the fresh matters list. Next.
But the meanwhile.
No, sir.
My
ಎರಡು
lord,
ವರ್ಷದ
it is
order ಅಷ್ಟೇ ನಾವು.
2012 complaint, my lord.
Nothing. Yes, next.
Lord, he has admitted the signature.
No, sir.
Lordship, in this case, habeas corpus was filed, my lordship.
ಏನಾಯ್ತು?
That is withdrawn, my lord.
Wait.
Yesterday it is withdrawn, my lord. Because, my lord, he is escaped from the kidnappers, my lord.
Kidnappers ಇಂದ escape ಆಗಿದೆ.
Yes, my lord. There is a serious allegation against the Raichur police and also to the Davangere police, my lord. They are hand in gloves with the kidnappers, my lord. 33 days he is illegally detained, my lord.
ಈಗ now you are seeking further investigation.
Yes, my lord. He has given also instructed that he has given a complaint on yesterday, my lord.
What
Yes.
investigation have you made, madam, till now?
Sheet not yet filed, my lord.
Charge sheet filed.
Not yet filed. Still under investigation, my lord. Records have come.
Records thoroughly, 21st in the fresh matters list.
Please, my lord.
Next. 10th or 13th?
10th,
List on 10th.
notice maybe.
Learned counsel, BB Patil is directed to accept notice for, ಎಷ್ಟು ಹಾಕ್ತೀರಾ ಇನ್ನು? ಒಂದು ಲಿಮಿಟೇಷನ್ ಕಟ್ ಆಫ್ ಡೇಟ್ ಹಾಕ್ಬಿಡ್ತೀರಾ? Yes. So till the next, sorry, ಏನಿಲ್ಲ, ಆರ್ಡರ್ ಏನಿಲ್ಲ. Petition, BB Patil is directed to accept notice, petition to serve set of papers, so and so. A 3, 4 and 5,
Yes, 498 a complaint.
164.
Yes.
You are appearing for.
Appearing for the petitioners, my lord. They are the in-laws of the wife,
right.
my lord.
Heard the learned counsel Srimati Rupa Arun appearing for the petitioner. The petitioners are A 3, 4 and 5, finding no allegations, Kashkan stayed. Next, yes.
165.
Emergent 1 HCGP. There shall be an interim order of stay of only the proclamation issued against A7 for it being completely in contravention in section 82 of the CRPC. Next. ಬೇರೆ ಏನಿಲ್ಲ, ಆಮೇಲೆ ನೋಡೋಣ. First proclamation stay ಮಾಡೋಣ.
I'm 68 years old.
So what?
I'm directed, my lord, after my lord, I have retired from service.
We'll see.
My lord,
Yes.
allegation is, my lord, I have registered a document. my lord.
List on 21st. Yes.
The freshman.
Freshman.
Great.
166.
In the meantime,
Petitioner, my lord. 67. I'm the husband, my lord, so 490 is registered again.
even then I have stayed it. Yes, next. Shanti Bhushan or CC of 2014.
Please.
Connected matter.
Please, madam.
Tag along.
ಅದು ಕೊಡಿ ಮೇಡಮ್, ಟ್ಯಾಗ್ ಸೊ ಅದು ಕಾವ್ಯ ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್ ಟ್ಯಾಗ್ ಸೋನ್ಸ್.
Please.
ಯು ಆರ್ ಆಲ್ ದಿ ಕಂಟೆನ್ಷನ್ಸ್ ದೇರ್.
Please, liberty.
ಅಲ್ಲ, ಚಾರ್ಜಸ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಲ್ಲ?
ಇಲ್ಲ, charge frame.
ಆಗಿಲ್ವಾ?
ಆಗಿ.
It is staged for framing of charge.
Discharge application is dismissed. My lord, all that I am the owner of the property, my lord.
That's all right. Charge frame ಆಗಿಲ್ವಾ?
ಇಲ್ಲ.
Yes, in the meantime, only if charges are not framed
Please.
as on today. Heard the land counsel Shanti Bhushan appearing for the petitioner.
Great.
If the event charges are framed, the interim order would not operate.
No, my instructions is.
Allah, whatever.
Please.
Yes, next.
Great.
Otherwise, it's a matter for staying. Yes.
Please.
168.
6 years, huh?
How?
ನೀವೇ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿಲ್ವಾ?
2017 ಇಂದ
17 to 23, 6 ವರ್ಷ
22
ಅಲ್ವಾ?
22 ವರೆಗೆ.
5 ವರ್ಷ, 1 ವರ್ಷ ಕಮ್ಮಿ ಆಯ್ತು, ದೆನ್ ನೋ ಸ್ಟೇ. ಅದು ಪೀರಿಯಡ್ 6 years ಇದ್ರೆ ಮಾತ್ರ.
Allegation.
madam. The petitioner, the petitioner and the respondent were in a live-in relationship,
They were in a relationship.
were in a relationship for close to 6 years prior to the registration of the complaint, which comes about on 1/12/2023. It is on the breach of promise of marriage, the complaint for the aforesaid offences spring. Permitting further proceedings will run foul of Naeem Ahmad versus so and so 2023 SEC online SC page 89. Therefore, there shall be
69.
Life.
Petitioner is accused number 5, please.
same we have stayed. Kodi.
Page number 77 minutes.
Page 77.
78. Page
Page.
number 78. Much.
70.
Petitioner is victim of a scam, my lord. Now His account has been frozen and
Correct. Victim of a scam, only projection, money trail ನೋಡೋಣ.
please, my lord.
Yes, learned HCGP is directed to accept notice, secure instructions and make submissions with regard to the freeze. What, with regard to the freezement of the account of the petitioner who is himself a complainant.
My lord, let the money not be disbursed. ಅಷ್ಟೇ ಕೇಳ್ತೀನಿ.
The amount lying in the account of the accused shall not be dispersed till the next date of hearing. It's next. Next date of hearing, date ಕೊಟ್ಬಿಡಿ madam. List on 10th September. Fresh matters list. Next.
171.
Section 12 of DV Act, my lord. So the all allegation made on in 1986 marriage. So all allegation against the husband. ನಾವು ಎರಡನೇ ಹೆಂಡತಿ ಮಕ್ಕಳು ನಮ್ಮ ಮೇಲೆ section 12 ಇಂಪ್ಲಿಕೇಟ್ ಮಾಡಿ.
Emergent notice to the respondent, there shall be an interim order of stay away the petitioner till the next date of hearing. Next.
172.
Why CBI?
The double murder, my lord.
Double murder.
And the investigation was, case was completely botched up by the jurisdiction police, my lord.
Let's see. Learned HCGP is directed to accept notice for the first respondent, Counsel Shanti Bhushan, the DSGI Shanti, alla, ನೀವಿಲ್ವಾ?
State government.
Sorry. HCGP 1, 2, 3, 4, 5. All respondents.
1 to 6, state government.
Irade 1 to 6. Yes. List on to secure instructions and make submissions, list on so and so. So and so ಅಂದ್ರೆ ಏನು? ನೀವು ಕೊಡ್ತೀರಾ? 12th. Yes.
Fresh matter.
73.
Okay. ಎಲ್ಲ ಆಗ್ಬೇಕು.
2013, my lord, we purchased the property. 2014, my lord, 16, there was interference, we filed a complaint. There have been, my lord, civil cases, my lord, as many as 8 execution petitions. My lord, column number 17 virtually gives, my lord, a title certificate. Virtually, my lord, gives a title.
ನೋಡೋಣ, ಬರ್ಲಿ.
Allah, kindly see, my lord, column number 17, my lord, I'll just
Page
point
40, page 42. sir.
Page 42.
Yes, sir.
Virtually, my lord, now what, my lord, they would say is, my lord, in the execution petition, they are saying my property as their property.
The respondent.
No, my lord. The additional documents in the
Lord,
execution.
how is this for the petitioner? and you
No, my
for the
lord,
respondent?
Sandeep sometimes, my lord, keeps hopping. No, my lord, what would happen is, my lord, this,
Stick it in the court.
the only, my lord, immediate imminent danger is this. The execution court, my lord, now we have filed objector's application. The execution court, my lord, is now, have to, my lord, is going to now find out that who is in possession, which is the identity of the property. Now, my lord, in the meanwhile, in the interregnum, my lord, this charge sheet comes with a beautifully worded, my lord, possession and title certificate. Now, my lord, what would do is, based upon this, they would now go to the execution court and, my lord, virtually the job of the execution court, my lord, will be, my lord, based upon this. Namd already charge sheet agidare, police have already given a finding, therefore we are in possession.
So charge sheet ಆದ್ರೆ trial ಮುಗಿತು ಅಂತಾನ?
Allah, but my lord, under, my lord, order 21 rule 10, my lord, 100 and 103, the inquiry, my lord, is summary in nature. Though, my lord,
Because you're an objector there.
Yes, my lord. Therefore, any document of this nature, my lord, would certainly prompt the civil court to, my lord, take a view. My lord, this findings, my lord, it's virtually a title certificate. And kindly see, my lord, my complaint
Let
is
the
in the year
respondent come.
2016.
Heard the learned senior counsel MS Shyam Sundar appearing for the petitioner. The one HCGP 2 emergent notice, list the matter.
The matter is before, my lord, the trial court on 23rd of this month.
Let it.
This will be used.
For what purpose? If it is used, you move the matter. List the matter on 12th September.
At any date before that, my lord, because otherwise, my lord, it will be disastrous, my lord.
Nothing.
If
what happens on 23rd, you produce it, we'll see.
We will, my lord, but only, may I just, my lord, proceed your lordships, only to, my lord, see the order of cognizance for a moment. Order of cognizance in the teeth of all these things. The police themselves, my lord, in that charge sheet, in that column number 17 itself would refer to, my lord, civil cases. Civil cases. And, my lord, the order of charge
On
sheet.
12th, how do they use that document? We'll see. List on 12th.
All likely, my lord, this entire document is designed for that purpose.
We'll see. All likely may become unlikely also. We'll see.
Allah, nange, my lord, what would happen is,
since, my lord, the inquiry, my lord, has a limited scope, then, my lord, now, if your lordships could kindly see, my lord, the additional documents for a moment, my lord, I'll just take only 1 minute. Additional
ಆವಾಗ್ಲೇ
documents.
ಆಗೋಯ್ತು, ಇದು ಥರ್ಡ್ ಟೈಮ್ ಹೇಳಿದ್ರಿ.
Another 1 minute, my lord.
ಹಾ.
Kindly see, my lord, the photographs which we have produced along with our police complaint, my lord, which is sometime, my lord, in 2016. In 2016, my lord, these are our photographs.
ಆಯ್ತು, list on 22nd in the fresh matters list. You serve on the respondent, counsel, whoever.
So great.
The petitioners are at liberty to serve on the counsels, represent the respondent in the trial proceedings.
74.
So great.
Apart from notice, you serve, yes,
We will, sir.
in the meantime, next. Next.
75.
75, I beg to appear on behalf of the petition in this matter. Oh. Change ಆಗ್ಬಿಟ್ಟಿದೆ attire. ಅದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ಲ. State, sir, yes, next. Granted, sir. Yes.
175 minutes, I'm appearing for the petition in this matter.
CC of 2018 revision.
I fully understand it, my lords, but the matter is not proceeded with, but the complaint, if your lords were to give me a minute's time.
No, we'll see, we'll secure the stage, yes.
Evidence stage, my lordship.
No, sir, charges frame ಆಗಿ evidence ಅಲ್ಲಿ ಇದೆ ಅಂತ ಇದ್ದಾರೆ.
Lords, even if, my lords, if I'm in a
No,
position
sir.
to demonstrate, there is nothing which is going to happen eventually. Lords, 2018, if the charge sheet is filed, 2024, nothing is progressed. Even today, the prosecution
I will
cannot come
direct
and say that
completion,
this is.
I will direct completion of the trial if you want.
Lords, completion of the trial is certainly one of the release, but if I am in a
Yes.
position to demonstrate that there is nothing much which can be not forthcoming in the manner in which it has progressed for all these years.
So then I'll have to entertain hundreds of petitions which I have not entertained till today.
I understand. my
ನಿಮಗೂ
lord.
ಗೊತ್ತು.
I understand.
Hmm.
Lords,
We'll see.
may I just
We'll
take
list-
instructions, my lords. Lords, may I have this
List
matter on Monday?
List on 23rd in the fresh matters list, yes.
No, only for the limited purpose as to whether I can, my lords, concede to a situation where
ಅದೇ
we can.
limited purpose ಗೆ 23rd.
Lords,
You want earlier to it?
earlier to it, my lords. It's only for that limited purpose since your lords have
List
already
on
expressed.
21st,
Lords.
yes.
176.
Petitioner.
In the meantime, till the next date of hearing, list the matter on 11th September, next.
177.
What has happened to the FD amounts? All are secured?
No, my lord.
All eaten away?
Same
Your
modus
lordship.
operandi is the same.
Your lordship,
As we have
second
seen
FIR
in
on the
the-
same incident. I've been arraigned as a charge sheet witness in the first FIR. And ED also has said that I'm the victim of the crime, your lordship. Even Lokayata complaint was filed. There also no wrongdoing has been found, your lordship. With respect to the same incident, I was the person who.
Checks are with us, and it is given to an account of the manager of that bank, directly to their account.
ಅಲ್ಲ,
This we revealed,
Vijaya Bank.
this we came to know much later, and that is how this happened. And since ED was already there, that is the difference in the time for filing.
Your
Lord, we'll
lordship,
file our objection.
File. I am not, this is not a matter to be stayed.
Obliged, Lord.
Let the objections come.
May I request
Heard the
for-
learned counsel appearing for the petitioner, learned senior counsel, learned counsel, yeah.
Swati.
Learned counsel Srimati Swati Ashok submits that you already filed.
I'll file.
Would undertake to enter appearance for the Waqf board, huh?
Lord, second respondent is the officer who's filed the complaint.
1 minute, madam.
That's-
ನೀವು ಯಾರಿಗೆ ಈಗ? Second.
For the board
To
itself.
the second respondent, the complainant. Learned HCGP for the first respondent. The learned counsel Srimati S.R. Anuradha representing, learned senior counsel Srimati S.R. Anuradha representing the second respondent seeks 2 weeks' time to file statement of objections. List the matter on 12th September, objections if any by then.
May I
4
request-
weeks, ಆಯ್ತು.
May I request for it to be in the fresh matters list at least?
Oh, that's fine. Yes, fresh matters list.
Great.
178.
In the meantime, next.
79.
Shanti Bhushan, sir, 17/6/20, ನಿಮ್ದು first stay ಆಯ್ತು. 179, 306, 17/6/24 is the crime.
Please.
Let the investigation papers come.
Please, please.
The learned HCGP on the first, madam, 178 in the meantime. 179, learned HCGP is directed to accept notice for the first respondent, secure instructions and make a submissions. List on 5th September in the fresh matters list.
Great.
Next.
180.
80 and 81 serve ಮಾಡಿ. We'll
Lord-
take it on 23rd.
Lord, they are non-executive directors.
I will see.
202, my lord, and these are accused 4 to 8. In respect of accused number 1 and 2, my lord, your lordships in a separate petition have granted a stay
Seriously.
for accused number 1 and 2.
Tag. So and so, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅದು? Both 180 and 181.
Lord, and 180,
180,
2 and 4.
182 and 184. Tag all these, madam. 180, 181, 182 and 184. Yes, next is 183. In the meantime, next.
185.
I'm the petitioner, my lord.
ಎಷ್ಟು ಹುಣಸೆ ಹಣ್ಣು ಕದ್ರಿ?
ಅಲ್ಲ, ಅದೇನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅದನ್ನ.
ಮತ್ತೆ ಟ್ಯಾಮ್ರಿನ್ ಟ್ರೀ ಅಲ್ಲೆಲ್ಲ ಖಾಲಿ ಮಾಡಿದೀರಾ ಅಂತ ಅಲಿಗೇಶನ್.
ಸ್ವಾಮಿ ಅದು ಏನ್ ಮಾಡ್ಲಿಲ್ಲ ಅದನ್ನೇ.
ಮತ್ತೆ
ಮಾಡ್ಲಿಲ್ಲ ಅದು.
how much tamarind you need, sir?
ಅದಲ್ಲ, ಅದ್ರಲ್ಲಿ 4 ಇದಾವೆ. ಅದೇನು ಹಂಗೆ ಇದೆ ಸ್ವಾಮಿ, ನಾವೇನ್ ಮಾಡ್ಲಿಲ್ಲ ಅದನ್ನೇ.
Allegation is that tamarind tree ಖಾಲಿ ಮಾಡಿದೀರಾ ಅಂತ.
ಅದು after 2 years minute is there is interim order against the 10th this morning number 2 OS number 81 of 16 and 21.
Not to take away tamarind.
ಅಲ್ಲ, ಅದನ್ನ ನಾವು ಏನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅದನ್ನೇ. ಏನ್ ಮಾಡ್ಲಿಲ್ಲ ಅದು. The RS pending ಇದೆ, 2 RS 2 pending ಇದೆ.
In the meantime, yes, next.
186.
That's just 2 submissions, my lords. It's page 84 may kindly be seen. I'm aware of the allegations that are there. Page 84 may kindly be seen, my lords. My earlier complaint to Madiwala police, my lords, I have specifically spoken about intimation regarding possible self-harm by her, by the girl, and possible false complaint that she might make against me. Then, my lords, I have stated this letter is to intimate you
Why
about
did you
her-
on your own do all that?
My lords, there, in fact, even before that.
Because
my
of the
lords,
alleged acts performed by you.
no, my lords, her mail may kindly be seen for a moment, page 116. She writes the mail to me in May 2023, where she says, my lords, right at the beginning, I am sorry for the person I become when I am not in my sound mind. And I'm sorry that you don't want anything to do with that person. It is sad that it has to end this way after all that we have put in this relationship. She says, then she says, finally, my lords, you are tired of trying and being there, and you have your own priorities. Basically, she has a state of mind where she's been taking treatment. But that is evident, and there are medical records also to that extent. It is the petitioner who was the one who was taking her to the hospital, my lords. Though despite there not being such a relationship. There's allegations in the complaint, but in fact, my lords, it is I who called the police on that night and called them. She says she was the one who was locked in the bathroom. In fact, I was the one who was locked in the bathroom. I am the one who called the police.
It's a matter of trial. Who was locked in the bathroom?
But my submission is, but in my voluntary statement, I have stated about these facts. Three of our friends were in the room when the incident took place.
Bathroom?
Allah, in the room, my lords, on the night. In addition to that, my lords, I have also stated that I am the one who called the police. The police have produced her telephone records, which do not indicate any call made to the police.
When you were in the?
On the day of the incident, my lords. And I have also indicated in the investigation that I am the one who had called the police. Police do not produce they do not investigate as to about my call records. But my submission is, I have also, my second prayer may kindly be seen. I have sought for further investigation to be directed by this honorable court. Eventually,
You want other offenses to be added?
no, my lords, it cannot be for this reason. Whatever has to be added from the complaint, everything has been added. Because my submission is, my lords, I'm at least entitled for a fair investigation. 3 witnesses are there. They have not been inquired into.
What is unfair about the investigation?
3 witnesses.
What is fair about your conduct?
As far as my conduct is concerned, I have, her mail says about her state of mind. Firstly, I had given a complaint in December 2023 to the police. NCR was registered.
She is likely to file a complaint against me.
Please, but in fact, I've even stated about her state of mind in the complaint. And in addition to that, my lords, my prayer, my lords, has been alternatively, I have sought for further investigation to be directed. My submission is, if at all my call records are not made a part of the investigation, but in that event, the police would know that the investigation report would indicate that I am the one who called the police on the said night. 3 other persons were witnesses to the incident in the room, my lords. They have not been inquired into. My lords, may also kindly appreciate this. The police come to the house. They, in fact, the eyewitness statement specifically speak, my lords, It says that they come to the house, they leave the girl in the house and then they say, you come tomorrow in the morning and file a complaint. But my submission is at least an investigation if ought to have been done, maybe what actually had happened, taken place that day would have actually come to light. Otherwise, in this background, in fact, I have stated even in my voluntary statement that she had caused injury to herself on the said day. Her medical state is such, my lords, that she, in fact, my lords, her male,
All is a matter of trial.
my lords, I am,
Allegation is that you have locked her in the bathroom. And
I have
all the
assaulted
other
her,
acts.
I beat her, all,
Not able to read all that, yes.
please, please, even I don't intend to read. My submission is, if at all an investigation would have been done with the witnesses who were present.
So it would
on
have
that-
revealed that you were locked in the bathroom.
Not it would have revealed. It would have also revealed that I am the one who made a call to the police.
Anything else?
Page 116 in the mail.
Okay, you submit to your satisfaction on 21st. Placed on 21st in the fresh matters.
22nd, if I could.
22nd, fine, no problem. Pendency of this petition will not come in the way of further proceedings before the
There
concerned.
might eventually,
I'm
there
not
might,
even issued notice.
please. My submission is, he's completed his law minutes.
Who?
The boy. He's
Oh.
finished his law.
Oh,
They were in a short relationship, my lords.
short relationship.
1.5 years, my lords.
Okay.
Now, the incident as such, my lords, even today, given the fact, despite he having made all the efforts as such, today he's meant to face this case as such without such material.
What to do, sir? As you sow, so you reap.
I'm at least entitled for an investigation which ought to be fair.
That will see. 21st,
I'll submit.
22nd,
22nd.
22nd, fresh matter. In the meantime, next. 187.
98.
187 ಆಯ್ತು ಕೇಶವ್ ದಾತಾರ್ ತಾನೆ. Oh, sorry. Heard the learned senior counsel Vikram Holigola appearing for the petitioner. In the meantime, I sorry, I didn't see you waiting for that. iPad ಎಲ್ಲ ತಂದಿದ್ದೀರಾ ಅದಕ್ಕೆ? Yes. Huh? Oi, police are troubling you. All right. ಆಯ್ತು. ಕೊಡಿ. ಅವೇ ಅಲ್ಲ 187. DA. 10th. List on 10th. BB Patil is directed to accept notice for the respondent so and so. Yes. Yes. Withdrawals ಯಾವಿದೆ ನೋಡಿ. Withdrawals ಯಾವಿದೆ ಇದ್ರಲ್ಲೆಲ್ಲ ಬರ್ಕೊಂಬಿಡಿ. Yes. 130.
Serial number 46, my lord. I was held up in other court hall, my lord. I was ready. my
Other
lord.
can't tell.
My lord, it's urgent for 2 weeks.
Other court hall is important, ಏನ್
But
ಮಾಡಕ್ಕೆ?
that's not my lord. It's urgent for 2 weeks. At least in 2 weeks.
Then why I do that is, you all think they ಇಲ್ದೇ ಇದ್ರು stay ಕೊಡ್ತಾರೆ ಅಂತ.
ಸ್ವಾಮಿ ಇಲ್ಲ ಸ್ವಾಮಿ. I'm still ready, my lord. But 2 weeks ಅರ್ಜೆಂಟ್ ಆಗಿದೆ. ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ. ಅಷ್ಟೇ ಕೇಳ್ತಾರೆ. ಜೂನ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೆ
2
ಸ್ವಾಮಿ.
weeks ಬಿಟ್ಟು
ಅದನ್ನ ಇವಾಗ ಬಂದಿದೆ ಕೋರ್ಟ್ ಮುಂದೆ.
ಆಯ್ತು 2 weeks ಬಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ.
46.
ಯಾವ್ಯಾವ್ದು 2 weeks ಅಂತ ಮಾಡಿದೀನಿ ಅದಕ್ಕೆಲ್ಲ ಒಂದು ಡೇಟ್ ಅಂದ್ರೆ 29th ಏನೋ ಇದೆಯಲ್ಲ ಮೇಡಮ್ ಅಲ್ಲ ಒಂದು ಸೆಕೆಂಡ್ ಸಾಟರ್ಡೆ ಬರುತ್ತಲ್ಲ ಯಾವುದು ಅಲ್ಲ ಸಾರಿ 25th 24th 25th 26th 27th
Please.
so that you should be present please, sir.
Serial number 236, withdrawal.
Thank you sir. Yes, anything else?
Madam. Madam.
Good afternoon, madam. Madam, good afternoon.
My lord, memo for posting.
Memo for
Post.
tomorrow.
Yes, my lord.
ಬೇಡ ನಾಳೆ.
My lord, there is an urgency, my lord.
You move the other court, sir. I am not sitting tomorrow.
My lord, please.
ಆ ಕೋರ್ಟ್ಗೆ ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ 2:30 ತಗೊಂತಾರೆ.
Serial number 27, reporting.
ಹಾ.
Lordships kindly. One request for end of the list, my lords. My lords, property release order, my lords, is passed on 37, my lords. I am one of the claimants. Rival claimant, my lords, it is allowed. My lords, the order, my lords, certified copy of the order, my lords, is furnished on 6/7, my lords. I filed the petition today morning. Saturday, the amount, my lords, is 38 lakhs, my lord. 38 lakhs. That is ordered to be released in favor of a rival claimant. If it is released, my lords, I would have.
Criminal case ಏನು ಸಂಬಂಧ sir?
My lords, a criminal, my lords, a crime is registered, my lords, by the Mandya West Police Station. My lords, allegation is that, my lords, the former president, my lords, has transferred certain amounts, my lords, to his personal accounts. My lords, while investigating, my lords, I'm in no way connected, my lords, with the former president. My amount, my money, my lords, is seized. Now the learned trial judge, my lords, has ordered the entire money, my lords, to be given to the society.
Release ಮಾಡಕ್ಕೆ ಹೇಳಿದಾರೆ.
Yes, my lord.
ಆಯ್ತು ಹೇಳಿ.
BPL.
ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಾ? ಎಷ್ಟಿದೆ? 5 ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತು ಸರಿ ತಗೊಂಬಿಡಿ. ಒಂದು ನಿಮಿಷ. ಮೈಕ್ ಮೈಕ್ ಅಂದ್ರೆ ದೂರ ಬಂದು ಮಾತಾಡ್ತಿದ್ರಿ. ನಾಟ್ ಇಂಟೆಂಡಿಂಗ್.
Please, my lords, and my laws directed to lease this matter in fresh matters list last hearing date.
This the matter on the counsel for the petitioner submits talks of settlement have failed.
I am for respondent number 2, my lords.
Respondent to complaint submits the talks of settlement have failed. List this matter on 4th September in the fresh matters list.
Please.
77.
ಏನು offense?
498. One is 498, other two are 323, 506.
Both settled. huh?
Both, sir. All the three matters are.
Three
settled.
matters.
Three settled.
Please.
All right.
Parties are present.
One of the accused is not present in the connected.
Why is not present? Why? One of the accused is not present.
That is.
Complaints are present.
ಯಾಕೆ accused ಎಲ್ಲಿದ್ದಾರೆ?
ಅಲ್ಲ ನಮ್ಮ ಅದ್ರಲ್ಲಿ 3 ಜನ ಇದ್ದಾರೆ, ಒಬ್ರು ಇಲ್ಲ.
ಆಯ್ತು. ಹಸ್ಬೆಂಡ್ ಇಲ್ವಾ?
ಹಸ್ಬೆಂಡ್ ಇದೆ.
then ಇನ್ಯಾರಿದ್ದಾರೆ?
ಇಲ್ಲಿ ಇವರ ಬ್ರದರ್, ವೈಫ್ ಬ್ರದರ್ ಒಬ್ರು ಇಲ್ಲ.
ಆಯ್ತು, ತೊಂದರೆ ಇಲ್ಲ ಬಿಡಿ. ಅದು ಕೊಡಿ ಮೇಡಮ್.
Page number 7.
Page?
Page 7. In first matter, 796.
DD, sir.
Madam, page 8 and 9.
Under
Clauses.
DD.
During the pendency of the petition, the parties to the list have settled ಇದರಲ್ಲಿ ಎಲ್ಲ ಮಾಡಿ ಲಾಸ್ಟ್ ವರ್ಡ್ ಹಾಕ್ಬಿಡಿ. The demand draft for rupees 10 lakhs is handed over by the petitioner and 10 lakhs. A demand draft for rupees 10 lakhs is handed over by the petitioner to the complainant in terms of the settlement. Both of them would submit that all terms and conditions of the settlement have been fulfilled. In that light, so closed. All three. Yes. ಅಲ್ಲಿ 3 ಇದೆ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ 3 ಇದೆ.
Respond. Petitioner, sir.
Offense.
498 and 340.
Page number 29 of the petition.
20?
29. Mediation is set like.
Madam, ಇದು application compounding in the during the subsistence. 29 ಅಲ್ಲಿ mediation ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ. ಅದೊಂದು ಕ್ಲಾಸ್ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. Clause 8. ಅಷ್ಟೇ. Yes. Next.
Please.
It's number 2. Till number 24.
ಅಲ್ಲ 230 ತಗೊಂತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ. Yes. Yes, sir.
Just to recapitulate the submissions which I made the other day. Just about 2 or 3 sentences. Well, it is not in every case where a charge that had already been framed against the accused is altered by an amendment or added by an inclusion. That he gets the right, the court gets the right to pass an order under section 216(4). No. And probably your lordship may have to have a look, second look at.
216.
Yes, my lord.
Yeah.
When he could do it, my lord.
Yes, yes.
See, after such addition and alteration, but if the court is of the opinion that recording of further proceedings in the case then and there is not possible, and if he were to proceed to record further proceedings in the case then and there, it may cause prejudice either to the prosecution or to the defense, then only, my lord, he has got 2 options. One is order for a new trial or adjourn the case for some time. It is not every addition or alteration that gives him a right or clothes him a right to order for a new trial. He gets, the trial court gets the right under section 216(4) or the power under section 216(4), provided he gives a finding that if I were to proceed to record further proceedings in the case, no sooner such alteration or addition took place, it may cause prejudice. Otherwise, no. But may I just request your lordship to kindly have a cursory look at that. Second look at section 216 subclause 3 first.
Yes.
And then go to subclause 4.
Yes.
So that subclause 3 is if his finding were to be in the negative, that no prejudice is going to be caused. You proceed with the trial of the case as if, my lord, the addition or alteration had come into existence on the date when the original charges came to be framed against the accused. Well, now under section 216 subclause 4, have a look at section 216 subclause 4. If the alteration or addition,
Yes, sir.
well, every alteration or addition does not enable him to
Order new trial.
order a new trial. Well, if my lord were to read it carefully, if we were to read it carefully, my lord, have a look at subclause 4. If the alteration or I'm sorry.
Yes. The only circumstance for a new trial is if there is a finding that there is material change, 1. And on the altered charge, the only obligation of the court would be 217 to recall the witness for examination.
That's it, my lord.
That's all.
Otherwise, what is
230, 231 procedure will come.
What is, yes, my lord, 230 and 231 would come into play. No sooner charges are framed under section 227 and 228.
And
not
now,
otherwise.
if the altered charge has the impact of recommencement of the whole thing, then 230 and 231 will come. That's all.
Otherwise, my lord, the procedure that is contemplated is only under section 217 and not otherwise.
Yes, that is true. Recall of
But
witness.
we have got to read 216 and 217 harmoniously. Now have a look at section 216(4) now,
Yes,
once
sir.
again.
Yes.
I'm sorry, my lord, I'm troubling your
problem.
lordship,
Yes,
taking your
yes.
lordship, because every time we keep reading something new would
Always,
occur
that
to
is
us.
always there.
Always would occur
Yes,
to us. If the alteration or addition is such that proceeding immediately with the trial, my lord, may kindly underline this, alteration or addition is such that proceeding immediately with the trial is likely in the opinion of the court to prejudice the accused. If the court were to come to the conclusion or were to give an opinion that such alteration or addition is there, it has been made. But proceeding then and there with the trial is likely to cause prejudice either to the prosecution or to the accused, well, then he has two options. That is not the only option. Ordering a new trial is not the only option that is available to the court. The first option is either order for a new trial or adjourn the case. Why, my lord, the court is closed with the power of ordering a new trial or adjourning matter is so that either the prosecution or the defense could keep themselves ready, my lord, to participate, to have an effective participation in the trial consequent to the addition or alteration, not otherwise. Let kindly see, the prosecutor, as aforesaid, the court may either direct a new trial or adjourn the trial for such period as may be necessary. Adjourn it by 15 days, adjourn it by 1 week, depending upon the evidence with the defense.
Them to get ready with the evidence.
Get ready, that is the main purpose. Well, my lord, it can't be, my lord, under section 230 and 231, but at any rate would be my respectful
Will
submission.
consider.
Otherwise, my lord, what happens is this. My lord, I invited my lord's kind attention the other day.
1 second. Yeah, where is Prasanna Kumar? I'm not granting time. I'm not granting a pass over even. Yes.
He's on his legs.
Yes.
My lord, the other day I invited my lord's kind attention to the provisions of section 386, where the appellate court would exercise its powers. My lord, that is also almost akin to section 216 subclass 4. There, my lord, it is the
Power of the appellate.
power of the appellate court. But even if, although the appellate court has the power under section 386 subclass 1 to order for a retrial, but the other day I invited my lord's kind attention to the dictionary meaning. What is retrial, what is new trial, what is
De novo
first trial, what is the de novo trial? They are almost akin to each other. But there also, my lord, the appellate court cannot blindly or mechanically order for a retrial unless and until, in the opinion of the appellate court, my lord, the trial has proceeded, the judgment of conviction or acquittal is recorded by the trial court, number one, without jurisdiction. Number two, without adverting to the evidence available on record in the case, my lord, upon extraneous considerations. That is how, my lord, the Supreme Court has said, my lord, a full bench judgment of the Supreme Court. The other day I took your lordship
yes.
to the first judgment of the Supreme Court. But well, now he has exercised his power under section 216 subclass 4. Kindly proceed with an assumption. It has enabled him, irrespective of the fact that a finding that recording of further proceedings in the case then and there may prejudice. No such finding is there. Then and
Yes.
there may prejudice.
Now, one clarification. What is the altered charge?
Well, there is no altered charge at all.
It's what?
I shall submit to your lordship. I was put on trial for an offence under section 302 initially
That is by the state.
by the state upon the investigation which came to be done by the state.
State, yes.
But upon the result of the investigation made by the CBI disclosing the commission of an offence which is also made penal under section 120B. But the altered charge is 302 read with 120B. But originally a charge under section 201 had not been framed at all.
Now,
But
201 is invoked
consequent to the collection of some evidence
by CBI.
by CBI, which would, according to the prosecution, indicate but either the concealment or destruction of the evidence.
Yes, yes.
A charge came to be framed, an additional charge came to be framed for an offence under section 201, read with section 120B. And the third additional charge is for an offence which is made penal under section 3 and 5 of the Arms Act. Except in this, nothing else.
So 201 is added,
201,
302 read with 120B is added, and
3 and 5.
Arms Act of the Arms Act
With
is added.
120B, the Arms Act is added.
That is the
But-
alteration.
Yes, but the witnesses who are to be examined, I'm sorry, PC Act also.
That is against public servant.
Against, but not against this petitioners.
Or ಬೇರೆ 18, 17, 18, 19 ಇದ್ದಾರೆ ಅವ್ರ ಮೇಲೆ.
How's But when I was put on trial for an offence under section 302 to the exclusion of 120B. Yes. 63 witnesses are examined. But the very same witnesses are cited in the additional charge sheet.
No, 63 witnesses were examined by the state pursuant to the charge sheet.
Charges framed against.
Charges framed
Under section 302
302 in a charge sheet filed by the state.
by the state.
Now, what is sought to be examined, who are sought to be examined and charge altered is pursuant to the charge sheet filed by the CBI.
a
Or a
kindly
supplementary report,
No, a report, an additional report to the report
additional
that has already
report
been filed
by the CBI.
by the CBI, doesn't matter.
Now,
Let it be
what
anybody.
forms the material alteration is what forms the content of the supplementary report of the CBI.
CBI.
Yes.
But now, kindly proceed with an assumption for the sake of argument, do not conceding for a moment, do not for the reason indicated under section 216 subclause 4 of the CRPC, the trial judge has the power or the authority or the jurisdiction to order for a new trial.
Yes.
New trial. Ignore, a finding not being given that if I were to proceed to record further proceedings in the case, then and there, it may cause prejudice to the accused. Kindly ignore that. But what is the procedure which is required to follow is the next question. Is it under section 230, 231, or is it under section
217.
217? That is the next question.
Now, one other clarification. Now, the witnesses that are sought to be examined,
Same witnesses.
under 230 and 231, are they different from the witnesses that were examined pursuant to the state filing the charge?
Additional witnesses, that's all.
Now there are additional witnesses.
Additional witnesses, same witnesses. Same witnesses are cited.
Are they termed as additional witnesses?
Yes, but no. What they say is, these are the additional witnesses. No, it can't be.
No, were these witnesses examined earlier?
Yes, but 30 witnesses have been examined. In
Out of the 63, 30 are repeated
Yes,
now?
30 are repeated. That is my grievance. No, my lord, I shall take your lordship next to the point that is involved in the case. Well, imagine the situation. 1 to 6 are eyewitnesses according to the prosecution in the original charge sheet. CWs 1 to 6. Well, they are examined as PWs 1 to 6. For one reason or the other, they might have supported the case of the prosecution, or they might not have supported the case of the prosecution. For one reason or the other. The very same 1 to 6 are cited as additional witnesses for the prosecution in the additional report which came to be filed. Likewise, 30 witnesses have been cited who are already examined during the trial of the case. Examined, cross-examined, re-examined, number of documents were got marked through them during the trial at the first instance. Again, the same witnesses.
1 second. Were these 30 witnesses or these 30 witnesses deposed something else in the charge sheet or before the CBI, contrary to what they had deposed before the state?
The only thing they would say is, whatever I have said earlier is false.
They have deposed differently. Alright.
Differently in the sense like that.
I'm just clarifying my,
Please,
what is
please.
running in my
No,
mind.
I'm glad to
Yes.
submit your lordship
Yes,
the
yes.
doubts. Well, as I submitted your lordship, what is the procedure which the trial court is required to follow? Would it be under section 230 and 231, or would it be under section 217?
217.
Well, may I just request your lordship to kindly have a cursory look at section 217?
Yes.
What the trial court is required to do, no sooner the charges are either altered or added.
Recall or resummon?
No. This is the language that is used is, kindly
Yes.
have a look at.
Yes, sir.
Whenever a charge is altered or added,
After, yes.
that is what your lordship would find under section 216 subclause 3,
Yes.
as well as under section 216 subclause 4.
Yes.
Here is a case of either alteration of a charge by way of addition or alteration independently. Whenever a charge is altered or added to by the court, after the commencement of the trial has commenced,
Yes.
charges are altered
Mm.
either by way of addition or by way of subtraction, the prosecutor and the accused shall be allowed to recall same witnesses, recall them, continue to record further evidence, if any, vis-a-vis the additional evidence, as my lord has pointed out, which the new investigator would collect during the course of the further investigation of the case under section 173(8). Come on, examine them.
Yes.
To recall or resummon and examine with reference to such alteration, or addition, any witness who may have been examined, unless the court, for reasons to be recorded in writing, considers that the prosecutor or the accused, as the case may be, desires to recall or re-examine such witnesses for the purpose of vexatious delay and all. I have no objection. I would never object. I have not objected. Come on, examine them, recall them, make an application. Look here, some additional supporting.
So the crux of the submission is, What is open is 217, not 230 and 231.
That would be my first submission.
Yes.
My lord, if it is 230 and 231, I shall take your lordship to a couple of judgments of the Supreme Court. My lord, what it says is, if it is a case of new trial, if it is a case of fresh trial, if it is a case of retrial, if it is a case of de novo trial, my lord, the effect is whatever the proceedings that have been
Get
recorded
defaced.
gets wiped out. Totally it gets wiped out. I can't place reliance on, although the learned judge has given a concession to me,
He says it's
but that is contrary to law. He gives a concession to me. Look here, you don't worry, I will look into those things also. No, he can't do it. That is contrary to law.
exactly why I asked what was the difference between the state charge sheet and the charge sheet filed by the CBI and other things, because he says he will look into that also. Yes.
That is, but he can't look into it. When once the law laid down by the Supreme Court as well as by this court and various other high courts is that when once a new trial, new trial is fresh trial, de novo trial, retrial. But when once a new trial takes place, whatever that has been recorded earlier, including the evidence, gets wiped out. That would cause prejudice to the accused.
No, but
Not-
that is not in a proceeding pursuant to 2164 or 217 or 230 or 231.
I shall take your
That
lordship.
that is in an appellate forum when
No, no.
when it is ordered for a new trial, the entire thing gets,
No, my lord.
or even under 214.
Yes, I shall take your
214.
lordship,
That's-
even under 216,
Actually,
four
that's
also, I
all.
shall take your lordship to that.
Then that is beneficial to you. Then
Yes,
why are you?
certainly, my lord. I shall take your lordship to that.
No, that finding appears to be beneficial to you.
Obviously, obviously. My lord, may I just request your lordship? Well, the first judgment, on the point the other day, I drew my lord's kind attention. Good. Please give it. I may not trouble your lordship much on this.
Yes, sir.
But this is a full bench judgment of the Supreme Court. But may I just request?
Under 386.
But that is almost analogous. Here also the same thing, there
No,
also.
that is what I asked. If
Yes.
under 386, everything gets wiped out, or under subsection 4 of section 216, everything gets
Your
wiped
Lord,
out.
one after the other, I shall take your
Yes.
lordship. First judgment, which I would like to draw my lord's kind attention is, have a look, kindly turn to paragraph 20.
Yes, sir.
Well, before I take your lordship to paragraph 20,
Hmm.
it would be useful for me to draw my lord's kind attention to paragraph 19,
Hmm.
because their lordship would refer to section 386.
Yes.
Well, let the prosecutor bring to your lordship's notice a single judgment which would indicate
Yes, sir.
that the evidence that has been recorded earlier or the proceedings which came to be recorded earlier
Yes,
to
sir.
the altered or the amended charge would keep the evidence that has been recorded intact. I'm happy. The courts would say no. Have a look at section 300, paragraph 19 at internal page 109.
Yes, sir.
My lord, I shall just
109.
skip 386.
Yes, sir.
Take your lordship to paragraph 20,
Para 20.
paragraph 20 at page 110.
Yes, sir.
The scope of the power of the appellate court, my lord, as my lord has pointed out, is the
Yes.
power under section 386.
86.
386. To direct a retrial has come up before this court for interpretation in several decisions. Here, instead of retrial, what the language that is used under section 216 subclause 4 is a new trial. Instead of retrial, what is used is a new trial.
New trial.
The judgment of a constitution bench in Karnataka versus state of Maharashtra has dealt with the issue extensively. In that case, the appellant was tried before the judicial magistrate for the offense of rash and negligent driving while under the influence of liquor, thereby causing the death of one person and injuries to 4 others, and for offenses under the Motor Vehicle Act. The trial judge held that the evidence was not sufficient to prove that the appellant was driving the motor vehicle at the time of mishap and acquitted him of the offenses under the Motor Vehicles Act and the Penal Code. But he held that the evidence established that the appellant had consumed illicit liquor and committed an offense punishable under section 66 subclause B of the Bombay Prohibition Act. The appellant was convicted and sentenced to imprisonment for 3 months and was directed to pay a fine. On appeal, the Sessions Court set aside the order of the trial court and ordered a retrial on the ground that a fair and full trial had not taken place. The revision was summarily dismissed by the High Court, which led to this appeal being squashed. But kindly go to paragraph 23 now, the next page. The above extract emphasizes that a retrial would not be ordered unless the appellate court is satisfied. But here also the trial court must be satisfied.
Yes.
If my lord is persuaded to accept my submission, is nothing short of a retrial, ordering retrial, because he says evidence has to be recorded under section 230 and 231. The above extract emphasizes that a retrial would not be ordered unless the appellate court is satisfied that the court trying the proceedings had no jurisdiction. Number one, the trial was vitiated by serious illegalities and irregularities or on account of a misconception of the nature of the proceedings, as a result of which no real trial was conducted. The prosecutor or an accused was, for reasons beyond their control, prevented from leading or tendering evidence material to the charge, and that in the interest of justice, the appellate court considers it appropriate to order retrial. Another feature which emerges from the above decision is, etc., is that an order of retrial wipes out from the record the earlier proceedings and exposes the present accused to another trial. It is for that reason that the court has affirmed the principle that a retrial cannot be ordered merely on the ground that the prosecution did not produce proper evidence and did not know how to prove the case.
Yes.
Well, although this may be under section 386, power of the appellate court.
Appellate court.
Your lordship could certainly draw a parallel. Despite the fact, my lord, I shall presently take your lordship under section 216(4) also, it wipes out, probably that would cut at the root of the. But the second judgment on which I am placing reliance is again that of the Supreme Court. Let kindly go to 2017, volume 12, Supreme Court cases 699.
Yes, sir.
Kindly turn to paragraph 12 and 30. But there it is de novo trial. It is here, it is de novo trial. There it is retrial.
Retrial.
In one case, it is new trial.
But
And
all,
then-
all under section 386.
No, I shall take your lordship too.
Hello, yes.
Certainly.
Those are the
What I am
judgments.
inviting,
Yes.
well, I am just drawing an analogy. Although the appellate court has got vast powers, still it can't be exercised blindly and in the most mechanical manner.
That is true.
That is what. the Supreme
Wiping
Court-
out the entire trial and saying a retrial has to be conducted, exceptional circumstances where
That is why.
the circumstances exist first.
Is it not going to cause prejudice to the accused?
True, yes.
But kindly have a look at paragraph 12. The de novo trial means a new trial ordered by an appellate court in exceptional cases when the original trial failed to make a determination in a manner dictated by law. The trial is conducted afresh by the court as if there had not been a trial in the first instance, as in this case. When he orders a new trial, under section 230 and 231 record the evidence, as if nothing has happened earlier. Undoubtedly, well, the appellate court has the power to direct the lower court to hold a de novo trial. But the question is when such power should be exercised. As stated in this case, so and so, an order for retrial of a criminal case is made in exceptional cases and not unless the appellate court is satisfied that the court trying the proceedings had no jurisdiction to try it, or that the trial was vitiated by serious illegalities or irregularities, or on account of misconception of the nature of the proceedings. And on that account, in substance, there had been no retrial, or that the prosecutor and accused was, for reasons for which he had no control, prevented from leading or tendering evidence material to the charge. And in the interest of justice, the appellate court deems it appropriate, having regard to the circumstances of the case, that the accused should be put on his trial again. An order of retrial wipes out from the record of the earlier proceedings and exposes the person accused to another trial, which affords the prosecutor an opportunity to rectify the infirmities disclosed in the earlier trial, and will not ordinarily be countenanced when it is made merely to enable the prosecutor to lead evidence which he could but has not cared to lead, either on account of insufficient appreciation of the nature of the case or for the other reasons. This court in the state of UP was so and so, while dealing with the question whether the High Court should have quashed the trial proceedings only on account of declaration of the legal position made by the Supreme Court concerning the procedural aspect about the cases involving offenses under so and so. A de novo trial should be the last resort, and that too only when such a course becomes so desperately indispensable. It should be limited to the extreme exigency to avoid a failure of justice. Observing that any omission or even the illegality in the procedure which does not affect the core of the case is not a ground for ordering a de novo trial in the state of Madhya Pradesh, etc. But the latest statement of the Supreme Court, the point just about, but it is,
Sunita Devi,
but this is in 2020.
2024.
Yes, Sunil Devi.
Ah.
Sunil Devi. Kindly turn to paragraph 22. The appellate court has got the ample power to direct retrial. However, such a power is to be exercised in exceptional cases. The irregularities found be so material that a retrial is the only option. In other words, the failure to follow the mandate of law must cause a serious prejudice, vitiating the entire trial, which cannot be cured otherwise except by way of retrial. Once such a retrial is ordered, the effect is that all the proceedings recorded by the court would get obliterated, leading to a fresh trial, which is inclusive of the examination of witnesses.
Yes, sir.
Well, their lordships would quote under what circumstances a retrial could be ordered.
Exceptional cases.
Not only in paragraph 33.2 to 33.5
Yes,
A, B, and C. Well, now, your lordship posed a question to me. What is the law laid down while dealing with the power of the court under section 216, be it subclause 3 or be it
Yes.
subclause 4? Well, this is what the Supreme Court would say. May I invite your lordship's kind attention to the judgment of the Supreme Court in 2013, volume 7, Supreme Court cases 256, in the case of Jaswinder Saini and others, at page 120.
120.
120, ink page 120.
That's where 304B was substituted to 302 without following the procedure. So 302 was quashed.
No. What they say is,
No, 302 charge framed under 302 was quashed, matter was remitted back.
well, what the Supreme Court would say is,
Yes.
when the court exercises jurisdiction under section 216, what is it that the court is required to follow? An alteration is made,
Yes.
an amendment is done,
Yes.
a fresh charge is framed
Yes.
under section 216 subclause 4.
Yes.
Well, what is the procedure which the court is required to follow after that addition or subtraction? May I just request your lordship to kindly turn to paragraph 10?
10 to 16.
I'm sorry, man.
Para 10 to 16.
No, para 10 to
Entire law.
16. Para 10.
Para 13 and 15.
Yes, my lord, this would be useful if I draw my lord's kind attention to para 10 first and then
Yes, sir.
para 11. I shall stop at that.
Because 10 they extract 216.
Yes, 216.
And 11,
Any-
what is the
yes.
purport?
What is the purpose? Any court may alter or add to any charge at any time before the judgment is pronounced. Or if the alteration or addition is such that proceeding immediately with the trial is likely in the opinion of the court is prejudice the accused or the prosecutor, as aforesaid, the court may either direct a new trial or adjourn the trial for such period as may be necessary. 11, well, this would be important. A plain reading of the above would show that the court's power to alter or add any charge is unrestrained, provided such addition and / or alteration is made before the judgment is pronounced. Subsections 2 to 5 of section 216 deal with procedure to be followed once the court decides to alter or add any charge. This would be important. Section 217 of the code
Yes.
deals with the recall of the witnesses when the charge is altered or added by the court after the commencement of the trial. In this case, the trial has already commenced.
True.
Now, during the pendency of the trial, my lord, the trial, as my lord is aware, continues till the judgment in the case is delivered.
Yes.
It was at that stage, my lord, they would come out with this additional report. And on the strength of this additional report, my lord, the charges came to be altered. But then, when once the charges are altered, in exercise of the powers clothed upon the court under section 216, subclause 3 or 4, the procedure which the court is required to follow is not under section 230 and 231, but it would be only under section 217. Section 217 of the code deals with the recall of witnesses when the charge is altered or added, not under section 386.
No, there is not necessary.
But now,
There, power of the appellate court is in a different circumstance when it
now, my
is
lord,
before
this,
it.
the law which came to be laid down by the Supreme Court is not under section 386, but it is under section
216(4).
216 and 217. Section 217 of the court deals with the recall of witnesses when the charge is altered or added by the court after the commencement of the trial. There can, in the light of the above, be no doubt about the competence of the court to add or alter charge at any time before the judgment. But here, the court has the power not only to order the recall of the witnesses whom the prosecution proposes to examine them further vis-a-vis the additional charge or the altered charge. It can also summon
Yes.
the new witnesses under section 217.
Yes.
But your lordship posed a question to me, whether when one of the order is passed under section 216 subclause 4 a retrial, does it wipe out the evidence that has already been?
So that finding is not there in
No,
the
I shall take your lordship to the next judgment, to the next judgment.
Rachaya's case.
ಹೌದು, ರಾಚಯ್ಯ's case.
ಹಾ.
ಅದು ಇದೆ.
ಅದರಲ್ಲಿ
ಆಮೇಲೆ
ಪ್ಯಾರಾ
ಅಲ್ಲ,
10 to 15 also you don't get that finding.
ಇಲ್ಲ ಇಲ್ಲಿದೆ ಅಲ್ಲ ಉಮೇಶ್ ಕೇಸ್ ಇದೆ, ಆಮೇಲೆ ಒಂದು ಎರಡು ಜಡ್ಮೆಂಟ್ ಎರಡು ಸೆಂಟೆನ್ಸ್
Yes, sir.
ಇನ್ನೇನಿದೆ. Kindly go to this Rachaya's case in paragraph 11.
Yes, sir. In fact, para 10, last two lines.
ಹೌದು.
A new trial is insisted if the charge is altogether different and distinct.
ಹೌದು.
That is one thing.
ಹೌದು.
Now, according to you, different and distinct alveoli, it is only,
ಅಲ್ಲ,
Allah, that is submission.
B.
So para 11 is what is the procedure to be followed under 217?
Even if the charge may be of some species, the provision for adjourning the trial is made. Well, I submitted your lordship little earlier. He has two options. One is either order for a new trial or adjourn the case. When not consequent to the every addition or alteration,
Material alt.
where the court is of the opinion that recording of proceedings then and there, consequent to the addition or alteration, may cause prejudice either to the prosecutor or to the accused, then only my lord he can order a new trial or adjourn the case. Otherwise, he has to fall back upon 216 subclause 3.
Yes.
As well as the accused shall be allowed to recall or resummon or examine
Yes.
any witness who have already been examined with reference to such alteration or addition. In such circumstances, the court is to even allow any further witness with the court thinks to be material in regard to altered or additional charge. This is the procedure which the court is required to follow, and certainly not, my lord, at any rate, section 230 and 231. Well, the
Yes.
next judgment is
Umesh Kumar.
Umesh Kumar. Kindly turn to paragraph 27 in Umesh Kumar's case. Para
Yes, sir.
27.
Yes. No, that more deals more with 173.8.
No, my lord, here.
ಅದರಲ್ಲಿ only last two lines.
ಅಲ್ಲ,
of
ಇದು
para
ಅಲ್ಲಲ್ಲ,
27.
173(8) ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಶೀಟ್.
ಹೌದು, additional charge.
ಇದರಲ್ಲಿ ಈ ಕೇಸ್
ಹೌದು, ಇವ್ರು ಹಾಕಿರೋದು.
ಇವ್ರು ಹಾಕಿರೋದು ಅಷ್ಟೇ.
Supplementary report.
My lord, in this paragraph at page 607, first paragraph, kindly
Yes, sir.
page 151,
Yes,
just about 5 or 6 sentences above the first paragraph.
yes,
In case charges are framed,
yes.
the accused has to face the trial. Charges can be added / altered at any stage of the trial before the pronouncement of the judgment to see through the evidence adduced before the court under the provisions of section 216 CRPC. The only legal requirement is that the witness has to be recalled as provided under section 217 when a charge is altered or added by the court. No other option. Recall. Examine them afresh. But in this unreported judgment of the Supreme Court, which came to be delivered just quite recently, my lord, about 2 months ago, in the case of Madhusudan,
Para
State-
21.
state of Madhya Pradesh, para 20.
Yes.
Para 21. The case materials nowhere indicate that the court intended to alter the charge, and it is unlikely that the altered charge was formally framed. But the facts of that case.
Yes, that case.
Read out and explain to the accused. A court may alter or add to any charge before judgment is pronounced But when charges are altered, opportunity must be given under section 217 of the CRPC, both to the prosecution and the defense, to recall or re-examine witnesses in reference to such altered charges. That is the only options that is given to either to the prosecution or to the accused. Well, a coordinated bench of this honorable court, I would respectfully submit,
Para 8 and 9.
did not go in depth.
Para 8 and 9 it is said.
In depth into the issue that is involved.
Yes.
But what his lordship would say is, para 8, my lord,
Yes.
from a reading of section 216 and 217 of the CRPC, it can be said that it is only the trial court which can so much to exercise the power under this provision of law. And power under this provision of law cannot be exercised in the instance of the accused or the complainant. If the provision of law does not provide any specific right to the parties, such a right should not be read into the provision of law by the courts, unless the court is of the view that if such a right is not conferred on the parties, there is likelihood of failure of justice. Abuse of legal procedure is one of the major factors for delay in disposal of cases. But here, again, 135 witnesses, including all those witnesses. Unless the courts dispense with such procedures, which are totally unnecessary and causes no prejudice to the parties if they are dispensed with, it would not be possible for the courts to take effective steps for speedy disposal of cases, providing fast track code, etc. Para 9. Section 216 of the CRPC provides that courts can alter or add any charge at any time before the judgment is pronounced. Section 217 of the CRPC provides that whenever a charge is altered or added by the courts after commencement of trial, well, a trial had commenced, charges are altered or added, the prosecution and the accused shall be allowed to recall or resummon and examine the witnesses with reference to the said alteration or addition of charge, and also call any other further witnesses whom the court may think to be material. Therefore, in the event the court alters or adds to any charge at any time before the judgment is pronounced, the prosecution as well as the accused gets a right under section 217 of the CRPC to recall or resummon the witnesses, and in addition to the same, even further witnesses may be summoned whom the court may think to be material after the trial has commenced. In the event the court exercises its power under section 216 CRPC, then under the normal circumstances, the trial is likely to be delayed for the reason that the accused and the prosecution are likely to exercise the rights provided under section 217 of the CRPC. Therefore, the court should be very conscious of this aspect of the matter, and unless and until the court is satisfied that the material evidence placed before warrants exercise of the power under section, well, that is prior to the passing of the order. Now that an order is passed, probably that may not be applicable. But what happens, this your lordship would get when an order is passed under section 216 subclass 4, where it erases the evidence. That your lordship would get in this, in Harishankar's case. Kindly turn to paragraph 18 at page 187. Para 18.
Yes, sir.
In the case of Gaurav Agarwal versus State so-and-so, whereby it was observed as undone, it bears repetition to say that the Code of Criminal Procedure does not provide for recording the plea of the accused in answer to the charge framed against or notice of acquisitions put to him more than once. If the accused pleads not guilty, or if his plea of guilty is not acted upon, and the prosecution is called upon to furnish proof of the guilt, the procedure prescribed for trial, resulting eventually in judgment based on evidence, is to follow. This holds good even if the charge is altered in terms of section 216 CRPC. If after the addition or alteration of charge, the court is of the opinion that prejudice is likely to be cast to the accused in his defense on account of such alteration or addition, it may direct a new trial in terms of section 216(4) of CRPC. It is inherent in this that the procedure applied and the proceedings recorded anterior to such stage stand affairs on account of the direction for the de novo trial. Necessarily in such event, the charge or notice will have to be framed again.
That is following earlier High Court, judgment of Delhi High
To
Court.
the High Court. Well, this is again under section 386, probably it may not be necessary.
Yes, sir.
Well, now, apart from this, I have also raised one serious and important issue. The procedure which the trial court is required to follow, and it is not in terms of the guidelines as laid down by the Honorable Supreme Court. Well, in the case of criminal trials and guidelines regarding
that-
inadequacies and deficiencies.
Three-judge bench, yes.
Justice Nageshwar Rao,
2021. Good of-
2021, volume 10 Supreme Court process. Well, I invited my lord's attention to paragraph 17.
Yes.
My lord, what is the procedure which the trial courts are required to do it? First have, my lord, virtually nothing short of saying a conference between the court, the prosecutor and the accused, formulate the procedure, eyewitnesses, examine them. Then, my lord, circumstantial evidence, if any, examine them. Then, my lord, expert evidence, then forensic science, then, my lord, immaterial, inconsequential punch witnesses and all. Well, in the instant case, what happens is, but have a look at, first you would file a list of witnesses.
This last judgment in the compilation,
Yes.
that appears to be a little useful. Division bench of Allahabad High Court,
Yes, ma'am. Yes, ma'am.
where
Paragraph 25, 26 and 27.
no, starts from paragraph 21
Yes.
up to 26,
Yes. Let
Where-
me see.
where 216 is explained.
26 only, my lord. I'm sorry, I lost sight of it. I'm grateful to your lordship for having
That's what.
drew my
in
attention.
Para
But para-
26, 27,
It's very,
28.
very, well,
If you-
directly, on the-
this
kindly
is-
have a look.
this
After
is the
framing of
procedure.
additional charge under section 302 and section 34, the
Yes.
court has to follow the procedure as provided under section 217 CRPC. Their same reads as follows. And at 27,
Yes.
the intention of the legislature in framing section 217 CRPC is to the effect that an amendment of the charge after witnesses have been examined, as in this case, may prejudice either party unless it is allowed to call fresh witnesses or to re-examine or cross-examine further the witnesses who have already been examined.
Yes.
An opportunity to be given. This is what
Yes.
illénaಗಿದೆ ಅಂತಂದ್ರೆ what they do is, you'll prepare a list of witnesses, you'll file the list of witnesses. May I request your lordship, the court would accept it. Court would accept it. Then, my lord, at the instance of the prosecution, at no point of time the accused had sought for an adjournment. In this case, that is apparently evident from the proceedings sheet of the case. I am not on that issue at all. I am on the issue. He files a memo.
But one more clarification. Sorry to pause you in the flow. But now there is material alteration in the charge because of the charge sheet filed by the CBI. Charges are now reframed, sought to be reframed, altered now because of the charge sheet filed with CBI.
Sure.
Should they not be given an opportunity to prove their case?
Certainly, undoubtedly.
Yes.
That is why, my lord, I said 30 witnesses who are already examined are the witnesses.
So
in there.
those 30 witnesses,
Recall them. Under section 217, you can
and
recall.
remaining you examine.
Remaining, 217 itself provides fresh witnesses, examine them. Instead, here, my lord,
No, if fresh witnesses are to be examined, procedure is under 230, 231 or
No.
217,
under section 217,
only on 217.
only under section 217.
Yes.
Matter, 230, 231.
No, that's what, clarification.
Yes, I'm sorry. Well, here, what happens is this. Well, my lord, kindly, I shall just give you, your lordship, one simple example. One witness came to be examined as PW1 during the earlier trial
By the state.
by the state.
Hmm.
Normally, the same witness in the list, his name would find a place
In the new list.
in the new list.
Is that the witness has contradicted his earlier statement with the state, with the CBI now?
But I shall submit your lordship now. I'm on this point, procedure. But he is given a different number.
No, true, but has he contradicted his own statement?
Halfway through, his evidence was stopped. Then a fresh list is filed. That is my grievance.
If he has contradicted,
But
should he
the-
not be questioned now?
No, halfway through his evidence has been stopped. What I'm saying is,
In the same, now,
no, my lord, during the subsequent trial, after the charges are amended, he was summoned before the court.
All right.
He was being examined in chief. For some reason or other, solely for the reason that the statement of this witness, which came to be recorded under section 164, was not immediately available in the record of the case, he was bound over. He was adjourned. The case was adjourned. He was required to appear before the court on the next date of hearing. He appears. Further examination, chief, is not done. Instead, they will file a fresh list of witnesses. Who are those witnesses?
Same witness.
No, a large owner, a punch witness, a motive, a man who participated in some meetings of the Jilla Panchayat. They have already filed the list, 6 eyewitnesses. Examine them further. Why? But the defense would have kept themselves ready vis-a-vis the list of witnesses which they have filed, who are present before the court, who are bound over by the court for their appearance on the next date of hearing. The defense would keep themselves ready to go on with the case.
Yes.
But here, they are present. One witness is halfway through, examination in chief. No, they would stop. But although it is said that the prosecution is the master of its case, but ultimately it is the court that controls the trial. The court should have said, they said, look here, you have examined one witness, an eyewitness, who was examined earlier as PW1. Now you want to examine him in the new trial. Earlier PW5, now he becomes PW1. Who could it be? But continue. PW5, you have summoned him. Continue. Further examination in chief. That is what is mandated or provided under section 217. Well, this procedure that is being followed by the trial court is unknown to law.
Yes.
Although the prosecution is a master of its case, still, my lord, as
So procedure cannot be given a go by.
cannot be given up. ಅಲ್ಲ ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಟ್ಟು ಇವ್ರನ್ನ ಸಮನ್ ಮಾಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ಗೆ ಅಂತ ಹೇಳಿ ಅವ್ನು ಬರ್ತಾರೆ ಎಲ್ಲ ಬರ್ತಾರೆ ಇದಾರೆ ನೋ ನೋ ವಿಲ್ ನಾಟ್ ಎಕ್ಸಾಮಿನ್ ದೆಮ್ ಒಬ್ಬನ್ ಮಾಡ್ತೀನಿ ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಮಾಡ್ಬಿಟ್ಟು ಮತ್ತೆ ಅದನ್ನ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಬೇರೆ ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಡೋದು. I have produced the list also. But that is impermissible. That is contrary to the guidelines with the apex court has
2021.
which your lordship would find in paragraph 17 of this 2021.
Yes.
But this would be my respectful submission.
Yes, sir. Anything you have to add? Add. Yes.
Reading 260. Transpired. Special CC 50 was pending before the 3rd additional district court. And the matter was referred by the government to the state government for, sorry, CBI.
This was 5 years ago, 2019.
I will not question. But I will narrate the fact. But the first additional charge sheet, this arrested some additional actions and produced before the 3rd additional court. Thereafter, in the 2nd additional charge sheet, they arrested one MLA. But MLA was produced before the 3rd additional court. At that stage, the registry of the city civil court writes a letter to the 3rd additional to transfer the case to the 82 additional court because of the involvement of an MLA. Now, the order sheet continued, proceedings continued. When the
Transfer agide ashte.
transfer again. When the matter was set down for evidence, I filed a memo. You cannot start the witness number from 1. Either if the witness is already examined, you will have to file an application for recall them and
ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಆಗೋಗಿಲ್ವಾ ಸರ್?
ಅದೆಲ್ಲ ಮುಗ್ದಿದೆ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಗೆಲ್ಲ ಹೋಗಾಗಿದೆ.
ಈಗ ಇವ್ರು ಕೇಳ್ತಿರೋದು ಏನು ಅಂದ್ರೆ ನಮ್ಮನ್ನ CW1 ಅಂತ ಮಾಡೋದಕ್ಕೆ ಅವಕಾಶ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಿರೋದು. Then they examined him, the very same witness who was examined as PW4 earlier. Now he is examined as PW1. And number of documents are marked, number of memos are marked. With the same memos and same witnesses are given different numbers now. Now what I requested the court, let them file an application to recall them and examine with reference to further steps.
217.
217. That is the request I made to the court. Then, my lord, the objection filed by the CBI, your lordship, kindly have a look at, I have produced in my writ petition. They wanted altogether a de novo trial. That is the prayer. It is
ಇಲ್ಲ,
submitted.
prayer ಏನಾರು ಇರ್ಬೋದು. What is the court done?
That is what the court has done. Now.
No, 230 and 231 court has done.
Yes, now
That's
bit of
senior
one is
argument.
exams. Now 216 ಬಗ್ಗೆ ನಾ ಎರಡು line ಹೇಳಿ.
ಆಯ್ತು, yes.
Lordship may kindly see. The alteration of charge under 216 will arise. For three circumstances. One, by the suo motu by the. And when the additional accused or additional material are brought in under 173. This is the case. Or under 319 when the additional accused is included by the court by in excess of over under 390. Here, my lord, the additional accused are added. Once the additional accused are added, my lord, even in 390, it is specifically mentioned that the witnesses will have to be examined afresh only with reference to such accused. And with reference to the new trial, what your lordship has asked. Sorry, the lordship has read the Rachaya's judgment. There in para 10.
Yes, para 10,
Last line your
10 to
lordship has
16,
read.
last,
Yes,
last two lines.
where it is said the charges are distinct.
Yes.
Lord, what is
New
distinct
trial is to be held only if the charges are different and
and
distinct.
distinct? Lord, your lordship may kindly have a look at page 165, the judgment of Banwarila.
Yes.
I have given. Para 30. The question is, what is meant by every distinct of it? Distinct means not identical. It stresses characteristics that distinguish. While the word separate would stress the two things not being the same. Two offenses would be distinct if they be not in any way interrelated. But in this case, the charges are not distinct. 302 remains same.
That is why Supreme Court says 233 proceeding is correct and nothing wrong, nothing foul can be found of it. But they have explained what is identical, what is distinct. That is too rudimentary, sir. We'll do it.
My submission is it is not a distinct.
It's all right.
To have.
Because if you have to read last two lines of para 10 in Rachaya's judgment with this, whether it is distinct or not.
Yes.
A new trial would be necessary only if the charges are different and distinct.
Even 319.4, Lordship may kindly have.
319.4 is when you recall the witness.
Recall, when the additional accused are added.
Additional, that's what, when the additional accused are added during the trial.
Yes.
Who have been dropped or otherwise, bringing them back into the web of proceedings.
Yes.
Then what is the procedure to be followed is
Same situation is here.
the trial is to commence from there and evidence will have to be recorded from there, not a new trial.
Here,
No, 319.4 is not a new trial at all.
Here.
It is only drawing few accused.
Here, same situation. That is the reason I am relying upon 390. Because Lord, the earlier evidence also, they are not saying they are not the witness. They are very same witnesses, they are examining.
319.4, the Supreme Court in Constitution bench has said, what is the impact upward? Sukhpal Singh Kaira, yes, in that judgment. If you see para 42 in that, about 10 postulates are laid.
Yes.
In those 10 postulates, Supreme Court says that it is not a new trial, but a continuation of a trial that is already pending.
Regarding examination of witnesses.
Also
para
that is
33,
said,
para
yes,
33.
yes.
That's.
ಬೇರೆ ಅದಾದ್ಮೇಲೆ 4 ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ 319.4. Yes, sir.
But I have tried to make, I just will not pass on. I showed a copy on the other side, straight, sir.
My letter to Mr. Prasanna.
Sir.
Next beginning. Kindly permit me to.
ಅಲ್ಲ ನಾನೇ ಹೇಳ್ಬಿಡ್ತೀನಿ ಸರ್. ನಾನು ಹೇಳೋದೊಂದು ನಿಲ್ಲಿಸ್ಬಿಟ್ರೆ ಆಮೇಲೆ ನನಗೇನು ಹೇಳಕ್ಕೆ ಉಳಿಯೋದೇ ಇಲ್ಲ. ಇದೊಂದು ಕೂಡ. Distinction between the first and the second one, I prepared a chart. Which also has been incorporated in the objections itself.
Objections ಇದೆಯಾ ಇದು?
Objection same copy ಮಾಡಿದ್ದೀನಿ. This is not ready reference.
Really, our statement of objections only one sentence ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ. ಅವರು 216, 217 ಎಲ್ಲ ಏನು ಹೇಳೋದೇ ಇಲ್ಲ. Only they speak of merits. We collected this evidence, we collected that evidence and all that. Let them collect anything. And kindly turn to paragraph, ink page 36, paragraph 38. Even how far your lordship would countenance, or does it warrant any action at your lordship's hands against the investigator in the case?
The thing is, everything is now upheld by the Supreme Court.
ಅದಲ್ಲ ಇದು ಇಲ್ಲಿ 36. But I am not on those things at all. Now I am only basically in the.
So
Not the
the
merit-
only thing I have to answer is 230, 231 or 217.
ಅಷ್ಟೇ ಇನ್ನೇನ್ ಇಲ್ವೇ ಇಲ್ಲ ನಾನು ಅದಕ್ಕೆಲ್ಲ ಹೇಳ್ತಾರೆ ನಾನು ಇಲ್ಲಿ kindly go to paragraph 38, ink page 36, first paragraph, last three sentences.
Para 38.
Para
Which
38,
page?
ink page 36 of the counter. Does it warrant action against the investigator or not is a question now.
Prosecution as well as the accused
No, my lord, it is
takes up a fresh trial in the case.
it is submitted that the material on record would also indicate that the trial conducted so far was
Perfunctory.
was stage managed, Taylor and parties on trial. And who, against whom he is making such a serious.
The state investigating agents.
Who are now accused, in this very
No,
case.
I'm
Trial.
sorry.
Are you
Sorry.
saying? No.
You are not making an allegation, you are making allegation with the court. Trial.
Rashmi, kindly come.
Trial is conducted not by the policeman.
Alla, para 38, sir. Para 38.
Yes, my lord. It is submitted that the material on record would also
ಪೂರ್ತಿ ಓದಿ
indicate
ಅಂತ.
that the trial conducted so far. Trial police nವರು ಮಾಡೋದು, court ನವರು ಮಾಡೋದು trial. What is this? Lord, I don't think your lordship should allow all these things to happen. Let them not go scot free.
What is this?
What is this, my lord?
Allala, Prasanna Kumar sir.
Not probably.
Record,
allegation.
alla, probably alla.
No,
Indicate that the
using
trial
kind of process,
conducted so
indicate
far,
no end of itself.
alla,
What is this?
trial conducted so far was a stage managed, tailored and partisan trial.
This is not to indicate
Trial.
the role played,
Trial
the
ಅಂದ್ರೆ
role
police
played,
ಮಾಡ್ತಾರಾ?
the role played by.
ಮಾಡೋದು trial.
ಅವ್ರು ನಿಲ್ಸಿದ್ರೆ ನಾನು ಹೇಳ್ಬೋದು.
ಹೇಳಿ.
ಅಲ್ಲ.
ಅಲ್ಲಲ್ಲ, it pains me a lot.
Alla, this, why did you use the word trial?
Not the role,
Conducted by the court.
the role played by not the state agency.
You should have been.
For now
clear.
the accused.
You should have been clear in that.
Not therefore, that's what I have said in the previous not lines. In the not a reading of not this paragraph number 38, not in its entirety would indicate,
That's
not
all
my
right.
not
Why should you
statement
use-
was against
use
the
the trial?
state investigating officers, but I have clearly stated, Lordship will find not the second line.
No, perfunctory ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರಿ.
Investigation
ಅದೆಲ್ಲ
conducted
ಆಯ್ತು.
with the state police.
ಅದೆಲ್ಲ ಆಯ್ತು. Why did
Allegation
you?
was, the allegation not
Trial
here in this.
conducted so far is partisan and what do you
Allegation,
mean by
no,
that?
my submission is allegation in this paragraph is purely against,
But it is
not
this
the
IO
officers.
It is this IO who had secreted this PW5 and took him and kept him in his jeep. Although he was summoned before the court, then later he appeared before the court. He said, IO had kept him with me. What do I do? But this calls for your lordship's. See, this you are casting aspersions on court. In court, what did the court do? Tell me, sir, what did the court do? Did the court
But I have made myself
indicate
clear.
trial conducted so far was stage managed? Trial. And then Taylor. And then partisan trial. Trial can't be partisan. Trial is trial.
Use of words very important, sir.
Of course, of course.
But this calls for some serious look at your lordship's hands in the event your lordship.
It's something more which calls for much more serious, not the interference at your hands. Not your lordship may kindly take
Yes.
chart not that I have given to your lordship.
Yes, sir.
Which is also not part of the statement of objections.
A1 is the companion petitioner,
Not
right?
your, please, not your lordship may not have been repeatedly asking. Not as to, your lordship may not kindly, may not trouble again, not with 216 subsection 4, because the order not is under section 216 subsection 4, which indicates if the altered charge by virtue of the alteration of charge, which would cause prejudice to the accused or the prosecution. Not both, not it is a
Yes,
distinction,
both.
or the prosecution, then not it shall, the trial, not the court shall order a new trial.
What did you do to say that you are prejudiced?
Not your lordship may now kindly have a look at, not the chart, not that I have now brought to your lordship, kind note how both the prosecution as well as the accused not are prejudiced in this case, not in the absence of a new trial under section 216 subsection 4. Your lordship may kindly have a look at, not accused number 1. Not in the first column, not I have stated, the role attributed may not to this accused in the state charge sheet, but he was may not stated to be an assailant. Not in the investigation conducted by not CBI, not kindly come to the second column. Not he is only a chief conspirator. The whole role may not played by this accused may not completely changes. Then may not the provisions not I have stated. Then not kindly, not similarly, accused number 2 was shown as assailant, accused number 3 was shown as, accused number 4 was also not shown as assailant. However, not all these accused persons, not they were only conspirators, not with the other, not accused persons. But after accused number 6, not your lordship may kindly will not come to the next page.
When
From
did
C-
Vinay Kulkarni come into the?
But he would come not in the, not accused number 15, not in the third supplementary charge sheet. But your
Third
lordship may not
supplementary
kindly come
charge
to, not the serial number 7. Not from serial number 7 onwards, not he, accused number 7, he is the real assailant. Not he was not even investigated, not he was not charge sheeted.
A7.
Not this A7, not who was now may not being charge sheeted, not by us. Not same is may not the role given to accused number 8, who is the real assailant, accused number 9, the assailant, accused number 10, accused number 11, accused number 12, and 13 and 14. Now, these are all the assailants who are not even investigated by the state agencies. Therefore, not in the absence of not these the actual assailants, not somebody accused number 1 to 6 are shown as assailants. Evidence is conducted, witnesses are threatened, or they are taken to Goa. Not that also not I have stated here.
Goa.
How the Goa Karkono
For threatening you take them to
witnesses
Goa,
were
is
not
it?
kept in confinement.
Allah, to threaten someone, you take them to Goa.
No, that's what not has happened here.
Amala.
Then not kindly, your lordship may kindly have a look at, not after this accused number 15. Not accused number 15, not at page number 4. But he was a chief conspirator who is not there in the first charge sheet. Accused number 16,
That is Vinay Kulkarni, is it?
please not. Accused number 16, the uncle of accused number 15, who had arranged not the country-made pistol, who was not there in the earlier charge sheet. Accused number 17 and 18, they were also not conspirators, they were not there in the earlier charge sheet. This accused number 19 and 20, not these are the accused, not the then investigating officers of the state agencies who had conducted perfunctory investigation and not had implanted this accused number 1 to 6 and filed a charge sheet. Accused number 21, not is the personal assistant.
A21.
He is the personal assistant, not of accused number 15, not who is involved.
ಇದು
not
ಬಿಪಿನ್
in handing
ಹೆಗ್ಡೆ
over
ಸರ್
money.
appear ಆಗಿದೆ.
Please,
ಅವರೇ PS
please.
fake TP. Yes.
Not
The
this
allegation.
is, not this is the first distinction where accused number 1 to 6 was shown as assailants. Not it's a totally different case, not when it comes to CBI. Now kindly come to not the comparative chart about the role of accused, motive, number of accused, other things your lordship will find, not which I have stated there. Not your lordship kindly have a look at. Not starting from motive, the role of the accused.
Then there is a whole, it's a altogether new thing that you.
Altogether new thing, which is done at the instance of not the previous investigating officers. That is the reason why not 216 subsection 4 has been invoked. Your lordship may kindly have a look at the motive, my lord. The motive, my lord, shown in the police charge sheet, not is a property, alleged property
Who
dispute.
is CW1?
Not CW1. Together. Not I have. Not he is an eyewitness, my lord, to the incident. Not kindly come to not the next page. Not I have stated. Not what he has stated now. Difference in the statements of witnesses recorded before the police and may not their 161 and 164 statement and the deposition. Not CW1. Not the statement under 161, which is recorded
CW1
by
is
CBI.
eyewitness.
Please, not. It says he was taken to Goa, kept in a segregated place where they were briefed by the advocate of the accused. Before that, he was taken to the diary of accused number 15. That's what he has now stated before CBI. And his 164 statement also is recorded, which say, wherein he says
164 also.
164 also has been recorded, who says he was threatened, not in confinement, then not tutoring by the advocates, and he was taken to Goa.
No, all that is on the merit of the matter.
On the merit
as
of the
senior said.
That is the reason
What
why.
is what is the reply to what senior has submitted?
Not the prejudice ultimately under section 216 subsection 4.
So you are prejudiced in this case.
The prosecution is all prejudice, not only the accused, it's also the prosecution.
216(4) says
Please,
so.
not. It says either the accused or the prosecution. The whole story changes. Not the CW 1, 2, 3 may not, they may be same eyewitnesses. But what they have been asked may not, what the 161 statement of those eyewitnesses recorded by the accused investigating officers, But is entirely different from what has now been recorded by us. But ultimately, the purpose of criminal trial is to find out the truth. Criminal trial is not only for the accused, but it's one the trial not is for the society. Therefore, not the prejudice not that is going to be caused, which I have narrated here, not clearly indicates not that the role played by each of these accused persons. The whole story changes. Therefore, in my humble submission, not these things would clearly indicate, the chart would clearly indicate that the prosecution would be clearly prejudiced.
Now this Vikram Ballari, who is the petitioner here,
Yes, Manoj.
he is accused number 2.
Accused number 2.
He
But he
was
was shown as
he
an
was also
assailant.
shown as an assailant.
Not he was shown as an assailant with the state agencies.
All right.
But he is not. Not here, no, your lordship kindly
The charge is
not his
framed
role.
as an assailant only.
Not charge was framed by the state, not initially as an assailant.
Now,
Now, not the charge against him is he being an associate of accused number 1, assisted the real assailants to provide logistic support and
so
surrendered
he was,
before the
he was
police.
not an assailant.
He was not an assailant and surrendered before the police, admitting the commission of crime. But ultimately, the charge, which is framed under section 290 in the contents of charge, which would indicate, kindly permit me to read section 211, subsection 1.
Yes.
Not my read,
Contents of the charge.
Every charge under this code shall state the offense with which the accused is charged. The offense means an act or an omission, not the section. This
correct.
offense will have to be stated. Therefore, the offense with which these accused persons are charged at the first instance has substantially changed and altered, not with the offense with which they are now being charged. Sections may remain. Not subsection 2, 3 may not deal with the law. If the law creates an offense, the law must be stated. Offense may not, or the law that creates as an offense may be 302. 302 would remain same. But the offense, there is a complete alteration, which necessarily would require not a new trial. That's what not the learned special judge has done.
ನಿಮ್ಗೆ ಜಡ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಯಾವ್ದಾರು?
Not the same judgment, which in fact,
Same judgment, sir.
ಇದರಲ್ಲ ಎಲ್ಲ ಪರವಾಗಿದೆ. If I permitted to not read. Ultimately, all this judgment would say, all that the courts will have to see is that there is a prejudice.
What is this? Just Dikshit sir ಯಾವ್ದು?
That is not on almost all these grounds, except not 216. But a petition was filed before this honorable court seeking quashing of the proceedings, quashing of the charge, which may not came to be rejected, may not by the learned single judge of this.
Dismissed, is it?
Dismissed.
Now the charge is framed under the, from pursuant to your charge sheet was
Please.
questioned.
That is the altered charge,
Yes.
which has now been held to be correct.
All right. Anything else?
Therefore, no, that's it.
Anything in reply, sir? Nothing.
One second, probably again, I may have to invite your lordship's attention to 216 subclause 4.
Yes, sir.
It is not the prejudice consequent to the alteration or addition or new evidence. No,
Yes, sir.
but if the alteration or addition is such that proceeding immediately with the trial is likely in the opinion of the court to prejudice the accused or the prosecution as aforesaid, then and there, charges are altered.
Subsection 3.
Subsection 3 means, to proceed as if
No.
the charges were there in the original at the,
If the alteration addition proceeding immediately with the trial
yes.
is not likely,
Not going to
is not
prejudice.
likely in the opinion of the court to prejudice the accused in his
Yes.
defense, or the prosecutor in the conduct of the case of the court may. in
Proceed
its
as if it
discretion-
was there at the earliest point of time, when the original charges came to be framed against me. Here, my lord, then and there, if proceedings can't be recorded any further, no sooner the addition or alteration is made, because that is going to prejudice, because the time, it is the time factor. What is indicated under section 216 subclause
This is
4
what
is,
Supreme Court says in speedy trial, that's
Speedy trial.
judgment.
That's it.
2021.
That's it. Here, he gets two options. Well, supposing that you feel that if I were to proceed to continue to record further proceedings in the case then and there, consequent to the alteration or consequent to an addition, then my lord, go for a new trial. Or you adjourn the matter. Why
Yes.
for a new trial here? Adjourn the matter. He has adjourned it by 1 month.
But 230, 231 is ordered.
What, ಹೇಗಿದ್ರೆ have the cake and eat it too. I am going to look into it. Don't worry. It is on record. it will not get effaced. But it should be under 230, 230.
None of them should be prejudiced.
That is all my grievance before your lordship in this case.
Yes. Yes, next.
Next,
Since Prasanna Kumar has said, because there is a different report by the CBI, it has caused prejudice. But that issue is discussed in the Vinay Tyagi's case. Exactly similar fact, there were two reports.
Vinay Tyagi was 173(8).
Exactly.
Further investigation, handing it over to the
Investigation or
CBI.
further
Same,
investigation.
same thing here.
Further investigation, handing it over to the
That's only
CBI.
difference. Their trial had not commenced. Here
That's
trial
why.
has commenced.
Their trial has not yet been commenced. So Supreme Court says why in such circumstances CBI should be bought in. That's all. Vinay,
Not
on
only-
further investigation.
What happens to both the reports ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಎರಡು ರಿಪೋರ್ಟ್ ಇರ್ಬೇಕು. Then Malad court, your lordship kindly have a look at para 61.
All right.
Court has to proceed further ಅಂತ ಹೇಳ್ತಾರೆ. They have, both the report has to be taken and proceed further. ನಮ್ಮ argument is then ಇಲ್ಲಿ. They will have to proceed further from the stage where it is stopped.
All right. Yes, heard the learned senior counsel C.V. Nagesh, learned counsel Nagendra Nayak appearing for the petitioners and counsel Prasanna Kumar reserved. Yeah, next date ಯಾವ್ದಲ್ಲಿ?
The second.
22nd?
This month.
This month.
22nd. Oh,
Not anyway, but
Yes.
if we
ಅಲ್ಲ,
cannot
ಅವತ್ತು
happen
ಬೇಕಾದ್ರೆ-
before that date,
No.
I'll.
ಇಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಬೇಡ. ಅವತ್ತು ಬೇಕಾದ್ರೆ my lawyer friend could
Yeah, you-
on that day tell
in case,
the court.
in case I,
Yes,
would-
that
in
is-
case I have not pronounced.
Go for another 1 week attendance.
Yes, that's all. Maximum ಅಷ್ಟೇನೆ. Yes, heard reserved. I'll try to pronounce it. We'll try.
No, I don't know anything ಅಂತಾರೆ. ಇನ್ನೂ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ. He must properly instruct you.
I'll try to pronounce by then,
Please.
but ask him to hold his
Please,
hands. Yes.
ಅಲ್ಲಿ
Yes.
ಮುಂದಕ್ಕೆ ಹೋಗುತ್ತೆ ಅಂತ ಅಂದ್ರೆ.
Yes. Heard reserved.
ಸಾರಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಇತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ವಿ ನೋ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಈಗಲೂ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಬಂದಿದೆ ಸೊ ಸ್ಟೇ ಇಲ್ಲ ಅದರಲ್ಲಿ ಕೈಂಡ್ಲಿ
ಪರವಾಗಿಲ್ಲ 4-9 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕಿದ್ದೀನಿ.
ಶಾರ್ಟ್ ಡೇಟ್
Shortest date. Yes. Next, call the case now.
ಗ್ರೇಟ್
Number 2, being spoken to still number 1.
Yes, Mabaleshwar sir, ಏನು?
Kindly go to.
ಏನಾಗಿದೆ?
ಇದರಲ್ಲಿ just convince your lordship, page number,
No, wait, what do you want to speak?
page number 15.
ಹಾ,
This is a complaint filed before the 437.
ಅಲ್ಲ ಈಗ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಡಿ, ಏನ್ ಹೇಳಿ? Being spoken to ಬಂದಿದೆ.
Earlier your lordship is referred the interim order granted in the another case.
ಹಾ,
But now I sought the interim order of the case filed before the ACMM, the same complaint, same allegation. Now there is a one case before the Tirthalli.
this court on 6/8/2024 had passed the following order que accused number 7. There appears to be an error in quoting the order so passed, in quoting an order that was already passed. Therefore, there shall be an interim order of stay as prayed for in the subject case till the next date of hearing. Yes, ಅಷ್ಟೇನಾ? Yes. Next,
Fresh matter still number 2.
mediation report.
Yes, we need some more time because the mother of the petitioner arriving in the second week of September,
From where?
Canada.
Ah.
I request my lord time.
One submission, my lord.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ.
In this case, petitioner is ready to give the property in the name of respondent number 2, but he is not ready to give the date.
ಡೇಟ್ ಯಾವ್ದಕ್ಕೆ?
ಅವರು ನಮಗೆ ಪ್ರಾಪರ್ಟಿ ಮಾಡ್ಕೊಡಕ್ ಸ್ವಾಮಿ.
ಅಲ್ಲ, ಅದು
ನಡೀತಿದೆ.
ಫಸ್ಟ್ ಕೆನಡಾ ಇಂದ ಇಳಿಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಬಂದಿರೋದು ಏನಂದ್ರೆ ಮೇನ್ ಕೇಸು ನಮ್ಮ ಪ್ರಾಪರ್ಟಿನ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇಟ್ಟಿದ್ವು, ಅದನ್ನ ನಮ್ಗೆ ರಿಟರ್ನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಬಟ್ ಯಾವ ಡೇಟು ಅಂತ ಅವ್ರು ಹೇಳಕ್ಕೆ ಮುಂದೆ ಬರ್ತಾ ಇಲ್ಲ. ದಟ್ ಈಸ್
ಯಾವ ಡೇಟ್ಸ್?
ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಗಿವ್ ಮೆಮೋ ಆಲ್ಸೋ ಇನ್
ಈಗ
ರೆಸ್ಪೆಕ್ಟ್.
ಸ್ಟೇ ಇದೆಯಾ? ಇಂಟ್ರಿ ಮಾಡ್ರ್ ಇದೆಯಾ? ವೇಕೆಟ್ ಮಾಡ್ಬಿಟ್ಟು.
Mother is, there is no, he also is submitting that it is settled.
True, but if you are not clear about your settlement, we will hear the matter.
My mother comes to India.
When is that moment going to happen?
Most of us know that it is
When?
Second September.
2nd September, I'll record it. The counsel, learned senior counsel appearing for the petitioner submits that what has stopped the execution of the settlement is the arrival of the mother from Canada, which the learned senior counsel submits that would happen on the 2nd of September 2024. Therefore, list this matter on 5th September 2024.
File has to be sent back to
And also
mediation.
The registry is directed to transmit the file to the mediation for the purpose of settlement.
and also
The
kind,
parties to appear before the mediation on the 4th of September at 3 PM.
one more submission, my lord. In this case, petitioner is ready to give the property back to his father.
ಅಯ್ಯೋ ಅದನ್ನ ಫಸ್ಟೇ ಹೇಳಿದ್ರಲ್ಲ ನೀವು. ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. Interim order stands extended till the next date of hearing. Canada ಇಂದ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ interim order vacate ಮಾಡ್ತೀವಿ. Yes. Yes, promotions.
Previous matters.
Huh?
Previous matters. Serial number 3, please.
ಈಗ ಕರೆದಿದ್ದೆ 3.
Please.
ನೀವೇ ಅದು. ಏನು?
I'm filing on the last occasion, please, lords. The learned additional
Opponent
be
ಯಾರು?
submitted that, my lord. They are not
Raghavendra
the first time
Reddy.
directors. I'm submitting a memo, please, lords.
ನಾರಾಯಣ್ ರೆಡ್ಡಿ.
Please, for our twins.
ಹಾ ಸರ್. Yes.
These were, my lords, last time, my lords. With the query which was, my lords,
Let him see it.
please, my lords. By next year, I'll do.
I'll take it on 22nd, ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. List on 22nd in the fresh matters list, but sacked.
Please, my lords.
You had nothing to do on that day.
Please, my lords.
We'll
First
see.
time
Yes.
directors, we are the,
We'll see.
for this petition.
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅದು.
Please, much.
Next.
Number 4.
Charge frame ಆಗಿದೆಯಾ?
Yes, my lord, on 7,
Address of frame, right? When the
On when?
2023, my lord.
7/12.
Yes,
After the filing of the petition,
charges.
I will entertain the petitions. Yes, sir, ಹೇಳಿ.
The stage when the matter was posted for framing the charges, the petition was filed.
All right.
Subsequently,
Now you tell me on the
right.
merits, sir.
The case is that my lord, the petitioner has purchased the property from one Siddegowda. He was also GP holder, Siddegowda. And this, he purchased and Kata was made in his name in the municipal records. His wife and children have also executed a confirmation deed. Subsequently, my lord, his name was metered in the municipal records.
All
At that
right.
time, there was a manual, my lord, that Kata was issued, and he was paying tax also. Subsequently, my lord, the president of city municipality Chikmagalur files a complaint to the superintendent of police alleging that by using the digital key of crime victim number 2 and 4, the petitioner along with the 2 officials of CMC have got the e-Kata in his name, in the name of petitioner. But she has no competency to file complaint. The commissioner has not filed any complaint. I'm the owner, my name is.
You forget about competency to file complaint. Criminal law can be set into motion by anybody. Yes.
That is the case.
No.
He is the owner and
Yes.
the legal heirs of the murder deceased, Siddegowda have not filed complaint.
This
My
court,
name is
no,
Mediation.
sir, not a case for interference now.
But,
This court on 5/8/2024 had passed the following order. The petition is entertained only on the score that the petition had been filed prior to the framing of the charges. There is no warrant for grant of an interim order at this juncture. 1 HCGP 2 emergent notice.
petitioner may be permitted to make an application of discharge before the trial court.
ಮಾಡ್ತೀರಾ? Charge frame ಆಗೋದು.
I thought that you are not disposing of the
No.
charges are framed.
Charges are framed. Where is the question of discharge now? Yes, we'll see next. Yes, next. Mediation, what happened, madam?
What happened because the
Not happened.
petitioner could not travel from Mangalore to Bangalore due to.
ಯಾಕೆ ಏನಾಗಿದೆ?
blockage of roads due to landslide and
Landslide.
road ಎಲ್ಲ block ಆಗಿತ್ತು. He could not travel that day. Maybe posted on 23rd, my lord.
All right, list the matter on 23rd. Yes.
Mediation will be on 23rd.
Or the parties to appear before the mediation on 23rd, list the matter on 29th. What's next?
Additional statements. Lords, on the last
What's
day,
in my this?
Lords, this is about Harrison Technology, please note, so one of the employees, please notes of the
I had
company.
heard this.
Yes, please notes. On the last date, please notes, your Lordship had directed criminal petition number 28221 of 2023.
It is not tagged, is it?
Is not tagged.
Correct number kodi.
It is 28221 of 2023. GM Police Bureau.
Here correct adu.
Correct.
Ah. ಇಲ್ಲ, ಅದು ಬೇಡ ಬಿಡಿ. Yes. You are ready?
I'll file my objections, my lord, I paid for them.
Learned counsel, the second respondent seeks 2 weeks' time to file statement of objections. Till such time, the order dated 23/7/2024 shall continue. List the matter on 10th of September. Next.
7.
When I read the.
One of 2 minutes. Objections, my lord.
Objections.
498, yeah, husband.
Objections
Paid
ಹಾಕಿ.
only for 15 days. Last time it has come.
Interim order ಬರೀ 15 days ಕೊಟ್ಟಿದ್ನ.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
But stayed only for 15 days ಅಂದ್ರೆ?
Petitioner and respondent stay together for
Oh,
15 days.
Husband and wife stayed together
Stayed
15
together
days.
for
I thought I've granted interim order for 15 days.
Settlement talks are also going on, my lord.
15 days. You want 15 days time?
Please. Lord, settlement talks are going on. That is the reason.
Settlement talks ಆಗ್ತಾ ಇದೆಯಾ?
ಆಗ್ತಾ ಇದೆ, ಅವ್ರ ಹತ್ರ ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ.
ಮಾತಾಡ್ತಾ ಇದ್ದೀರಾ?
That
There
the
is
petitioner
settlement.
is ready to take the second respondent. It appears that she is reluctant to come and join with
You need 15 days time?
you.
First to file objections, I require.
You require 15 days to file objections.
Till then interim order may kindly be passed.
I have said in the event no objections are filed, I am constrained to grant an interim order ಅಂತ ಹೇಳಿ. But anyway, talks of settlement are also on.
That's all.
Heard the learned counsel appearing for the petitioner and the respondent. The petitioner is the husband. The complainant, his wife. The learned counsel for the petitioner submits that the husband and the wife stayed only for 15 days. And the allegations have sprung. The learned counsel appearing for the complainant submits that if 15 days time is granted, objections would be filed. Both of them then submit that if 15 days time is granted, settlement, talks of settlement would fructify into closure of these proceedings. Therefore, finally 15 days time is granted for the parties to arrive at a settlement, comma, if any, or file objections by the second respondent, comma, again, if any. Yes, interim, there shall, in the light of the aforesaid circumstance, there shall be an interim order for the next 15 days.
Okay.
Yes.
Interim order is granted, my lords, then he may not settle the issue.
No, no, we'll see. ಅದಕ್ಕೆ only 15 days.
Only.
ಈ ಕೇಸಲ್ಲಿ ಎಲ್ಲ only 15 days. Yes. All right.
Okay.
Offense punishable under section 143, 341, 504 and 140.
ಏನು ಕೇಳಿಸ್ತಾನೆ ಇಲ್ಲ. Offense 302 ನಾ?
Please, ಇಲ್ಲ.
ಮತ್ತೆ?
143,
ಮತ್ತೆ ಜೋರಾಗಿ ಹೇಳಿದ್ರೆ ನಂಗೆ 302 ತರ ಕೇಳಿಸುತ್ತೆ.
143, 341, 504 and
Special
140.
court matter
Huh?
next week. This special court matter next week. Like this.
Special court matter ಇದು.
This matter.
Then list on 22nd. Right. Yes.
Respondent, who will listen? Wait for a short time, my lord, to file a statement of objection. It is partly admitted by the petitioner itself, my lord, there is an.
All right, your objection fully ಹಾಕ್ಬಿಡಿ. Yes. Learned counsel for the second respondent seeks 2 weeks' time to file statement of objections. Objections, if any, in the next 2 weeks. List the matter on 11th September. Interim order subsisting shall continue to the next date of hearing. Next.
10.
11th September in admission ಅಂತ. Next.
Here for the petitioner.
Ah.
It is purely civil in nature. The agreement of sale is on 7th of June 2010.
Ah.
Now, PCR is filed on 1st of September 2017, after
Hmm.
lapse of 7 years.
Hmm.
And lords, there is a.
Civil suit is not filed?
Consumer complaint is filed 13th of September 2017. And there is a.
You are the owner of the property?
I am the builder of the,
ಏನಿದು?
I am the developer.
Tripartite agreement?
ಅಲ್ಲ, agreement of sale ಆಗಿದೆ.
Is it concerning surface proceedings also?
And
You are
I've
the
already-
builder. Why have you not given the property?
No, I have already transferred. There was an agreement, there was a settlement talks.
And subsequently, I've
It
already.
is not plain and simple agreement that has been breached, but you are the builder.
Also, I've already transferred whatever the amount that is paid by the
Let,
complaint.
let the respondent come. Yes.
Because there is also a stay that is granted by the division bench insofar as the execution proceedings are concerned.
That is independent, we'll see.
And also there record a similar matter,
Huh.
by this honorable court, as against the very same accused, number one.
Oh, you are indulging in all these cases. Kudi,
Now, let's, the,
kudi.
they transferred 45 lakhs,
45 lakhs ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ already.
ಇನ್ನು ಎಷ್ಟು ಕೊಡ್ಬೇಕು? ಬಾಕಿ.
As per the agreement of sale, it says 45 lakhs and I have transferred it.
You have given everything back?
Yes. And he has taken 15 lakhs.
The counsel for the petitioner submits that pursuant to the agreement, there was the complaint comes about on account of non-delivery of the possession of the property pursuant to an agreement. The complainant had invested 45 lakhs is what the learned counsel for the petitioner would submit and would further contend that all the 45 lakhs is returned now to the hands of the complainant.
15 lakhs is returned, 15 lakhs is returned. Remaining
ಯಾವ್ದು
is
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಇದೆ submission ಮಾಡಿದ್ರಲ್ಲ ಯಾವ್ದದು?
where it is.
The counsel for the petitioner submits 15 lakhs is returned and you would return the whole thing?
No, remaining is deposited before this honorable.
And the remaining 30 lakhs is deposited before this court. In that light, there shall be an interim order of stay till the appearance of the complainant. Tag this petition along with Justice Hemant over the order.
Great.
Yes, next.
11.
Under section 217 is the case and counter case, and second respondent has been appeared before the court and pleaded guilty and paid a 2,000 rupees fine.
Yes, I told you,
Please, madam.
records ತರಕಲ್ಲ ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಇದು ಕ್ಲೋಸ್ ಮಾಡದ ಅಂತ. ಅದು has pleaded guilty and it's compounded.
Yes, my lord. It is the copy, certified copy of the.
Good, yes. Yes, sir.
Notice has to go, my lord, to the second.
One HCGP, two emergent notice. List the matter on 19 September till such time further proceedings where the petitioner shall remain stayed. Next.
12.
ಇದನ್ನ ಅದ್ರೊಳಗೆ ready ಮಾಡಿ.
So, seal number.
ಇದು ಅಷ್ಟೇ 22nd, same. Yes.
Can I connect with seal number 8? Similar.
ಬೇಡ ಎರಡು ಒಟ್ಟಿಗೆ ಅವತ್ತೆಲ್ಲ ಬರೋದು ಅವತ್ತು.
For complainant in this case, my lords,
This is
for
the
1
case.
week time to secure instructions and file objections.
ಏನಿದು?
My lord, it has been repeatedly going on this point, my lord. So your lordship asked for the investigation papers. Last time it was brought.
Is ordered to
To file
serve.
wakalat.
Number two, asked for undertaking to file wakalat. They have not
ಅದು
filed.
ಏನ್
wakalat.
ಮ್ಯಾಟ್ರ್?
Not arising out of an agreement agreement to transfer the trademark and the business. This petitioner was earlier working in the respondent two company as CEO. Thereafter, and that company was making supplies to the petitioner company. The petitioner is an individual, but the company is with which it was associated is a foreign company. Now what has happened, this petitioner one's company itself has decided to start the business here. And petitioner number one has joined this new company. It is all done with the knowledge. The agreement itself says, in the transition, when the sale is to happen from the respondent to the petitioner, petitioner number one will be the person who will facilitate both of these things. Money transfers are done. Nobody is disagreeing to following the agreement. But the allegations are made.
Page 23.
Please. I'm aware, my lords. That
ಹಾಗಾದ್ರೆ objections.
ಅಲ್ಲಲ್ಲ forgery ಅಂತ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, that is the agreement itself.
Forgery ಅಲ್ಲ. Last time you told us.
Embezzlement and siphoning.
ಅಲ್ಲಲ್ಲ, forgery is not the only, I am not concerned about forgery. ನಾವು ಕಂಪನಿ ನಂಬಿಕೆ ದ್ರೋಹವಾಗಿ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಯೋಜನೆ ರೂಪಿಸಿಕೊಂಡು ಸುಳ್ಳು ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ಸುಳ್ಳು ಮಾಹಿತಿಯನ್ನು ನೀಡಿ
Please.
ಸುಳ್ಳು ದಾಖಲೆ ಯಾವುದು?
My lord, Sullu Dakle is the agreement itself, they're saying is Sullu because they're cancelling it.
Yes, sir.
That's
And
my
they say
client.
the complaint itself is based on the agreement. They're not, there is no forgery. Sign forge ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿಲ್ಲ.
But
ಯಾವುದೇ clause.
Then we'll post it on Monday.
My lords, let there be some protection, my lords.
ಏನಾಗಿದೆ ಈಗ? ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
My lords, in this, what has happened is,
ಬೇಲ್ ತಗೊಂಡಿಲ್ಲ.
ಎರಡೇ abuse ಹೇಳ್ಬಿಟ್ಟು.
ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
ಈ ಕೇಸಲ್ಲಿ ತಗೊಂಡಿದ್ದೀವಿ.
ಮತ್ತೆ ಇನ್ಯಾವ?
ಎರಡೇ abuse, only two things I'll mention. After that, I'll rest my case. The registration of the FIR is done by Malleshwaram Police. Malleshwaram Police, after it is taken custody and kept me for about 5 days, comes to the court. When the court takes the IO to task, saying how you did not have even jurisdiction, how did you take it up? initially comes saying we want extension of police custody. Then it is recorded, I put that in the record. Court notices.
ಬೇಲ್
that this-
ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ವಾ?
ಅಲ್ಲ,
ಹಾ.
bail ತಗೊಂಡಿದ್ದೀನಿ, but abuse ಯಾವ ಮಟ್ಟಿಗಿದೆ ಅಂತ they're using it. Second
ಆಯ್ತು,
round, second round.
ನಾಳೆ ಹಾಕ್ಲಾ?
ಅಲ್ಲ, ಒಂದೇ ಅಲ್ಲ, ಇದು last time 2 times it came. I was not able to place the facts.
ಅಲ್ಲ, ತುಂಬಾ ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ನಾಳೆ ಹಾಕ್ತೀನಿ.
Very well, very well. Not 20, well, finally, my lord, they cannot
20,
ask
yeah.
time.
List on
Client is out of station. I have to file wakalat. Within 1 week, I'll file and I'll file my objections. That's what.
ಮತ್ತೆ ವಕಾಲತ್ ಹಾಕಿದ್ಮೇಲೆ ಕ್ಲೈಂಟ್ has come from United States ಅದೆಲ್ಲ
ಇಲ್ಲ,
ಹೇಳಂಗಿಲ್ಲ.
ಇಲ್ಲ.
Yes. List on 21st in the fresh matters list.
14.
23rd. Yes. ಬರಲ್ಲ. ಕಸ್ಟಡಿಲಿ ಇದಾರಾ? Split, I know. What's the problem?
Fresh matter list.
All right, fresh. Yes, 23rd in the fresh matters list. Yes. Next.
15. Can we post this matter for next week, Madam?
16.
Next week, 15.
15. Raja Yoga. No yoga at all. No interim order. Huh?
Next week, Madam.
Learned counsel for the petitioner seeks a week's time. List the matter after 29th. 27th in the fresh matters list. Yes, next.
15.
The NDPS Act, my lords, and NCB is the.
This ASG wants to address the arguments.
All right. List on 22nd,
Please.
in the fresh matters list. NDPS will hear him and then pass. Yes.
Not for quashing.
All right, yes.
17.
Amar also knows. ಯಾವ್ದು press ಮಾಡ್ಬೇಕು ಯಾವ್ದು ಮಾಡ್-
This matter, my lords, absolute 58 is what would be considered.
All right. Let him also. Yes.
With my lord's permission, my lords, the petitioner is a financial intermediary.
Which one?
My lords, 17.
Why did you seek permission?
No, my lords, because there was
I thought
somebody
you were
else
asking
also-
something out of turn.
No, no,
It's
no,
your
my
turn.
lords, there was somebody else also who was saying that the
All right,
17.
tell me.
My lords, financial intermediary, 18 lakh rupees have been asked to pay without even issuing.
Where is
notice.
my Rahul Chari judgment?
It's annexed here.
Where?
We are placing reliance on that. In fact, my lords, that's
That
annexed.
is phone pay.
Phone pay.
PhonePe.
Phone pay. We are pay nearby. We are a business correspondent. We
What
run
are you? Pay?
pay nearby.
Pay
Not-
nearby.
Please, my lords.
Then you,
Literally
have you
get
paid
a-
something very far now?
My lords, we
Then-
will have to pay. If my lords don't stay, in fact, my lords, the difficulty is, we were not made parties. So we did not have the
No, amount
judgment.
is transferred?
No, my lords.
Not
What
yet.
I'm told, last hearing was on 31st August.
One HCGP, 2 and 3 emergent notice returnable by 11th. The concerned court shall not direct transfer of the amount lying in the account of the petitioner to the complainant till the next date of hearing.
My lords, we filed a memo along with it. We finally gotten the entire court order sheet. The order says transfer. In fact, my lords may have just annexure B.
But what to do? If it is already transferred, then
It's
we.
not, it's not.
Ah,
But annexure B, police has written a letter to the bank saying that you also freeze the account after transferring. So apart from transfer of 18 lakhs, I cannot
No,
even use the. other-
transfer, 1 minute. Transfer and there shall be an interim order of stay of further direction of, where, have you challenged that?
Please, my lords, that's annexure B.
Defreezing.
Please, my lords. Freezing.
Freezing, I think.
Freezing.
What have you sought? Freezing order stay.
Please, my lords. If my lords, it's not a very clean copy, 23, last line. From account remaining balance to be held
All right.
on hold until further
Madam,
orders.
madam. The petitioner is Nearby Technologies Private Limited. The allegation of the complainant is that amount of how much?
19 lakh rupees.
Amount of 19 lakhs is transferred through the petitioner, comma, an intermediary. The amount is now sought to be transferred to the complainant without hearing the petitioner. The learned counsel would submit that apart from the direction of transfer, the investigating officer has also directed freezement of the account of the petitioner the moment the transfer happens. Therefore, all these actions shall remain stayed till the next date of hearing. List the matter on 4th September. That's a nearby date, don't worry.
No, no, my lord, I was just checking if I could travel because I have to
come for this matter, that's why.
Oh, you don't stay nearby?
No, my lords, quite far.
Yes.
Obliged, my lord.
All right.
Pay for the petition.
Hmm.
This dispute is between complainant and accused number one for breach of contract.
Hmm.
Lords, accused number one has multiple contracts with different parties, my lords.
Hmm.
If I may just.
You serve on the complainant. What's the impending urgency?
My lords, what has happened is, the petitioners herein have obtained bail. Post which they have reported to the police station. They have the investigation officer had made the petitioners wait for 2 days, despite which, the order has not been complied.
Okay, you are waiting in the police station, is it?
Please, my lords, for 2 days. I have the
For 2
photocopies.
weeks?
2 days.
2 days.
Now the representatives, they live in Mumbai, my lords. And there is no privity of contract between the complainant and the accused number three.
1 HCGP 2 emergent notice returnable by the 11th of September 2024. Till such time, the respondent investigating officer in the garb of investigation shall not precipitate or harass these petitioners. Yes, next.
19.
Petition. Well, in the trial court, the council has already given an NOC.
So,
No,
list after 2 weeks, interim order granted earlier stands extended to the next date of hearing.
But a private complaint not has been lodged by the pollution control board.
Pollution Control Board.
They have filed not statement of objections, not and an affidavit appears to have been filed by the petitioner stating not that the unit has been closed. Not it's no longer being run not in survey number 11.
As far as survey number 11 is concerned, whatever the offense he has committed, complaint can be filed. Now they are seeking their survey number is 57, for which they have sought for CFE. Yes, we have granted CFE for 57.
What is CF?
Commencement for establishment.
Oh.
CFO ತಗೊಂಡಿಲ್ಲ.
What is CFO?
Operation.
Oh. Yes. You want to establishment or operation?
Not insofar the complaint not is so.
Idu CFC closure.
My lord, para number 22 of the petition, he says that there is no relation, ನನಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Para number 22.
ಈಗ ಅವ್ರು ಕ್ಲೋಸ್ ಮಾಡಿದ್ಮೇಲೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Petition, but whatever the offense he has committed, as far as survey number 11, we have filed a complaint.
We will decide about it.
Yes.
Yes. List on 29th in the fresh matters list. Till such time further proceedings where the petitioner shall remain state. We'll decide ಅವತ್ತು.
ಇಲ್ಲ ಇದು ಫೈಲ್ ಬೇಕಂದ್ರೆ ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಇದು ಮಾಡ್ತೀನಿ.
ಅವತ್ತು ಕೊಡಿ.
ಅವತ್ತು.
Yes.
ಆಫೀಸ್ ಬಿಲ್ ತರಿಸಿದ್ದೀನಿ.
ಓ ಇದು ಕಷ್ಟಪಟ್ಟು ತರಿಸಿದ್ದೀರಾ?
ಅಲ್ಲ ಬೇರೆ ಊರಿಂದ.
ಬೇರೆ ಊರಿಂದ.
ಬೇರೆ.
Not a nearby place. All right. Yes.
ತರಿಸಿದ್ದೀನಿ. Because I have to assist the court. Because their main allegation is
29th. Assistance on 29th.
Yes.
For petitioner, my lord. 138 NAC, my lord. Application 311 filed to recall PW.
311, sir. 511 ಅಲ್ಲ.
311, sorry.
Yes, sir.
Lord.
Respondent in this case.
ಅಲೋ ಮಾಡದಾ?
Yes, there are admitted in the signature exhibit P1, my lord.
ಆಯ್ತು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ. Yes.
Today, actually, today was listed.
2 weeks
for
to file
arguments.
statement of
Only 3
objections.
grounds they filed the 311 application, my lord. 2 application was allowed. This is the rejected only ground. that-
Next date ಯಾವತ್ತು?
Today it was there, my lord,
Ivatti.
till urgent, not urgent. They have already argued, my lord. It's for final argument.
Argument
Till you file your objections, don't precipitate there.
Please.
Yes. Learned counsel for the respondent complainant undertakes not to precipitate the matter before the concerned court till he files a statement of objections. In the light of the said submission, list the matter on 29th.
Long date.
29th. Yes. Long date ಬೇಕಾ?
ಅಲ್ಲ ಅಲ್ಲ ಹತ್ರ ಡೇಟ್ ಯಾಕಂದ್ರೆ
ಹತ್ರ
ಅಲ್ಲಿ
ಬೇಕು.
ಡೇಟ್ ಹೋಗ್ತಾನೆ ಇದೆ ಸುಮ್ಮನೆ ನಾನು ಮಾಡಿದ್ದೀನಿ ಇವ್ರು ಮಾಡ್ತಾ ಇಲ್ಲ. There is
23rd.
no grounds to.
No, because I filed a petition.
23rd, sir.
Please.
ನಿಮಗೆ ಲಾಂಗ್ ಡೇಟ್ ಬೇಕಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಸರಿ 23rd.
22. The petitioner in this matter, your lordship senior is on his legs in another court. Kindly be listed next week. Any day.
List after 2 weeks, interim order subsisting shall continue to the next date of hearing. Yes, next.
23.
9B.
9B, my lord, in
Ah.
fact, it is purely called by your lord's judgment, my lord, because kindly see, my lord, even there, 9B ಒಟ್ಟಿಗೆ 3, section 3 of the Explosive Substance Act is also involved. Last me kindly see the judgment, I gave that judgment in the morning. Here only 9B in one case.
9B stay ಮಾಡುವ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಒಂದು ನಿಮಿಷ.
ಅದ್ ನೋಡಿದ್ದೀರಾ ತೇಜೇಶ್?
Kindly look at the judgment.
ತೇಜೇಶ್.
But not only that 155, but also about 122.
ಜಡ್ಮೆಂಟ್ ಕವರ್ಡ್
Third,
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ, ನಾಳೆ ಹಾಕ್ತೀನಿ.
please man. ನಾಳೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತೀನಿ.
ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲ. ಮಂಡೇ ಲಿಸ್ಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ 20th ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ.
Let me connected each other.
ಕನೆಕ್ಟ್ ನಂಬರ್ ಹೇಳಿ ಸರ್.
Connect ಮಾಡಿದ್ದಾರೆ last week.
141 tag the petition sounds 21st next.
Please.
21st yes. Special court. Hey, ಆಯ್ತಲ್ಲ 24 sorry 25 yes.
Please. The last hearing date, it was directed for additional SPP to secure instructions, my lords, that the certified copies was not able to, they are not issuing any certified copies, my lords.
Just on 22nd, the order dated 8/8/2024 shall continue to the next date. Okay, next.
26.
ಇದೇನು ಚಿಲುಮೆ ಅದೇ ಕ್ರೈಮ್. Time over.
Some date.
Today first list was long.
Correct.
Twenty-third,
23rd, but 23rd, one day I'm not.
22nd, 22nd.
May I request it at 4 or 4.
22nd, 3:30 PM. Yeah, come at 3:30. Next.
That's,
Settled, huh?
no, I'm saying
Yes.
that there, he will agree to it. Settlement talks are at an advanced stage. Parties are meeting tomorrow.
Yes, my lords, may have it on Tuesday or Wednesday.
Wednesday, 22nd,
22nd.
21st August.
21st, huh?
Ah.
Wednesday, 21st, yes, right. List on 21st, yes.
Great.
My lord, in this matter,
We'll have
steps
this
are,
also on 23rd.
my lord, may kindly have it in,
Model subsisting.
my lord,
yes.
may kindly have it in the month of September. Last week,
Huh?
there is, my lord, may kindly have it in the month of September, any date, my lord.
Madam, that is an interim order operating September last week, not possible. They will have objections.
My lord, there is some personal difficulty in the last week of August, my lord.
No, like,
Any,
When do you want? First week of September?
1 crore 90 lakhs.
No, madam, this interim order cannot continue like this.
my lord, any date in September first week, no issues.
Yes, so list the matter on September 4th. In the fresh matters list. Next, interim order subsisting shall continue till the next date of hearing.
Some
Obey.
condition may be put.
Our
1
thought.
crore 90 lakhs is there.
That day I will decide it on its merit. Yes,
Obey.
yes, next.
29, I appear for the petitioner.
I'm up
Appointment of special people.
Huh?
Appointment of special people.
I'm up here for the respondent number 3, my lords. I praise for a short accommodation.
Rest time, grants time. Yes,
Interim order may be extended.
extends interim order. Yes, yavat ಬೇಕು madam?
Next week, my lords.
Next week, yes.
Request on 27th. my lords.
ಆಗಲ್ಲ. 4th September.
Interim order.
ಆಯ್ತಲ್ಲ ಅದನ್ನು. Yes, next.
30.
Lordship, in this matter, I am appearing for R2 and R3, my lordship.
Appearing for the
This-
petitioner, my lord, kindly pray for short accommodation, my lord.
This is a matter where, my lordship, interim, the protection of, from arrest has been stayed by this honorable court. Lordship, the main application itself was heard, my lordship, and it is posted for orders today.
Oh, this, what happened?
My lord, senior counsel appearing in this matter.
All right, what happened before the court?
I'm not.
Lordship, it is
counsel,
heard and matter is heard, my lordship.
Proxy counsel.
It is
Kindly
listed
post the
for,
matter for- Short accommodation may be granted, my lord.
Huh?
it is heard, my lordship.
List on 23rd, 22nd. In the fresh matters list, yes.
It has become infructuous, my lordship.
Interim order may
ಅದಕ್ಕೆ
be-
ಹಾಕಿದ್ದು infructuous ಆಗ್ಲಿ ಅಂತ. Yes,
Please.
22nd.
Interim order may be extended.
Interim order subsisting shall continue till the next date.
Offenses under section 66 and 72A of the Information Technology.
Yes, sir.
Though the petitioner is granted anticipatory bail,
Very good. Yes.
PT would not be accepted by the police.
Now that you are out on bail, we'll consider this later.
Yes, ma'am. But surety is not accepted within the condition period.
That is a separate cause of action. One HCGP 2 emergent notice returnable by 11th September. List on 11th September in the fresh matters list, yes. Memo for withdrawal, huh? Sorry,
30 more matters, fresh matter, bill number 1.
ಎಷ್ಟಿದೆ?
10.
ಕೊಡಿ, ಕೊಡಿ.
311 application.
ಒಂದ್ ನಿಮಿಷ ಸರ್.
311 application.
Next date ಯಾವತ್ತು ಸರ್?
Next date, today is the date, my lord.
Next
Now
date.
we adjourn to, my lord, next week, my lord.
List the petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement till the next date of hearing further proceedings before the concerned court shall remain stayed. List on 3rd September in the fresh matters list. Yes, next.
Number 2, Ashok, Nidini.
For the petitioners, my lord.
How are you here?
And two are the advocates.
Huh?
Petition number 1 and 2 are advocates, my lord.
So?
Number, no, my lord, I'm just giving a facts of the case. I'm just giving a facts of the case, my lord. Sorry.
Yes.
Yes. Sorry.
Facts of the case.
One suit, declaration suit is filed by the complainant. It is pending from 2015 and there are several suits. In 2016, this incident occurred. Then we have filed a discharge application before the trial.
When was it rejected?
March.
ಮತ್ತೆ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಇನ್ನು ಇಲ್ಲ.
Petition file ಮಾಡಿದ್ಯಾ ಅವಾಗ? 2nd August.
Yes.
Heard the learned senior counsel, Sri Vivek Reddy appearing for the petitioner. There shall be an interim order of stay of further proceedings in CC so and so, only if the charges are not framed as on today.
Please.
In the event charges are framed, the interim order would cease to operate.
Please. Obliged.
Yes, next.
And delivery.
Hand delivery.
ಏನ್ ಬೇಡ. Upload ಆಗುತ್ತೆ. Upload.
ಏನ್ next date ಯಾವತ್ತಲ್ಲಿ? ಮತ್ತೆ hand delivery ಯಾಕೆ? Yes.
ಆಯ್ತು.
Number 3, Saravanan.
ಇನ್ನ postal delivery ಕೇಳ್ತಾರ ಅವ್ರು. Yes. ಹಾ? ಹೇಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಈಗ ಗೊತ್ತಿಲ್ಲ ಬಿಕಾಸ್ ಐ ಸೈನ್ ಅಂಡ್ ಗೋ ಇಟ್ಸ್ ನಾಟ್ ಪಾಸಿಬಲ್ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ ಎಸ್
Notes appear for petitioners. Notes in WP 17208.
ನೀವು ಮಾಡಿದ್ಯಾಕೆ?
Notes 10 FIRs are registered.
Not
One of
10
the
FIRs ಕೊಡಿ.
in one of the FIR, this court has already granted
ಇನ್
stay.
9 FIRs ಏನಾಯ್ತು?
10 FIRs, notes, it is not within our knowledge. Therefore, we have moved the matter.
ಈಗ now you are getting knowledge of each FIR.
Yes, my lord, 353 of 24-2.
ಅದನ್ನು ಸೀರಿಯಸ್ ಆಗಿ ರಿಪ್ಲೈ ಕೊಡ್ತಾರೆ. ಟ್ಯಾಗ್ ಸೇಮ್ ಕೋರ್ಟ್ ದಿ ಇಂಟರ್ಮ್ ಆರ್ಡರ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Number 4, Satish.
ಏನ್ ಸಸ್ಪೆನ್ಷನ್?
Yes, my lord, the
Learned counsel B.B. Patil is directed to accept notice for the respondent. In the light, list the matter on 10th along with the identical matters. In the light of the matters being heard by this court, precipitative action against the petitioner shall not be taken. Precipitative action, I mean any kind of, yes, till the next date of hearing. ಅಷ್ಟೇ. ಡೈರೆಕ್ಟ್ ಅದೆಲ್ಲ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಆರ್ಡರ್ ಇಲ್ಲಿ ಕೇಳಬೇಡಿ.
Only one submission. Lord, I have raised one question of law with regard to, my lord. I am from, my lord, Malavalli. Lord, I am working in Mangalore. Lord, the superintendent of police.
What is the significance that you are from Malavalli?
Lord, SP Bangalore may not get jurisdiction to register the FIR, my lord. The 8/5/2002 government order is issued. Lord, the jurisdiction of SP, my lord, Bangalore is defined. But I am not working in Bangalore. I am not from Bangalore. I am working at present, my lord, at Mangalore, Mangalore.
ಎಲ್ಲಿ ನೀವು ಅಲೆಜ್ಡ್ ಇದು ಡಿಸ್ಪ್ರಪೋರ್ಷನೇಟ್ ಅಸೆಟ್ಸ್ ಅಲ್ವಾ?
Proportionate
ಎಲ್ಲಾ ಕಡೆ ಆಗಿದೆ.
ನಂದು ಯಾವ್ದು ಪ್ರಾಪರ್ಟಿನೂ ಇಲ್ಲ ಸ್ವಾಮಿ ಇಲ್ಲಿ. But I can understand, my lord, if the search has taken place in Bangalore.
ಎಲ್ಲಿ ಸರ್ಚ್ ಮಾಡಿದ್ರು?
Search has taken place at Mysore, Mandya and Mangalore.
ಅಲ್ಲಲ್ಲಿ ಪ್ರಾಪರ್ಟೀಸ್ ಮಾಡಿದೀರಾ ಅಷ್ಟೊಂದು?
Yes.
ನೀವು ಎಲ್ಲೆಲ್ಲಿ ಮಾಡಿದೀರಾ ಅಲ್ಲಿ ಸರ್ಚ್ ಆಗಿದೆ. ಸರ್ ಚೆಲ್ಲೆಲ್ಲಾಗಿದೆ ಅಲ್ಲಿ jurisdiction ಇದೆ.
ಹೌದು.
Correct.
Registration is at Bangalore, my lord.
ಬೆಂಗಳೂರಲ್ಲಿ ಯಾವ್ದು ಪ್ರಾಪರ್ಟಿ?
ಯಾವ್ದು ಇಲ್ಲ.
We will direct search to be conducted elsewhere. Yes.
ಇಲ್ಲ, lord, your lordship.
The learned counsel appearing for the petitioner would further contend, ಹಿಂಗ್ ಮಾಡಿ first ತಗೊಳ್ಳಿ. The learned counsel of the petitioner would contend that the crime is registered by the superintendent of police. Crime is registered pursuant to the direction of the superintendent of police at Bangalore, with jurisdiction the counsel for the petitioner submits that he did not have. On the score that that no cause of action has arisen in the jurisdiction of Bangalore, as everything is either Malvalli, Mangaluru, ಆಮೇಲೆ
Or Mysore.
Or
And Mysore.
and Mysore. In that light, there shall be an interim order of stay till the next date of hearing. List on 10th.
Yes. Lord,
ಅದು
your
ಬೇರೆ
lordship,
ಬೇಕಾ?
your lordship may
You
say.
appear to be insatiable. Yes.
Order 6
Hmm.
Lord,
Ganesh ke
Withdrawal and stay ಬೇಕಾ?
ಇಲ್ಲ, hand delivery, my lord, he is
No.
likely to be.
ಆಯ್ತು
ಆಯ್ತು.
ಆಯ್ತು ಅದೊಂದು ಕೊಡಿ ಮೇಡಮ್ ಹ್ಯಾಂಡಲ್. ಎಸ್ ಸರ್.
5 Ganesh ke
Withdrawal. Petitioner, learned counsel of the petitioner, ಏನಕ್ಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅಂತ ಏನು? Counsel of the petitioner moved the matter seeking to withdraw the petition in the light of the submission withdrawn. Same second. ಯಾವ್ದ್ರಲ್ಲಿ ಮೇಡಮ್? 6 ಅಲ್ಲಿ counsel of the petitioner submits charge sheet has been filed during the pendency of the petition and seeks leave of the court to withdraw the petition to raise a challenge to the charge sheet, reserving such liberty the petition is disposed as withdrawn. Next.
7 location ke
I appear for the petition. Lord, this is petition by the folks of victim, Lord.
Victim.
Yes, my lord.
Why, what happened?
Lord, she had caused the public prosecutor to file an application for adducing additional evidence, my lord,
Ah.
electronic records.
That's
That
not
was rejected.
acceded to?
Lord?
What has happened now?
Lord, now the matter is posted for arguments, my lord,
When?
on 27th. That is,
Yes, look into it. List on 21st in the fresh matters list, the learned HCGP to secure instructions with regard to the application filed by the victim not being considered by the prosecution or by the court.
Lord, this is the electronic evidence that need to be produced, my lord.
ಇಟ್ಕೊಂಡ್ರಿ ಅವತ್ತು ಕೊಡ್ತೀನಿ, ಅವತ್ತು ಕೊಡಿ. List on 21st in the fresh matters list. 27th ಅಲ್ವಾ?
How's
ಅವತ್ತು will.
published?
Next.
number 8
Withdraw the-
for
I
withdrawal.
withdraw the petition, but I made some error in the petition, therefore I.
Made some error.
In the petition, I filed fresh petition, but kindly liberty may be reserved, my lord.
Yes,
Kindly direct the office to return the certificate copies of.
all right. Petitioner has files a memo seeking to withdraw the petition on account of certain errors crept in the petition. The registry is directed to return all the originals, if originals appended to the petition. Reserving liberty to file a fresh petition, petition stands disposed.
Applies.
Next.
9 Arun G
Petitioner, 311 application. The matter is posted for judgment on 19th.
ಇಲ್ಲಿವರ್ ಎಷ್ಟು ಸರಿ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿವರೆಗೆ?
Because, no, on 2 occasions,
Yeah,
because
no,
the reason why the present 311 application is filed, because my specific contention is that this complainant has colluded with one company. I have put a specific questions and he had denied earlier. I have called out those admissions at page 11. Subsequently, now I have got a document which would indicate that these person, what my defense would, that says that this complainant is colluding with one other company. They are misusing my check. This is my, I just called out.
The application filed by the petitioner under section 311 comes to be rejected solely on the score that the complainant is 72 years old. This cannot be the ground on which an application under section 311 can be rejected. Therefore, there shall be an interim order of stay of further proceedings where the petitioner, further proceedings before the concerned court till the next date of hearing. Petitioner is directed to serve set of papers upon the counsel representing the respondent in the trial proceedings. List on 21st.
Yes.
Yes,
10 Arun Govind
21st in the fresh matters list.
No, the petitioner is a tenant under the second respondent's son.
Second respondent's son.
Yes. On 28th of April, there's an attempt to forcibly dispose him from the premises.
You sought.
I filed a complaint about page 63. Thereafter, I filed an injunction not before the civil court, and the civil court.
Tenant is a lady? Sorry,
I'm the tenant.
Land.
The mother of the landlord is a lady, my lord. She filed the complaint under 350.
Seriously?
1 month later.
Mother of the landlord is a lady. Should that be stated even?
It's
Mother of the landlord, sir.
87-year-old,
Yes.
87-year-old lady, my lord, files a complaint of under section 354. Complaint is filed 1 month after my complaint is filed.
That's all right.
Abuse
the-
of process.
Statement.
Look, abuse of the.
Mother of the landlord is a lady.
Yeah, sorry.
Huh? Yes, heard the learned counsel Arun Govindraj appearing for the petitioner. 1 HCGP 2 emergent notice, there shall be an interim order of stay spread for till the next date of hearing, list on 29th in the fresh matters list.
No, they've also filed a criminal petition, my lord. On my complaint also.
ಅದು
has been
stay
rejected.
ಆಗಿದೆಯಾ?
Otherly, they have alleged that their complaint is earlier, which is,
ಆಯ್ತು
what?
ಕೊಡಿ.
I'll furnish the number.
Number ಕೊಡಿ.
Okay.
Tag this
53.
petition along with so and so.
5393 of.
List them both on. Yes, next.
Right.
ಮತ್ತೆ ಓ ಇದು 230ಗೆ.
Rival claim not between the petitioner.
Rival claimant.
Yeah, claimants, not between respondent number 2 and not the petitioner who is a witness.
ಯಾವ್ದು ರೈವಲ್ ಆಪರೇಟರ್ ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ
ಅಲ್ಲ,
ಇದ್ದೀರಾ?
ಅಲ್ಲ. Rival claims not with regard to not certain cash not seized by the instance of the present petitioner.
ಈಗ
Now,
attachment
it
was
is
released,
direct-
ಅದೇನಾ? Move
Yes,
ಮಾಡಿದ್ದು.
yes, yes,
Will direct attachment not to be released.
yes.
ಅಷ್ಟೇ, next date ವರ್ಗೆ ಅಷ್ಟೇ.
Till then not to be released, not.
ಅದೇ
How?
ಅದ್ರ ಮೂವ್ ಮಾಡ್ದಾಗ್ಲೇ ಹೇಳ್ದೆ.
Published.
Heard the learned senior counsel so and so. The 1 HCGP 2 emergent notice list on 29th in the fresh matters list, till such time the property subject matter of attachment, there shall be status quo with regard to the properties which are subject matter of attachment.
Not to be released to respond number 2.
Status quo ಅಂದ್ರೆ ಏನು sir? ಈಗ ರಿಲೀಸ್ ಆಗೋಗ್ಬಿಟ್ಟಿದ್ರೆ? Yes.
No, it is not yet released, madam.
If not already released.
Yes, published.
Next. ಆಯ್ತಾ ಏನಿದೆ ಮೇಡಮ್? What was that?
32.
In terms of memo,
33.
list 2 weeks to do the needful, interim order subsisting shall continue till the next date of hearing.
3.1, my lord. 33.
Interim order ilva?
Either, my lords, wherein in one matter, the respondent has taken the notice. I may be permitted to serve the copy in the council.
ಅವ್ರಿಗೆ ಕೊಡಿ, ಯಾರಿಗೆ ಹೇಳಿ? ಸತೀಶ್ ಚಂದ್ರ.
Yes. In
Learned counsel,
33.1.
first 33 ಅಲ್ಲಿ madam. Learned counsel Sri KV Satish Chandra is directed to accept notice for the respondent.
34.
Much of.
Post immediately after service of notice upon the respondent, interim order subsisting. No interim order, no interim. Yes,
35. Hearing.
yes.
Lord, appearing.
Balasubramanian applicant in that list number 35.
ಇವತ್ತೇನ್ ಟೈಮ್ ಆಗಲ್ಲ.
6184, 6184.
We'll have it, we'll fix a date.
14%.
Admission matters where interim order is there, they will all stand.
Implementing application.
ಆಯ್ತು ಗೊತ್ತು
Lord,
ಸರ್,
then-
ಡೇಟ್ ಕೊಡ್ತೀನಿ. 5 ಗಂಟೆ ಆಗೋಗಿದೆ.
Interim order to continue. Lord.
1 minute, 1 minute.
Applied for consideration of implementing application.
ಆಯ್ತು, 1 ನಿಮಿಷ ಸರ್. ಆಯ್ತು ಕೊಡಿ. ಯಾವ್ದು ಹಾಕ್ತೀವಿ ನಾವು? ಓಕೆ, ಅದೊಂದು ಮಾತ್ರ ಹಾಕಿ. Wherever interim orders are there, they will all be extended and they will be listed in the 3rd week of September. Where interim orders are not there, I will tell you. Yes.
Serial number 75 of list 2.
But first, the wait, court employee, wait, sir.
Yes.
Both the waits. Yes. Madam, 18th, 19th. 18th and 19th, all matters will be listed.
My lord, in the fresh matter, my lord, at least in the fresh,
Huh? Where there is no stay.
my lord, serial number 60, my lord. My lord, kindly have it in the fresh matter list. My
ಎಲ್ಲ
lord.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಗೆ ಬರುತ್ತೆ ಸರ್. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಯಾವ್ದಿಲ್ಲ ಅದೆಲ್ಲ ಫ್ರೆsh ಮ್ಯಾಟರ್ಗೆ ಬರುತ್ತೆ.
It had come for our.
CL number 45, we have filed vacating stay, madam.
Vacating stays, madam, vacating stay ಎಲ್ಲೆಲ್ಲಿದೆ ನೋಡ್ಕೊಂಬಿಡಿ, ಅದೆಲ್ಲ. Yes, vacating stay will come in that caption only. Yes.
69.
216. DNP recalling application ಹಾಕಿ. Recalling application ಹಾಕಿ ಡೇಟ್ ಕೊಡ್ಬೇಕು.
My lords.
ನೀವು ಹಾಕಿ, ಏನಾರ ಆಗ್ಲಿ, 10th time, 7th time, 6th time, you all should change, sir. Interim order ತಗೊಂಡ್ಮೇಲೆ ನೀವು ಈ ಕಡೆ ಬರೋದೇ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಒಂದ್ ನಿಮಿಷ. 41 ಆಯ್ತು, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 18th ಬರುತ್ತೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್, ಅಷ್ಟ್ರಲ್ಲಿ ಟೈಮೇ ಇಲ್ಲ.
Serial number 39.
ವಿಲ್ ಸಿ ಮೇಡಮ್, 18th ತುಂಬಾ ಲೇಟ್ ಆಗ್ಬಿಡುತ್ತೆ. ಒಂದ್ ನಿಮಿಷ 24th ವರ್ಕಿಂಗ್ ಡೇನಾ ಮೇಡಮ್? ಆಗಸ್ಟ್ 31st August working. 31st working day, sure. All on 31st Saturday, working Saturday. Yes. Wherever these matters are not listed, will come on 31st. Our very fresh matters.
Even where interim order is granted.
Interim orders are there, adella 18th September.
59 and 61, employees, your lordship, there is a fact sheet file.
Interim order kotilva madam?
The employees want to go somewhere else, these proceedings are coming in a very short.
Then 1 minute, adon matra, because they have to travel andre, list on 4th September.
One submission, my lord, serial number 44,
Adu
serial number 44, my lord,
23rd. Really madam, Lakshmi Angar madam idralla.
serial number 44, it is covered by judgment, Sami, 498 is the offense.
Yeah, 498 ella covered sir.
One submission. Serial number 45, the petitioner is making some payment, may be ordered.
ಒಂದ್ ನಿಮಿಷ, ಹಾಗಾದ್ರೆ ಪೇಜ್ ವೈಸ್ ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್, ಪೇಜ್ ವೈಸ್ ಕರೆದ್ಬಿಡಿ, ಇಂಟರ್ಲೋಕೇಟರ್ ಕರಿಬಿಡಿ, ಅಲ್ಲಿ ಅದಾದ್ಮೇಲೆ
7, 39, 41, 42.
39. ಸ್ಟೇ ಇಲ್ಲದೆ ಇರೋದು ಮಾತ್ರ ಹೇಳಿ. ಎಂಟ್ರಿ ಮಾಡಿ ಇಲ್ಲದೆ ಇರೋದು ವಿಲ್ ಕಮ್ ಆನ್ 31st.
Client has filed for 376 case against an advocate, but serial number 39.
Why, what happened? ಅದು ರಿಲೇಶನ್ಶಿಪ್ ಇತ್ತಾ?
There's the allegation, in one complaint she says they are married, and in another complaint says he has completed the agreement. And they, matter is not.
ಈಗ ಸ್ಟೇ ಇಲ್ವಾ?
Stay in the fresh matter. 39.
ಸ್ಟೇ ಇಲ್ವಾ? ಆಯ್ತು, 31st. 31st. ಚಾರ್ಜಸ್ ಫ್ರೇಮ್ ಆಗ್ತಾ ಇದೆ. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
What happened is.
31st.
Serial number 40.
ಪೇಜ್ ವೈಸ್ ಕರಿತಾ ಇದೀನಲ್ಲ, ಯಾರದು 40 ಅಂದಿದ್ದೀಗ? ಎಸ್. 40ನೇ, ಯು ಆರ್ ಆನ್ ದ ಪೇಜ್, ಸಾರಿ.
Interim order is there, my lord. Interim order is there.
Yes sir, 18th. Yes.
18 is Sunday, my lord.
August 18th ಅಲ್ಲ ಸರ್. We have crossed August. Yes. Fresh matters ಬರುತ್ತೆ. In the fresh matters, Saturday ಅವತ್ತು ಹಾಕಿರೋದೆಲ್ಲ fresh matters. You want to take advantage, you can.
Page 8, 46, 47.
45, one submission.
44, my lord.
45,
ಅದೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿರೋದು ಯಾವ್ದು ಮೂವ್ ಕೇಳ್ಬೇಡಿ.
45 ಇಲ್ಲಿ settlement ಆಗಿದೆ.
ಪೇಮೆಂಟ್ ಏನು?
ಮಾಡ್ತಾ ಇದ್ದಾರೆ. 40
Just to record it.
ಎಷ್ಟದು?
About 6 like 10% of the amount which is payable by.
ಎಸ್ ಮನೋಹರ್.
6 lakhs. 6 lakhs.
40 ಏನದು ಸೀರಿಯಲ್ ನಂಬರ್?
45.
Learned Counsel MRC Mano, Learned Counsel, I forget the name. Your name is it? The counsel Siddharth Suman representing the petitioner hands over a demand draft to the respondent counsel MRC Manohar of an amount of rupees 6 lakhs. The same is acknowledged, the receipt of which is acknowledged.
Balance payment next week. Next week. Balance.
List the matter on 18th September.
Date may be fixed.
18th September.
8.
Next payment ಮಾಡಕ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲಿ ಕೊಡ್ತೀರಾ?
ಮಾಡ್ತೀನಿ.
ತುಂಬಾ ದೂರ ಆಯ್ತು.
LOC matter there, my lord. LOC matter.
All right, yes. Interim order subsisting shall continue till the next date of hearing.
My lord, 49th matter, 49th matter. I am for the respondent number 2,
40?
my lord. 9.
Yes.
I am for the respondent number 2. A1 and.
Madam, interim order ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ.
Illa, Swami.
All these matters will come on 31st. ಅದಕ್ಕೆ ಮುಂಚೆ ಆಗಲ್ಲ, don't make a mention. Yes, next.
Page 9, 54, 55, 56, 58.
My lord, 52.
31st.
My lord,
Yes.
52.
ಅವತ್ತು very fresh. Yes.
My lord, 52, my lord.
31st. ಹಸ್ಬೆಂಡ್ ಎಲ್ಲಿ ಕೊಡ್ತೀವಿ ನಾವು? ಅದು 31st ಬಂದ್ರು ಅಷ್ಟೇನೆ, next 30th ಬಂದ್ರು ಅಷ್ಟೇನೆ. Yes, 31st, yes.
Lordship, 52, your lordship.
Page
1 minute. ಎಲ್ಲಿದೆ? asked for you. 52,
52.
interim order illa.
The interim order, your lordship, the writ petition court they have granted on the same issue.
Then
If
take
you-
advantage of that.
We want to
31st.
take advantage from your
31st
lordship.
hakla. 31st,
Please,
31st in the fresh matters list.
shorter date she wants.
ಯಾವ್ದು ಇಲ್ಲ, next week ಯಾವ್ದು ಇಲ್ಲ.
Tuesday, your lordship.
60.
Again, 300 matters are there. I don't know if, because this is an old, it's a notice agiro matter, adrinda it will come in admission. 31st are the fresh matters. Till, ಹೆಂಗು stay ಕೊಟ್ಟಿದಾರಲ್ಲ ಅಲ್ಲಿ.
So we want to show the writ copy of the order and then probably convince your lordship.
Not necessary, even otherwise I'll get convinced. Yes.
Please.
My lord, 60 is low.
Next.
60 interim order.
65, 67.
60,
Interim, no interim order, my lord.
31st. ಅದ್ಯಾವ್ದು urgency ಅಂದ್ರಲ್ಲ madam ಯಾವ್ದು?
Your lordship, there was 61, your lordship.
ಏನಾಗಿದೆ?
Your lordship, I am for the
61 and?
directors of the same company.
Only 61.
59 and 61.
60 is mine. No?
59 and 61.
59 and 61.
Respondents are served also.
Respondents are served.
Then we'll,
If 59 my lord, I appear
ಇದೊಂದು
for
ಸ್ವಲ್ಪ
the
early ಹಾಕಿ because they want to travel or something, yes. We'll post it on 4th September,
Great.
yes.
My lords, may I request after 8th September any date, my lord? In 59, I filed wakalatnama yesterday for the respondent.
69 I have not yet reached, sir. 61 is.
59, my lord, 59.
59. You are appearing?
For the complainant, my lord.
Oh, Learned Counsel Arjun Rao submits that, you filed wakalat?
Nene hakidini.
Learned Counsel submits his entered appearance for the second respondent complainant registry to print the name of so and so. When do you want?
Lord, any date after 7th September, my lord, if
All
convenient.
right, 8th September.
I'm so grateful.
Yes, sir. Oh, serious, fresh matters list. Sorry, it's a Sunday, 10th September, yes.
Please, I'm grateful.
No interim order, bad abide, nimge ಯಾಕೆ, yes. 31st, yes. 31st, sir, yes. Not to precipitate ಅಷ್ಟೇ ಇರೋದು ಇದರಲ್ಲಿ. ಎಲ್ಲಿ ಇವರು ಜಗದೀಶ್, when is Jagdish coming? List, ಇದು list on 21st in the fresh matters list ಹಾಕಿ. 66. Yes. Vipin sir,
Serial number 73, my lord.
ಒಂದ್ ನಿಮಿಷ ಕರೆದು ಬಿಡ್ತೀನಿ ಸರ್.
Serial number 68, my lord.
67, 68 ಎಲ್ಲ ನಿಮ್ದೆ.
68, would it be listed in the hearing, IA, my lords?
ಯಾರು ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದಾರೆ?
Applications pending ಇದೆ.
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Other side ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಅವ್ರು ಹಾಕಿರೋದು ನೀವೇ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
B group reach.
List on 18th, interim order subsisting shall continue till the next date of hearing.
The list of hearing, orders are in.
Don't worry, sir. Yes. ಜಲ್ದಿ ಮೇಲ್ ಬರ್ಲಿ ಅಂತ ಅವ್ರ ಸಬ್ಮಿಷನ್ ನೀವು ಮಾಡ್ಬೇಡಿ. Yes, next.
Serial
71, my lord. Serial number
73, my lord, before.
70?
73. My lord, serial numbers,
ಇದಲ್ವಾ 70 and 72?
my lord.
ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ? ಸರ್. 18th.
71,
Serial
my
number
lord.
73, my lord.
My lord.
73.
18th, sir. Interim order ಇದೆಯಲ್ಲ? We can't mix the two, sir. No interim order and interim order. No.
Lord, 71.
ಎಲ್ಲ with retrospective effect.
My lord, serial number
71, my
73.
70?
73, my lord, matter relating to disproportionate assets. Last week ಬಂದಿತ್ತು. My
10th
lord, I
of-
had pressed for interim order, my lord,
Why?
saying that there is a, my lord, the promotion has been withheld. 2018 FIR as on today, charge sheet was not filed. Your lordship, my lord, fixed a date for today to consider interim order, my lord. 73, serial number 73, my lord.
ಹೌದಾ? Fix a date for interim order and DA
To
case.
consider for interim order.
Why?
My lord, this is a matter where, my lord.
No, I have said charge sheet will not be filed in.
Yes, my
all
lord,
the
therefore I made a submission saying that, my lord, my promotion has been withheld. FIR has been filed in 2018.
Covered matter.
FIR has been filed in 2018. As on today, charge sheet is not filed. My lord, and there is only 2 lines ordered by the superintendent of police, my lord. There is no.
No, that runs through all the petitions.
There is no
But,
order at all. There is only 2 lines.
DPC ಯಾವಾಗ?
Date. My lord, therefore, my lord, Thursday ಆಗಿತ್ತು, your lordship posted.
DPC ಯಾವಾಗ?
My lord, date is not at which.
ಅದಕ್ಕೆ ಅದೇ DPC ಗೆ ಮುಂಚೆ ಸ್ಟೇ ಮಾಡೋಣ. ನೀವು ಕೇಳ್ಕೊಂಬ 21ಕ್ಕೆ ಹಾಕ್ತೀನಿ. 21st.
23.
Serial number 71, my lord.
In fresh matter list, my lord.
ಅದರಲ್ಲೇನ್ ಮತ್ತೆ 6 ವರ್ಷದಿಂದ ಯಾಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ?
No.
ಓ, ವೆನ್ ವಾಸ್ ಇಟ್ ರೆಡಿ? 6 ವರ್ಷದ ಕೆಳಗೆ. 21st, then don't file till the orders are passed by the court.
It's a fresh matters, man.
Fresh matter.
Serial number 71, man.
71,
Defreezing of accounts, my lord. Already coordinate bench has defreezed other acquisitive accounts. It is a covered judgment. There is no interim order.
all right. ಹಂಗಾರೆ ಇದು ಬರ್ಲಿ, 18ಕ್ಕೆ ಬರ್ಲಿ. Yes,
There is no, because 73 lakhs are lying in my account.
ಇರ್ಲಿ. You are the complainant.
No, I am for the accused.
ಆಯ್ತು, we'll see. Yes.
There is no interim order.
No, interim order ಇದೆ sir.
No, it is. I not sought any. interim order.
75 interim order ಇಲ್ವಾ?
I not sought any interim order.
70 not sought. ಅದೇ that's what. ಅದ್ರಲ್ಲಿ ಏನಿದೆ? Yes, next.
Serial number 38.
31st ಬರ್ಲಿ ಹಾಗಾದ್ರೆ. Yes.
Serial number 38, my lord. Second list, my lord.
Wait, sir. Why are you putting the clock back? Yes.
76 here.
75 ಆಯ್ತಲ್ಲ? 76. 75 list on 23rd. ಅದನ್ನ ಅವತ್ತು ಮುಗಿಸ್ಲೇಬೇಕು ನೋಡೋಣ. ಇಲ್ಲ, ಒಂದು ಕೆಲಸ ಮಾಡಿ ಮೇಡಮ್. Reserved, yes. It was already reserved once.
It was, yes.
So we'll re-reserve it.
Orders.
Re-reserve it. Yes, reserved, yes.
76, your lordship, this is that.
For the highlight of you.
In the appellate court. Yes.
Further hearing.
ಆಯ್ತು, further hearing on 23rd, yes.
At 4 PM.
ಎಲ್ಲ ಬೇಕಾ? ಆಯ್ತು,
But
yes.
what is, my lord, really amazing, my lord, is after a long day's work at 4:45, your lordships are still in this mood. My lord, we really acknowledge.
Yes, yes, sir. It's just to break the monotony, I
I
just
know,
keep
but
the
to do
humor on in the court, that's all.
But to do it at 5 o'clock in the evening after a long day's work,
Yes,
my lord,
yes.
is
Today is really a long day.
Long
About
day, I can see that.
close to 300 cases.
I know, I can see that.
Yes. 76
Happy for the petitioner.
from Russia.
Please.
Yes.
Russia and Dubai. We are all over the world, my lord.
No, no.
Whenever your lordships.
Yes, ಯಾವತ್ತು ಹಾಕೋಣ?
ಯಾವ ತರ?
31st.
Interim order ಇದೆಯಲ್ಲ
ಇದೆ.
It's in their favor.
We'll finish it. But ಏನಾಯ್ತು? What happened?
They have filed a rejoinder.
ಎಲ್ಲ ಆಗಿದೆ. All pleadings complete, is it?
You're not gonna- you are not filing anything because you said you wanted to file a
Yes.
rejoinder. So if it is not there, then I am.
No, response is there. We'll give it to them.
Then give it to us.
Response at the appropriate time.
I didn't give it earlier because then I don't know under which act next one.
No,
takes the
don't
next
say,
one.
I mean, don't make any such state.
That is
I
what.
mean, we also know what you have done.
ಬೇರೆ other-
Don't.
This is where that exactly what he said about your lordship. He lacks the sense of humor already. Your lordship,
right.
any date, 31st.
ಯಾವತ್ತು?
31st, your lordship.
31st ಬೇಡ, ಮುಂಚೆನೆ 23rd.
ಸ್ವಲ್ಪ ಏನೋ my
23rd,
23rd.
next Friday.
Please, please.
23rd.
Please.
23rd.
Oh, you have
Both of us
something.
are not there.
27th.
22nd,
27th
ಆಯ್ತು, 27th, 20.
or first week of September, whatever you are.
No, 20.
Whatever.
We'll
Well, I'm ready, man. I'm ready.
because I've heard it at length, we'll finish it off.
Yes, but it
Plus,
requires,
you want time.
it requires,
We
my
are
lord,
ready.
it requires a little more elaboration. I will do it. my lord. Yes, it requires. It requires.
Yes, all right.
27th one.
This is a globe-trotting case, so we will see.
My petition, 35.
one. ಬರ್ತೀನಿ.
ಒಂದೇ ನಿಮಿಷ.
27th.
Yes, 27th, all right, 27th.
Yeah, get it.
27th, we'll keep it at 4 PM.
Please.
Very,
That should be enough, right?
Please, please.
may not be, my lord, but anyway, we'll
It
make
will
the.
be
May not be enough?
more than sufficient.
My definite friend, my lord,
All right, allow you what?
now, I can't compete with him. I am a little slow.
Yes, yes, all right, all right. All right, 27th,
27th.
4 PM.
That interim order has to be extended.
Interim order subsisting shall continue till the next date. of
Great,
hearing.
great.
Fast over. ಬರ್ಕೊಳ್ಳಿ, don't worry. Learned counsel submits office objections have been complied with, office to verify. In the event they stand uncomplied, the order remains. In the event it is complied, the order stands recalled.
My lord, serial number 9 passed over matter.
ಒಂದು ನಿಮಿಷ.
This to serial number 43, vacation of stay analysis is not mentioned like that.
ವೆಕೇಶನ್ ಆಫ್ ಸ್ಟೇ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್, ಒಂದು ಯಾವತ್ತು ಹಾಕ್ಬೇಕಾದ್ರೆ ಹಾಕಿ. ಬೇಡ, ವೆಕೇಶನ್ ಆಫ್ ಸ್ಟೇ 31st ಹಾಕಿ, 31st August.
Order in serial number 75.
That will extend.
38 my lord, case and counter case my lord. My parties is ready to report the settlement. my lord.
ಏನು
Case and counter case.
offense ಏನು
323, 24.
ಈಗಿದಾರ?
Now present is, my parties are present, madam. That's outside.
Both the parties be present. I'll take it on 23rd.
Please, interim order be
Serial number ತಗೊಳ್ಳಿ.
38 madam, second list.
Interim order ಇದೆಯಾ?
Yes,
Interim order ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
please.
Serial number 32 in list number 2, we had already moved a memo of withdrawal on the last date.
32 must be withdrawn.
Yes, my lords.
32 withdrawn, sir.
Withdrawn.
Withdrawn, yes. ಹೇಳಿ ಸರ್. ಅದು ಯಾವತ್ತು ಹಾಕಿ? ಒಂದು ನಿಮಿಷ ಸರ್. ಅದು 31ಕ್ಕೆ ಹಾಕಣ್ವಾ? 31 1 31st. Yes.
Interim order to continue.
That will exchange. Good.
My lord, serial number 9.
ಏನು ಹೇಳಿ ಸರ್? 9.
Serial number 9, passed over matter.
ಆಯ್ತು.
Next Monday.
ಅಷ್ಟೇನಾ? ಎಸ್. ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ.
Serial number 195.
23rd ಅಲ್ಲ? Further hearing.
Madam, serial number 35, 31st ಅಲ್ವಾ?
ಚೆಕ್ ಮಾಡ್ಬಿಡಿ. 23rd ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲ? ಇಂಟ್ರಿ ಮಾಡ್ಬೋದು.
Madam, serial number 35.
Hello.